Hey guys, I think that there is something out of the presence of the jury first. I think they're talking about um, the defense's misstatement of the law. But I don't know what he misstated, because what he said made sense to me anyway. So that's why I wanted to watch jury instructions. I know there's going to be parts where it's boring. Thank you guys for coming, though. I appreciate it. We've got to do something to push my channel out. You guys have got to help me think of something. I know I need to do some more true crime videos because I feel like my channel was growing more when I did. Well, maybe not, because it took me an awful long time to get to 500. And thanks to Biggin for that, because I got like 200 subs like that. Because when he started putting my link in the chat, it was like boom, boom, boom. But I am stuck at 573. I've been stuck for months at 573 subs. But yeah, what he said made perfect sense. If there's no arson, there's no crime. Right? That makes sense. Because what did she do to try to kill him if there's no arson? I don't see it. StreamYard, I really don't want to have to go back to turning my camera off all the time, but I guess I'm going to. I had it at the right spot, and it jumped ahead again. Me. You lost me in the portal. I guess I'm going to have to start turning my camera off again. I have a thing about creators that don't turn their camera on. I feel like they're trying to hide something. And I don't like that. But you guys know I'm not trying to hide anything. I don't like it. Oh, mine have already been lost a long time ago.
Okay, we're on the record in the case of People versus Linda Stermer. Counselor present, Ms. Stermer is present. Jurors are all here for final instructions. Any matters to address before we bring them in?
Yes, Your Honor.
Okay.
The elements of the charges discuss causation. Let's talk about the act. The act, it's undisputed, that caused Todd Stermer's death was the setting of a fire. Ms. Zurabine in rebuttal yesterday said, you don't have to find arson or anything with the fire, consider the totality of the evidence to find first-degree murder. Everything in every single claim and count talks about the actions of Todd Stermer. The act that caused the death is the setting of the fire. So it was just an incorrect statement by Ms. Zurabine in a rebuttal, and I don't want the jury going back thinking we can talk about the man and the motive and everything else, but we don't have to worry about the fire in order to convict. You have to have the act to convict. So I think the jury should be instructed that there was an incorrect statement, not intentional, but an incorrect statement. The action that caused the death is the setting of the fire. That's undisputed through Dr. Markey.
Ms. Zidevine?
Thank you, Your Honor. I think that's a mischaracterization of what I said. I said that I actually quoted him. I don't have my paper in front of me what he said, and I said you can consider all the things. You can. I was referring to strictly. He kept saying if you don't have arson, meaning Mr. Trinkle arson, you have no case. You have no causation. You have nothing. And I kept saying you have to look at all of the evidence. So I think that's a miscategorization. I think it was very clear in my rebuttal. It's certainly, I was informing them that you look at all evidence. And he said, if you don't have an arson, you don't have a crime. That's the word I heard, and that's the statement I wrote down, and that's what I was addressing. You certainly can have a crime. You can certainly have premeditated murder. You can have second-degree murder, all of her actions together. So I think that's a miscategorization of my rebuttal.
Your Honor, Justin, she said you do not have to find arson. You don't have to find the setting of the fire in order to find first-degree murder. Yes, you do. It's the action of the defendant, which is the fire, that caused the death. So it's a causation issue, and she misstated. I don't want the jury thinking they don't have to find the setting of a fire caused the death, and you can still find first-degree murder on all the other stuff she said.
Or you can still find a crime when you have creating a greater likelihood of harm and death through a second-degree murder as well, which they are being instructed on.
Every single
Counsel, I heard enough from
Thank
both of you. The jury's here. I'm ready to provide them the final instructions. I'm not going to amend the final instructions. They're going to learn from me what the law is, and they're going to be instructed to follow the law as I give it to them right now. Thank you. Bring in the jury.
I want to know what the right thing is. Because he died from the fire. If there's no arson, there's no murder. Yeah. He died from the fire. How can you say that she planned to murder him if it wasn't arson? That's ridiculous. She's not charged with second-degree murder.
Welcome back, Terry.
You're right. She's not charged with that.
Okay. Do they have the final? Do they have copies? Okay. I'm going to provide you the final instructions.
Yeah.
We're going to give you
Now
copies of
you're
them
right.
now.
Finally.
Counsel, you both have a copy as well?
Yes, Your Honor.
Your Honor.
Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all of my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutors must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutors have not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair, honest doubt growing out of the evidence or the lack of evidence. It's not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that she did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that she is charged with more than one crime is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses, your questions to the witnesses, and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see and hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecution has introduced evidence of statements that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you must give the statements whatever weight you think they deserve. In deciding this, you should think about how and when the statements were made and about all the other evidence in the case. You may consider the statements in deciding the facts of this case. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that's direct evidence that it's raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it's raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. You've heard evidence that before the trial, witnesses made statements that may be inconsistent with their testimony here in court. You may consider an inconsistent statement made before the trial to help you decide how believable the witness's testimony was when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witness has said in the earlier statements when determining the facts of this case. When the lawyers agree on a statement of facts, these are called a stipulation or stipulated facts. You may regard stipulated facts as true, but you're not required to do so. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutors do not have to prove that the defendant had a reason to commit it, the alleged crime, They only have to show that the defendant actually committed the crime and that she meant to do so. The testimony of Dardita Gordon was read into this trial because she was not available. This testimony was taken under oath at an earlier hearing. You should consider this testimony in the same way you consider any other testimony you've heard in court. The defendant's intent may be proved by what she said, what she did, how she did it, or by any other facts and circumstances in evidence. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You've heard that a lawyer talked to one of the witnesses, and there's nothing wrong with this. A lawyer may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You've heard testimony from expert witnesses. Dr. Michael Markey gave you his opinion as an expert in the field of forensic pathology. Dr. Dave Hayhurst gave you his opinion as an expert in the field of DNA analysis and forensic biology. Ann Hunt gave you her opinion as an expert in the field of serology and DNA analysis. Troy Ernst gave you his opinion as an expert in the field of fire debris analysis and trace evidence. Scott Leroy gave you his opinion as an expert in the field of fire investigation and cause and origin. Robert Trenkel gave you his opinion as an expert in the field of fire investigation, fire suppression, and fire inspection. I'm going to try my best, Zujetsky gave you his opinion as an expert in the field of injury biomechanics. Experts are allowed to get experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts the expert gave for his or her opinion and whether those facts are true. You should also think about the expert's qualifications and whether his or her opinion makes sense when you think about the other evidence in the case. During the testimony of Robert Trenkel, videos were admitted as evidence to illustrate his testimony. The parties agree that the videos are not in any way a recreation of the events at issue in this trial. You may only consider the videos to help you understand and evaluate this witness's testimony as it relates to the speed at which a fire might grow and propagate in the absence of liquid accelerants under certain conditions, and how polyester clothing might burn when doused with 2 ounces of gasoline versus how it might burn in the absence of any gasoline. During the testimony of Robert Trenkel, a pair of gray polyester sweatpants were admitted as evidence. The parties agree that these sweatpants are not the same pair of sweatpants involved in this case. They are an exemplar pair of 100% polyester sweatpants. You've heard testimony from witnesses who are police officers, and that testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. In count 1, defendant is charged with first-degree premeditated murder. To prove this charge, the prosecutors must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Todd Joseph Stermer. It is not enough that the defendant's act made it possible for the death to occur. In order to find that the death of Todd Joseph Stermer was caused by the defendant, you must find beyond a reasonable doubt that the death was the natural or necessary result of the defendant's act. Second, that the defendant intended to kill Todd Joseph Stermer. Third, that this intent to kill was premeditated, that is, thought out beforehand. Fourth, that the killing was deliberate, which means that the defendant considered the pros and cons of the killing and thought about and chose her actions before she did it. There must have been real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. It is for you to decide if enough time passed under the circumstances of this case. The killing cannot be the result of a sudden impulse without thought or reflection. You may also consider the lesser charge of second-degree murder. To prove this charge, the prosecutors must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Todd Stermer. It is not enough that the defendant's act made it possible for the death to occur. In order to find that the death of Todd Joseph Stermer was caused by the defendant, you must find beyond a reasonable doubt that the death was the natural or necessary result of the defendant's act. Second, that the defendant had one of these three states of mind: she intended to kill, or she intended to do great bodily harm to Todd Joseph Stermer, or she knowingly created a very high risk of death or great bodily harm, knowing that the death or such harm would be the likely result of her actions. In count 2, defendant is charged with first-degree felony murder. To prove this charge, the prosecutors must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Todd Joseph Stermer. It is not enough that the defendant's act made it possible for the death to occur. In order to find that the death of Todd Joseph Stermer was caused by the defendant, you must find beyond a reasonable doubt that the death was the natural or necessary result of the defendant's act. Second, that the defendant had one of these three states of mind: she intended to kill, or she intended to do great bodily harm to Todd Joseph Stermer, or she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her actions. Third, that when she did the act that caused the death of Todd Stermer, the defendant was committing the crime of arson. To prove the crime of arson, the prosecutors must prove each of the following elements beyond a reasonable doubt. First, that the defendant burned a building or any of its contents. The term burn in this case means setting fire to or doing anything that results in the starting of a fire, or helping or persuading someone else to set a fire. If any part of the building is burned, that is all that is necessary to count as a burning. The property does not have to be completely destroyed. Second, that at the time of the burning, the building was a dwelling house. A dwelling house is a structure that was actually being lived in, or that reasonably could have been lived in at the time of the fire. Third, that when the defendant burned the dwelling or any of its contents, she intended to burn the dwelling or contents, or intentionally committed an act that created a very high risk of burning the dwelling or contents, and that while committing the act, the defendant knew of that risk and disregarded it. When there is a fire, the law assumes that it had natural or accidental causes. The prosecutors must overcome this assumption and prove beyond a reasonable doubt that the fire was intentionally set. You may also consider the lesser charge of second-degree murder on this count. To prove this charge, the prosecutors must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Todd Joseph Stermer. It's not enough that the defendant's act made it possible for this death to occur. In order to find that the death of Todd Stermer was caused by the defendant, you must find beyond a reasonable doubt that the death was the natural or necessary result of the defendant's act. Second, that the defendant had one of these three states of mind: she intended to kill, or she intended to do great bodily harm to Todd Joseph Stermer, or she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her action. The prosecutors must also prove beyond a reasonable doubt that the crimes occurred on or about January 7, 2007 within Van Buren County. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon used, the type of wounds inflicted, the acts and words of the defendant, and any other circumstances surrounding the alleged killing. Premeditation and deliberation may be inferred from any actions of the defendant which show planning or from any other circumstances surrounding the killing. The prosecutors need not prove a motive for the killing, but you may consider evidence of motive in deciding if there was premeditation and deliberation. Motive by itself does not prove premeditation and deliberation. When you go to the jury room, you'll be provided with written copies of these final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. I've already given you instructions regarding lesser offenses. As to any count which includes a lesser offense, you must first consider the principal offense. If you all agree that the defendant is guilty of that offense, you need not consider the lesser offense. If you believe that the defendant is not guilty of the principal offense, or if you cannot agree on that offense, you may consider the lesser offense. It is up to you to decide how long to consider the principal offense before discussing the lesser offense. You may go back to consider the principal offense again after discussing the lesser offense if you want to. If you have any questions about the jury instructions before you begin your deliberations, or questions about the instructions that arise during deliberations, you may submit them in writing in a sealed envelope to the bailiff. Possible penalties should not influence your decision. If you find the defendant guilty, it's the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the bailiff. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in this case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside of the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. The exhibits admitted will be available in the jury room for you to review. You've been given a written copy of the instructions you've just heard. As you discuss the case, you should think about all of my instructions together as the law you are to follow. Defendant is charged with 2 counts, first-degree premeditated murder and first-degree felony murder. These are separate crimes, and the prosecutors are charging that defendant committed both of them. You must consider each crime separately in light of all the evidence in the case. You may find the defendant guilty of both or either one of these crimes, guilty of a less serious crime, or not guilty. I've prepared a verdict form listing the possible verdicts. You will have on your verdict form as to count 1, the option of not guilty, guilty of first-degree premeditated murder, or guilty of the lesser offense of second-degree murder, and as to count 2, the option of not guilty, guilty of first-degree felony murder, guilty of the lesser offense of second-degree murder.
Oh, she is charged with second degree.
Counsel,
They
any
didn't say that in
objection to the
opening.
Yep. Did I miss?
She didn't even address that, did she? About no arson, no crime. She does a good job at reading jury instructions, though. She's, her inflection and everything, it's not just, it doesn't run together like a lot of judges. Because most judges just read and it just rattles off together, and it doesn't sound like they're talking to the jury. It just sounds like they're reading something. That sounded like she was talking to the jury. But I didn't hear anything about no arson, no crime like they were talking about before the jury came in, unless I missed it. But in openings, because I read you guys last night, I read you guys my notes, exactly what she said in opening, her very first part of opening, the 3 charges: murder, first degree murder, felony murder, and arson. That's all she said in opening. Well, she needs to, because now I don't know. I agree with the defense, but prosecution said that was a misstatement of the law.
Additions. Mr. Trenko, when I talked to you about experts, he was also qualified as an expert in fire origin and cause. And this is an instruction you got at the beginning of the case, but I'll give it to you again now regarding this being a second trial. This case has been tried before, and during this trial, you may hear references to the first trial. Sometimes a case must be retried before a new jury, and you should not pay any attention to the fact that this is a second trial. Your verdict must be based only on the evidence in this trial. You must decide the facts only from the evidence that you yourself hear and see in this trial. Counsel, any other objections or additions or requests?
No, Your Honor. Thank you.
Yes, Your Honor.
You're good with the instructions?
Yes, will they get a printed copy of that?
You should have one on your,
And they were
No, I'm
given
talking
to
about
the jury already had it.
yeah, the jury has theirs.
the
Pardon?
added ones, the added prior trial.
Oh, you
you
want,
don't
oh,
feel
you're
like
asking
this-
that, does the jury, we'll give them each another copy of the second trial instruction? Okay, we'll add that. We'll just make a copy of that second trial. Okay, we're good on instructions then? Okay, so jury, you may recall, way back in time, at the beginning of this trial, I indicated that we would draw lots to excuse 3 of you. The first person we're excusing is by stipulation of the parties, and it's not random. But the other 2 names we're calling will be randomly pulled. If you're one of those persons, we're going to get you.
What happened to the sound?
We had to call you back in as a juror and begin the deliberations.
Must have said their names.
We will call you when the jury has reached a verdict, and once you get that phone call from us that the verdict has been reached, then you can talk to anybody you want about the case if you wish. Okay?
And then they can watch
So we'll call them.
YouTube 48 hours, whatever. I wonder if it was the juror that during closing she went, "I see your face." Yeah, I don't want that one on the jury. I already made an opinion. I think I know what Peter says and other YouTube lawyers say. Oh, don't listen to me. I don't know anything about the law. All I know I've learned on YouTube. I remember when I first started watching trials on here. My first trial was Depp v. Heard. And then it was the Menendez brothers trial. And I kept, every time they would have a witness talk about things that the Menendez brothers had said to them, I kept saying, that's
You
hearsay,
do
that's
solemnly
hearsay.
swear or affirm that you will, to the utmost of your ability, keep the persons sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made to them or any of them, orally or otherwise, that you will not communicate with them or any of them, orally or otherwise, except by the order of this court, or to ask them if they have agreed on their verdict until they shall be discharged. And that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon.
Okay, jury, you can take your notebooks with you, and I'm directing you to the jury room.
So I was watching Menendez brothers, and like every time a witness would say things that the brothers said to them, I would say, that's hearsay, that's hearsay. And Alita was like, no, that's an exception to hearsay because it's, what's it called? Something about a party opponent or something. Bye, Carla. Opposition of a party opponent, something like that. And so that was my first clue that I didn't know as much as I thought I did. So I have gradually learned more and more and more. That's been what, 2 years ago, 3 years ago? So, oh wow, that's long enough to finish law school, isn't it?
Counsel, any matters to address?
No, Your Honor.
Okay, thank you.
Thank you.
Judy, I don't know. I don't know because I think that might be a standard instruction along with, don't do any research on the case. I don't think they want anyone that's on a jury with a retrial to know anything about a previous trial. But I do agree with you that there had to be something in the first trial that wasn't included in this one because they I'm terrible at multitasking. I can't even click a button and talk at the same time. Yeah, so I think, how long ago was the Depp v. Heard trial? Was that 2 years or 3 years? I've lost track. So 3 years. That's long enough for law school. Statement of a party opponent. Thank you. I never remember that one. Can't remember what that one's called. What I heard, and you guys, my memory's crap, so take everything I say with a grain of salt, was that it was ineffective assistance of counsel. One of the things also was that the prosecutor said that she had 2 cell phones when she didn't. But they have said in this trial many times that she did have 2 cell phones. And a bunch of witnesses have said that she had 2 cell phones. So that can't be true. I think that juries tend to believe that if they found enough evidence for somebody to go to trial, that they're guilty. I just think that's the way that juries think. I could be wrong about that, but that's just how it feels to me. And I also think that juries think that circumstantial evidence means guilty. And sometimes it does. But in this case, I just don't see any proof that she started the fire. Yeah. Did she do some suspicious things? Yes. But I don't see that they proved that she started a fire. Buying gas does not prove that she used it to start a fire. Someone buys gas and their house burns down the same day they buy gas. That doesn't mean that they started a fire because they had a fight with their husband the night before. So they send their kids out of the house the next morning because they think they're going to fight some more. That doesn't mean that, and then their spouse dies in a fire. That doesn't mean that they set the fire that killed their spouse. There's not proof. And if I was on a jury, I wouldn't want to send somebody to prison for the rest of their life on something like that when there's not proof. Maybe I'm being too soft, but I wouldn't say guilty. Even though, yeah, she did some weird stuff. But I can't say for sure she did this. And I'm sure a lot of people would disagree with me. I know Recovery Addict would. But he said that he knew the evidence from the first trial. I don't know if he watched it or just saw some stuff about it. But yeah, Judy, they saw something that made them believe she did it. But apparently something that wasn't allowed in this trial, because that's why she got a new trial. And I don't think they should have put her sons on the stand. And I don't think that their testimony is credible because they were young and then they lived with Todd's mom for I don't know how long. And you know that they tainted the kids' memories of the events. So I'm just not sure. And that's reasonable doubt. So then you have to vote not guilty. In my opinion. Completely my opinion. And I don't know what we're going to do while we wait for jury watch. How long do you think it's going to take? Well, Crime's not doing a clock. Oh, wait. I got to push play. Why does my thing keep pausing? No clock. I wonder if StreamYard don't crash while I do this. I wonder if Court TV has a clock or if they're even doing it. Oh, man. Judge Boyd had a murder trial? I didn't know she did murder trials. Well, I don't. Okay, I don't see it on Court TV. I just see non-crime. I'm sure they're doing it because that's what I've been watching. That's what we've been watching the whole time is court TV. At 3 o'clock today. Well, I don't see it on any of the court channels. Let me see if I can look it up. I'm afraid to touch the computer. I wish StreamYard would get their act together. Um, forgot her name. Shanna Gardner is having a hearing today at, I think it's TV Trial Live has got it as upcoming for 3 o'clock. I don't know if it's gonna be streamed live somewhere at 3. And now I can't find it. Of course I can't find it. Yes, love. What do you want? I hate the face I make when I concentrate, you guys. I'm gonna have a really weird wrinkle right there when I get older. I know what we can do if I can find it. Yeah, I think they all want a new trial. What, Spike? Yeah, see that I'm busy. I'm busy. I thought I had. I thought I had the body cam footage of her arrest, but I guess I don't. And I don't know which one of these videos come first.
Right, and so is the other issue. Now that you have a clarification from the as lawyers, you know, is there a stipulation to the defendant element? Yes,
And I do have a those motion to turn confidentiality to exhibits and to the clerk for filing at this time. Those exhibits have been marked as 1 and 2. They are letters from a medical provider and mental health provider.
okay, there's no objection to those.
And Your Honor, I also have exhibit 3, which is a declaration from Andrew Bagley, a Washington State lawyer, for dismissal of the extradition case for Ms. Carter. And exhibit 4 is an email. And exhibit 5 is a deposit exhibit that includes excerpts settlement purchase agreement and deeds for 270 Ocean Drive, Jackson.
Okay, this will be some, as, defense exhibit one. It's going to have one person. So, a little more.
All right. Get off the screen. Get off the screen, comment. Okay, this is Shanna Gardner. She was married to a Microsoft exec here in Florida, and they divorced. She married somebody else. They moved to another state, and then she hired somebody to kill her husband. So she was extradited back to Florida. And I don't know when the trial is going to start, but hopefully our schedule will allow us to follow this. This is another Florida one that I want to follow. I have 2 of our hearings that I downloaded. I don't know which came first. I'm sorry, guys. I was going to do a video on this. And since we have nothing else to do today, we can watch them. And I'm sorry, I don't know which comes first. And I thought I had video of her, body cam video of her arrest, and I don't see it. So I apologize. I thought I had her extradition hearing too, but I guess not. Because this is clearly in Florida, because there's a Florida flag right there. What you want, dude?
There you go.
All right, thank you.
One more housekeeping matter. On the Zoom is Mr. Angel Ortiz. He's a lawyer for witnesses, John Cody. I just want to inform the court of his presence.
Thank you. Ms. Mansell. How are you? Need to put you in the bond, but we need an answer. Oh, did you have a word out? Yeah. I heard this one right here. No, I needed an answer. They, as the defense filed 2 exhibits that a assert confidential in nature. They have sensitive information. Yes. Yes. Okay. I'm sorry to can't remember. I know that WJST doesn't. Yes, thank you. I didn't mean to make you rush over.
Why does that keep doing that? Okay, can anybody tell me why that play bar thing at the bottom keeps doing that? My cursor is not on it. I mean, it is now, but it wasn't a minute ago. I got it on full screen. And it keeps jumping up like it won't disappear. What is the deal?
On the docket line of the defense commission.
Why is it doing that? It's driving me nuts.
So the state filed a motion for pretrial detention, and I just found it, and then we're offering, the right purposes holding the hearing of the defense motion. comments that the state indicated that during your first.
Yes, sir.
All right. The state can call it first witness.
Whoops. Stop. It's driving me crazy.
You solemnly swear in the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Yeah. Yeah. Yeah, thank you.
Good. Mr. Johns,
And what agency are you employed with?
I work with Jackson Beach Police Department.
How many years have you been, I'm gonna call it Jack's Beach PD for time sake policy. How long have you been employed with Jack's Beach PD?
A little over 5 years.
And prior to your.
Because Jacksonville is so hard to say.
Your education and job experience.
I mostly worked in the financial industry, mostly consumer banking and investment management. I held a stockbroker's license as well as a firm principal's license, and I'm currently registered with the SEC as an investment advisor.
And with the Jackson Beach Police Department, what's your current role?
I'm a detective in our criminal investigation unit, which handles pretty much everything with the exception of vice or drug crimes.
So that would include homicides, armed robberies, major crimes, all the way down on.
Yes, ma'am.
And did you have any special training or experience to become a detective in the criminal investigation unit?
On top of the police academy, I've attended approximately 300.
Law and Crimes poll has 82% guilty, 10% not guilty, and 8% hung jury.
Hours of special ed training and criminal investigations or crime scene investigations. About 120 of that team for death investigations and homicides.
And you are the lead investigator. To investigate homicide.
Yes.
I want to talk to you a little bit about your initial involvement in this case. February 16, 2022, you dispatched to the scene in which you were in the victim.
Yes.
And where in Jacksonville County was this homicide?
I was dispatched to Jacksonville Drive and Sanctuary Boulevard, which is it's really an on-ramp to JTV and also serves as a entrance into a neighborhood called Sanctuary. Yes, ma'am.
There was a child in the vehicle with Jerry. I believe his name was Bart's initial BP.
Yes.
And what was the relationship to the victim, Jerry?
Jared Stuck.
Do you know approximately at the time of your arrival on scene how old she would have been?
2.5.
When you arrived on scene, where was he located?
When I arrived on scene, a good Samaritan grabbed her from her car seat, which was in the back of the vehicle, taken them to their vehicle and covered her with a boat.
Do you recall what BB's demeanor was like when you encountered her on scene that night?
She was very upset, crying, scared, obviously.
And the Good Samaritans relayed to you the day of taking her out of her seat. Did you have the opportunity to observe Jared riding in his vehicle on scene that night?
I did.
And Jared himself was not in the vehicle.
Correct.
Can you describe to the court in relation to where BB was seated in the car seat, what damage you observed to the vehicle?
In regard to she was at least 2 restrictions, and striking the bottom of the window sill and shattering that would have been just in front of her car seat.
And I guess I didn't ask this specifically, but Jared riding in was pronounced deceased by the medical examiner, cause of death being gunshot wounds.
Yes, ma'am.
And from your review, were there projectiles that entered into the vehicle in which BB was in the car seat?
There were. She made mention of hearing a loud sound, boom, boom, saying she had to take her shoes off to cover her ears. And she made mention that her dad was sick and was on the ground and taken to the doctor.
Oh yeah, I forgot to tell y'all his kid was in the car.
Just in an investigation, you also did many hours of machine in the days, weeks, months following your response to this scene.
Yes, ma'am.
Did you eventually were able to make an arrest in this case for the murder of Jared Bradigan?
Yes, arrest.
And who did you arrest?
Henry Ten, Shannon Gardner, and Mari Francis.
I want to speak for a moment about Henry Tennant. Henry Tennant was arrested.
She hired the guy to do it, and he did it while his kid was in the car. He put something in the road so that he would have to stop and pull over to get the obstruction out of the road, and his kid was in the back seat. That's despicable.
Charged with the murder of Jared Bradigan, including the discharge of the firearm that caused his death. And to your knowledge, has Henry Tennant pled guilty to his role in the murder of Jared Bradigan?
He did.
Were you present when Mr. Tennant gave what's called a sworn statement in conjunction with his plea, which outlines his involvement in Jared's murder?
Yes, I was.
What did he advise you about how it was that he came to be involved in Jared's
Mr. Ten was a tenant at one of their rental properties, and he had been approached by Mr. Fernandez a number of times, asking him if he would participate in his homicide. Mr. Tennant stated that he initially denied Mr. Fernandez's request. However, once Mr. Fernandez had agreed that they would, Shannon and Mario would invest $150,000 into a pallet business, he agreed to participate.
Now I want to go back and ask a follow-up question about that. When you say that Henry Tennant said Mario Fernandez requested him to participate in a homicide, what specifically was that conversation, according to Mr. Tennant?
He stated that in exchange for the money, that Mr. Fernandez would provide a firearm, and then they would contrive a plan. Initially, the plan was to kidnap Mr. Bradigan and then take him to another location and murder him.
And did Mr. Tennant advise as to what, if anything, Mario Fernandez Saldana said about why he wanted to murder Jared Bradigan?
They had initially planned, or were planning this in late 2021, and then after returning from a Hawaii trip in February, Mr. Fernandez approached Mr. Tennant and stated that this needed to happen this week. And if he didn't get it done, his marriage was going to end.
Did Henry Tennant know Jared Bradigan?
No, he did not.
Have you ever seen him before the night of the homicide of 16, 2022?
No, in fact, there were two instances where Mr. Fernandez took Mr. Tennant in an attempt to show him Mr. Bradigan, and both of those failed attempts.
Other than the relationship of Mr. Tennant being a tenant of Mario Fernandez Shannon Gardner's rental company, were you able to find in your investigation any other link or connection between Henry Tennant and Jared?
No.
In your conversations with Henry Tennant, was Mr. Tennant able to, even before this night, describe what Jared Bradigan looked like? What type of car he drove? Did he know on the night that he murdered Jared Bradigan that BD would be in the vehicle?
He did not.
Detective, I'm going to draw your attention to a screen that's in your witness box. Some of these exhibits have been entered by agreement of both parties. I'm going to start with Exhibit 1. Detective, what is this?
These are articles of organization for a company named First Choice Home Rentals LLC. Annual filing for that same LLC.
Okay, so when you're we say that annual filing on state exhibit 2 is to be the annual report of First Choice Home Rentals LLC. Going back to state exhibit 1, you have some familiarity with this from your records. Who are the title holders or principals on these articles of organization?
Both Ms. Gardner and Mr. Fernandez are listed as managing members or which would be considered members of the LLC.
And the LLC is First Choice Home Rentals. What was the business of this LLC?
The business was established to manage their rental property holdings.
And these are some of the articles that we'll have. But under Article 5, the electronic signature on this article of incorporation is Shannon Gardner.
All of them, so
Moving to state exhibit 2, this document is an annual report. What is that?
this is just a document that's filed every year. Basically, let the state know this is still an active company and that to make any changes to the ownership or management.
And this was filed in the upper right hand corner, January 28th, 2022, which was a few weeks before the murder of Jerry Morgan. And again, at the bottom, who are the still owners or signatories on this LLC?
The listed owners are Shannon Gardner and Mark Fernandez.
I'm turning your attention to State's Component Exhibit 3. Detective, can you describe to the court what these documents are?
This is the bank statement from Navy Federal Credit Union that held the account for First Choice owners.
And in the exhibit the court will receive, you obtained these records via subpoena and they are accompanied by certification records from Navy Federal.
Yes, ma'am.
And there's a red box here. Can you describe to the court what that is indicating?
The red box is indicating a transfer from a separate checking account also held in a federal credit union. In this instance, it's stating that on March 15th, $5,000 was transferred from the Shannon Gardner Irrevocable Trust account that Navy Federal into the First Choice Rentals.
This is another exhibit or another page of Composite Exhibit 3, again showing that the First Choice Rentals LLC was getting appears to be monthly transfers from the Shannon Gardner Irrevocable Trust.
There was another transfer in April of the same amount.
And we'll come back to the trust in a moment. I'm going to move to State's Exhibit D. What records are we looking at here?
This is a PNC bank statement for Mr. Henry Bennett's account.
Four. I'm sorry. In your discussions with Mr. Tennant involving how he became part of this ancient murder, you mentioned that he was promised a payment. Can you give us any more details about what Mr. Tennant advised you that he was promised and how he received this money?
He was promised $150,000 in the form of
In a lump sum or an installment?
the installment payments.
Was there any discussion of why that would be the case?
That's not arousing suspicion.
And moving through Composite Exhibit 4, documents for Mr. Tennant, and a portion of the standard checking statement. Okay. Drawing your attention to the screen now, there's a red box. Can you describe to the court what is indicated by that on this checking statement?
The statement is indicating a deposit for $2,000 on March 28th, which would be in line with the check that's in the top right hand corner.
And this is March 28th, 2022.
Correct.
This would be about a month and some time after the murder.
That's correct.
And then a second red box.
Correct.
Describe what this indicates.
This is a check that was deposited on the next day, on March 29th, for $3,000, also written from First Choice Rentals.
Okay. And on the next slide, we see the final check and final box. Can you describe what we're seeing here?
This check is on April $6, written to Hamilton from First Choice Rentals.
And in the subject line, it says Kickstarter good luck. Can you describe for the court, based on your conversations with Mr. Tennant, what this check is actually for?
Mr. Tennant stated this was the first of many payments that was supposed to be an investment into his pallet company, which was actually payment for the homicide.
Now, the prior check, the $3,000, $4,000 were marked for landscaping and roofing. What did Mr. Tennant say about those?
He stated that those payments were for legitimate work that he had done on the rental property of the Potomac Cabin.
So this was the first and the only payment he actually received from First Choice Home Rentals. The contract killing. I want to talk about Ms. Garner and Mr. Hernandez. When you were investigating a murder of your writing, were you able to eliminate your investigative techniques, other potential suspects?
In the beginning, we really didn't have any suspects. We look at everyone who might be close to family, any relatives, spouse. And so through various techniques, we start to eliminate people. We just had no reason.
And did you do search warrants and subpoenas into Jared Cardigan and those in his immediate inner circle?
Yes, ma'am.
Did you download Jared Cardigan's phones, work phones, personal devices, financial records, all detailed records for Jared Cardigan? Did you get them for his wife, Kirsten Cardigan?
Yes, ma'am.
Did you get them for many people close to him and his family and inner circle?
We did.
Was there any indication through your investigation that anybody, putting aside Ms. Gardner and Mr. Hernandez, had any problems with Jared Cardigan or any motive to carry out the homicide? There's no death that he was hiding,
No.
no evidence of drug use that he was hiding.
By all accounts, Mr. Brady was a very boring person who lived a very close and religious family life. He had no debts, had plenty of money in the bank, no indications of gambling or drug habits, no affairs. These were all things that we checked for.
And you even spoke to people who even had minor arguments with Jared over the years, just to check them out.
Correct.
So during your investigation, at some point, did you start hearing from people that you should be looking at Shannon Garner and Marna Hernandez on as?
You guys, I'm gonna see if I can find this on YouTube because the sound will be better. Because when I play, somebody told me if I download a video and then play it through StreamYard, that it won't tax StreamYard as much. So it will be a better experience for you guys. But I don't know how to do the audio when I do that. So you guys are hearing the audio through my speakers and then through my microphone. And the audio isn't as good. So I feel like if I can do it through YouTube, you guys are going to get better audio. And it's still on YouTube. So let's just watch it through YouTube. And then I don't have to worry about a stupid bar in the bottom. And I will tell you what little I know of this case. So she got remarried to this other guy. He got remarried. They had one kid and one on the way. So the kid in the car with him was his kid from. Yeah. Sounded way better. So this guy put something in the middle of the road that he could not go around. So he couldn't avoid it. So he got out of the car to get the thing out of the road. And when he did, the guy pew-pewed him. With his kid in the back seat. He had just had custody of his kid that he had with Shanna Gardner. I think like one night a week he had him for dinner, or her. I don't remember if it was a girl or a boy. Like a family dinner thing. And he had just returned the kid and then was going home to his pregnant wife.
On the rental property on Potomac Avenue.
So this was the first and the only payment he actually received from First Choice Home Rentals for the contract killing of Jared Brightigan.
Correct.
I want to talk about Ms. Gardner and Mr. Fernandez, your development of them as suspects in this case. When you were investigating the murder of Jared Brightigan, were you able to eliminate, through investigative techniques, other potential suspects?
In the beginning, we really didn't have any suspects. We look at everyone who might be close to the family, any relatives, spouse. And so through various techniques, we do start to kind of eliminate people who just had no reason or no capability of doing it.
During your investigation, did you do search warrants and subpoenas into Jared Brightigan and those in his immediate inner circle?
Yes, ma'am.
Did you download Jared Brightigan's phones, laptops, work phones, personal devices?
We did.
And you reviewed all those records?
We did.
Did you get financial records and call detail records for Jared Brightigan?
We did.
Did you get them for his wife, Kirsten Brightigan?
Yes, ma'am.
Did you get them for many people close to him in his family and inner circle?
We did.
Was there any indication through your investigation that anybody, putting aside Ms. Gardner and Mr. Fernandez Saldana, had any problems with Jared Brightigan or any motive to carry out the homicide of Jared Brightigan?
No, there was not.
There's no debts that he was hiding?
Nope.
No evidence of drug use that he was hiding?
By all accounts, Mr. Brightigan was a very boring person who lived a very close and religious family life. He had no debts, had plenty of money in the bank, no indications of gambling or drug habits, no affairs, and these were all things that we checked for.
Okay. And you even spoke to people who even had minor arguments with Jared over the years, just to check them out and clear them?
Correct.
So during your investigation at some point, did you start hearing from people that you should be looking at Shanna Gardner and Mario Fernandez as suspects?
Almost immediately.
Directing
Board of Ms. Gardner stating that she hated Jared and could not stand the fact that she had to share custody with him and that she wanted him dead.
And you heard this unsolicited from numerous people, not just one person?
Correct.
When you heard this information, did you investigate into the past history of Shanna Gardner and Jared Brightigan?
Yes, ma'am.
And they had gone through a pretty acrimonious divorce.
Correct.
And can you briefly describe for the court what that investigation uncovered for you?
They were divorced in 2015, and pretty much consistently between 2015 up until Jared's death, they were in court at least annually. Pretty much every aspect of the child custody was litigated and fought through mediation. It was to the degree that they no longer had any type of verbal communication about their children. Everything was done either in writing or through an attorney.
And from your investigation, were they even able to be in the same room together?
No,
How did they co-parent?
through the court.
When they went to the school, did they have separate parent-teacher conferences?
It was indicated that they had separate parent-teacher conferences. They would have separate doctor's appointments, or only one of them would attend the doctor's appointments. There was virtually nothing that they did together as far as their kids were concerned.
During your investigation, you spoke with Mr. Fernandez Saldana and Ms. Gardner. Did they tell you and corroborate this information that there was this bad relationship between them as co-parents?
Yes, much of this information came directly from them.
And from your investigation, can you describe for the court some of what you uncovered about what Ms. Gardner was trying to do through the court system in terms of Jared's ability to participate in co-parenting?
Ms. Gardner was attempting to initiate a quote-unquote social investigation or a BCF investigation in an effort to gain, if not majority custody, sole custody over the children, so that she did not have to involve Mr. Bradigan in custody issues.
What kind of things were they disagreeing over in terms of child rearing?
Everything from schedules to who could be around when the children were there, and then to more severe things such as medication, medical devices that one of the twins needed. There was little that wasn't litigated.
What about religion?
One of a big contention, which I don't think it's ever made it to litigation, Mr. Bradigan did state that he wanted to raise his children in the Mormon faith, and Shannon did not want to raise the kids. At some point, one of the twins indicated that she wanted to be baptized into the Church of Latter-day Saints, and this was very troubling for Ms. Gardner.
And when we all hear that, can you put into perspective for the court how big of an issue religion was to Jared Bradigan?
He was a devout member of his church, a very faithful person, so it would have been an extreme issue for him.
I also want to talk about Shanna Gardner's financial motivations. Earlier, we saw records from the Shanna Gardner Irrevocable Trust. Can you describe for the court, have you seen the trust documents yourself?
I have.
Can you describe for the court what the trust is and what it was, I guess, created to do?
So the trust would operate as a separate entity. The trust was funded by Ms. Gardner's parents, and it was a way that they could essentially give money for the benefit of Ms. Gardner and the twins that would not be considered her personal income, and so therefore Mr. Bradigan would not have any access to those funds. In this case, the grantors were Mr. and Mrs. Gardner, and the trustee was Margaret Fernandez.
So the trust not only was something that people with a lot of money do with their money, there's also partially motivated by wanting to prevent that money from being litigated in the courts between Jared Bradigan and Shanna Gardner.
That's correct.
Had they had a history of litigating finances in addition to all the child custody issues?
Yes, during their divorce, their financial situation, especially their marital home, was heavily litigated.
And I'm turning to a portion of State's Composite Exhibit 6. Detective Johns, this is from the trust document itself. Can you describe for the court what this clause means?
This clause states that once Ms. Gardner has no more legal entanglements with her ex-husband, Mr. Bradigan, she may elect to serve as trustee of her trust, essentially giving her control over the assets inside the trust.
At the time of Jared Bridegan's death, who was the acting trustee of the trust?
Mario Fernandez.
I want to turn your attention to what we discussed earlier, that you actually spoke with Mr. Fernandez-Aldana and Ms. Gardner during the course of your investigation. How many times did you speak with Shanna Gardner after the homicide of Jared Bridegan?
I spoke to her twice.
And let's talk about that first interview. Did that occur March 1st, 2020, Mr. Fernandez-Aldana at the Jacksonville Beach Police Station?
I did.
Okay. Did you ask them to come to the police station and speak with you?
Initially, yes, I did.
And were you speaking to many other people as you testified earlier? At that point, you had no suspects.
We were doing dozens of interviews.
Conversations with them. Were they custodial interrogations? Were they under suspicion at that time?
Absolutely not. At that time, we were just really collecting information about who Jared was, anyone that he might have associated with. We wanted to basically know everything we could about him. Really, he was kind of the focus at that point in our investigation.
Well, what did you advise Ms. Gardner was the purpose of your conversation with her on March 1st, 2022?
I stated at that time we were doing something that we refer to as victimology.
And that would be a background investigation into the victim, in this case, Jared Bridegan.
Correct.
When you spoke with her, did you speak with her in what's called the soft interview room at Jacksonville Beach Police Station?
Correct. We have two interview areas. One of them would be what someone would maybe describe as an interrogation room. There's no soft furniture. It's a room with a couch and a couple of chairs. And it's where we conduct our interview, really just more interviews versus interrogations.
And Ms. Gardner was brought to that room for her interview?
Correct.
Just like every other witness you spoke to in this case?
That's correct.
And during that conversation, just a brief overview of her demeanor and how that interview sort of began.
She was very forthcoming. It was a very typical interview. She was very talkative and provided a lot of context without a whole lot of questions being asked.
And you say provide a lot of context. What was the general tone of that context she provided?
The general tone of it was, I don't really know a whole lot about Jared now, but I will tell you how he was when we were married and what our divorce was like. Essentially, he was manipulative and caused her a lot of trauma, and then moving on to we had a terrible divorce, and then talking about how that affected the children, and so on, really.
Did she bring up at any point that Jared Bridegan was at all abusive towards her, physically or verbally?
She stated that he was in fact not physically or verbally abusive.
And during this conversation, part of the reason you spoke to her is that she and her husband, Mario Fernandez, and their children, her children, A.B. and L.B., were the last people to see Jared Bridegan alive.
That's correct.
And did she give you some indication as to where everybody was in the house during the time of the homicide?
She stated that when the kids were dropped off by Mr. Bridegan, Mario was asleep and she was cooking with her earphones in the kitchen.
Did she say where he was sleeping?
I don't know that she stated that where he was sleeping during her interview, but he indicated that he was on the couch.
Did you have a second, and you also interviewed Mario Fernandez-Aldana separately, but on the same date as this interview?
Correct.
I want to jump forward. April 15th, 2022, did you have a second interview with Ms. Gardner?
I did.
And how was it that you came to interview her a second time?
At that point, we were not anticipating having a second interview. We were actually approached by Mr. Fernandez. He asked if they could come by. They were receiving a lot of media scrutiny or people from their neighborhood complaining, basically accusing them of being involved in this. So Mr. Fernandez specifically wanted to know if this was something that we were encouraging or that if we were behind it. We indicated that we were not behind that. And then he to come by and basically do the same thing, and she agreed to come speak with us.
like the first interview, was this what we would call a soft interview or a custodial interrogation?
It was a soft interview.
Same interview room with the couches,
Correct.
no reading of Miranda rights,
No.
no questioning of her as a suspect.
Correct.
During this interview, describe her demeanor.
This demeanor, she was much more upset, but she was upset because she felt like she was being attacked in the media or on social media, really. And she did not feel safe leaving her home because people were recognizing her and they were basically blaming her for this homicide.
In this particular interview, did you ask her many questions?
No, not at all.
Did she do most of the talking,
She didn't.
unprompted?
Yes.
You did ask her a question about whether she had any theories about what happened to Jared.
Towards the end of the interview, we asked if she had any theories about what she thought might have happened.
Did she?
She provided some.
And let's start there. What did she say she believed happened to Jared Brightigan?
She said that maybe it was a drug deal gone wrong or a gang initiation, and then she stated that we should look into Kirsten Brightigan.
What did she say about it being a drug deal gone wrong? What made her think that that was a possibility as conveyed to you?
She said that she had heard from friends that Sanctuary Boulevard was where you go to buy drugs in Jacks Beach.
And you're a general investigations detective with the Jacksonville Beach Police Department. Based on your knowledge and your years with the force, is that true?
I have never heard that.
Okay. What about, you mentioned gangs. What did she say about gangs?
She said that she had heard that some gangs do initiations by doing drive-by shootings like this.
Okay. And in your experience with the Jacksonville Beach Police Department, have you all ever had a gang-related drive-by shooting initiation case involving the murder of a father in a vehicle with his child at 7:50 p.m.?
I'm unaware of any of them.
In general, do you get many gang initiation shootings in Jacksonville Beach?
I'm not aware of any.
Lastly, what did she tell you about Kirsten Brightigan?
Just that we should look into her as a suspect for the homicide.
Did she give you any reasons?
Not that I can recall at this moment.
All right, so she gave you these theories to potentially investigate. Presumably she was trying to be helpful.
Presumably.
Did she ever mention that you all should investigate Mario Fernandez Saldana?
No.
Did she ever mention any conversations she had had with Mario Fernandez Saldana about killing Jared Brightigan?
No.
Did she ever mention someone by the name of Henry Tennant?
She did not.
Did she ever mention anything about knowledge of a vehicle that looked like the one in the news release that Jacksonville Beach put out?
No.
Did she ever mention to you that people might come forward saying that she had said she wanted Jared Brightigan dead?
No.
Did she ever mention to you that people may come forward saying that either she or Mario Fernandez Saldana had talked in the past about hiring a hitman to kill Jared Brightigan?
No.
Was that your last contact with Miss Gardner?
Yes, it was.
Now, after that point, you began to develop leads in your investigation, and you began to look at some point at Ms. Gardner and Mr. Fernandez Saldana as suspects.
That's correct.
And you zeroed in on Henry Tennant and were able to identify him as a person of interest, perhaps the shooter.
Correct.
And after his arrest, you were able to obtain evidence further into his involvement, as well as the involvement of Ms. Gardner and Mr. Fernandez Saldana.
That's correct.
I want to go through some of what your investigation revealed after you last spoke with Ms. Gardner. And for the court's information, in the state's exhibit, there's a composite 7, it's an extraction report of a cell phone belonging to a woman named Kim Jensen. Detective Johns, who is Kim Jensen in relation to Ms. Gardner?
Kim Jensen was a lady that Miss Gardner met when she moved to Jacksonville. They were a member of the same ward or church, and they became very good friends. by all means, best friends.
Did their friendship begin before Jared Brightigan and Miss Gardner were divorced?
No, their friendship did begin before their divorce, correct?
So she knew her when she being Miss Jensen, knew Miss Gardner when she was married to Jared Brightigan.
Yes, that's correct. And in fact, she knew Jared longer than she knew Miss Gardner.
Based on your investigation, we see your text messages. At some point, did you obtain a cell phone download of Kim Jensen's phone?
We did.
And was there contact between Miss Jensen and Miss Gardner?
There was extensive contact on a daily basis between the two of them,
For how long?
at least going back to 2015.
And how frequent was their contact with each other?
It was numerous times a day, phone calls, text messages,
Voice notes?
all kinds of things.
And from your review of not relevant to the homicide necessarily, but for context, your review of their contact, did they seem to have a very close of their lives?
Yes,
The most mundane details of their lives.
yes.
So we're looking at here State's Composite Exhibit 8. These are text messages on Ms. Jensen's phone that you found between her and Shanna Gardner dating back to 2015. And we're going to start there and work our way forward to 2022. I know it's difficult to read. Can you please describe for the court the conversation, tone, and tenor between Ms. Gardner and Ms. Jensen regarding Jared that began around this time period?
The context of this particular chat chain is Shanna telling Ms. Jensen that Matt is ready to come over there and to talk to him, meaning Mr. Brightigan. She said it would not be physical, and maybe then moves on to basically say, that they could maybe encourage it to become physical at some point.
Miss Stifler, what did you identify this as?
This would be State's Composite Exhibit 8.
8, okay. Thank you.
Sorry, my computer decided to reset its password in the middle of this.
Okay.
In 2015, what was the status of Shanna Gardner and Jared Brightigan's relationship?
In the beginning of 2015, they were still married, and they did eventually divorce in 2015.
Moving on to page 2 of State's Composite Exhibit 8, more text between Ms. Gardner and Kim Jensen, and what are they talking about here?
It says Matt was ready to come over here today and talk to him. It wouldn't get physical yet, but I tell him if these things happen, X, Y, and Z, then A, B, and C will happen to him. And if he calls the cops, Matt would know, and A, B, C would happen. He said, I tell him he can thank the beautiful woman he's leeching off of that he is even still alive, because if it were up to him, he would have disappeared months ago. I told him your comment about the casserole, ha ha ha. We both had a good laugh.
Okay, and then Ms. Jensen replies, and she talks at some point in this text here about funeral potatoes. Did that phrase become relevant to your investigation?
It did. There were two phrases that kind of were a continuation during all of their text messages. One of those referred to as a casserole, also aka funeral potatoes, or then there was the phrase of doing magic.
right.
Sorry.
So sorry, I don't mean to interrupt you. Let's talk about the funeral potatoes casserole. Did these words, were they used frequently in conversations between Shanna Gardner and Kim Jensen?
Yes, they were.
And in what context were they used?
In reference to the death of Jared.
So there's more text here about funeral potatoes. These are, in fairness, everybody blows off steam when they're mad at their ex-husband.
Absolutely.
Okay. But at some point, did these texts continue and escalate to the point where they became significant to your investigation?
There was a continuation of this type of texting between them throughout their entire relationship that we were aware of. starting in 2015 through at least 2021. And I would say that the messages get much more vulgar than this.
So here we have, again, on the state's composite exhibit, 8 text messages from 2015. Shanna Garner saying, I would happily watch them give him the lethal injection. They're talking about they would love to see him get the death penalty and they could make a casserole. And moving on, again, state's composite exhibit 8, more text messages. And in these ones, there's a discussion. Can you describe to the court where this discussion develops?
These are essentially theories of what they could do to, Ms. Jensen refers to Jared as stupid.
Okay, so stupid, and we'll see that in other text messages. That was a nickname that Ms. Gardner and Ms. Jensen used to refer to Jared Bardigan.
Correct.
Okay. So what direction does this conversation take?
It's essentially just more about ways that Ms. Gardner is unhappy with Mr. Bardigan, that she would like for him no longer to be alive, and then they talk about casserole, and then they will move on to other things as far as how to cause his death.
These are difficult to read. This is State's Exhibit Composite 9. These are texts in 2016. And the next slide will be zoomed in a little bit. But here we see Ms. Gardner. This is the first time she brings up the word hitman in her discussions with Ms. Jensen. Can you describe for the court what this conversation centers around and how it develops?
Essentially, Ms. Gardner is upset. She says it's too late to get a hitman. I'm serious. I think Ms. Jensen is trying to kind of talk her down a little bit. And then they move on to basically where they start talking about does she know anyone that could actually carry out this plan?
There's anything you want to circle that Ms. Jensen says, I know Sue's husband knows people. Ms. Gardner replies, and then replies, I'm not even joking, I want him gone, and the conversation goes on from there. At the time they're having this conversation, and here's a zoomed in version of it, simultaneous with this conversation, did you also find text messages between Ms. Jensen and the person that they were discussing finding them a hitman in the previous slide?
Correct. So while this conversation was going on, Jensen reaches out to the person that they're referring to and asks if she knows anyone that can do magic, i.e. make someone disappear, referring to do they know anyone.
And one quick second. These text messages between Ms. Jensen and the third party are referenced in both the exhibit we just looked at and text messages that you found later, correct?
That's correct.
And in your conversations with Ms. Jensen, she disclosed to you that she reached out to this person because of her conversations with Ms. Gardner.
Correct.
Your Honor, at this time, the state would seek to move into evidence that's been marked as State's K as State's Exhibit 10.
Any objection?
I'm sorry, as State's J as State's Exhibit 18.
Your Honor, same objection. I don't see anything in here where Ms. Gardner is asking Ms. Jensen to reach out to Sue. I don't know how that can be, what Ms. Jensen did can be used against Ms. Gardner at this point. Again, we're talking about things that are 6 years prior to the killing of Jared Brodigan. I don't believe there's any allegation from the state whatsoever that this led to anything, or that even in the state's theory, to the death of Mr. Brodigan. It's totally irrelevant. It is so stale, and this court should not even consider it for purposes of this bond hearing. It's not relevant.
Your Honor, that
Even as a co-conspirator statement?
Are they saying that the conspiracy went back to 2016? Is that the state's argument?
Ms. Stifler?
Your Honor, the date range encompasses these text messages in the charged indictment. There are further statements leading up to the death of Jared Brodigan between these individuals. They are relevant because they show Ms. Gardner's state of mind, intent, incitement, encouragement as it relates to being a principal in first-degree murder. This is a bond hearing. The rules of evidence are loosened. There's no jury before the court. The court can give whatever weight to these text messages it deems fit based on the argument of Mr. Carodi, but his argument goes to the weight, not the admissibility. They are admissible because they are simultaneous statements to a conversation she's having with Ms. Jensen to a third party that is then referenced by Ms. Gardner and Ms. Jensen about what it is they're planning to do or hoping to see done.
As far as the dates, the indictment covers a different time period for the conspiracy. I'm looking at it. As to count two, conspiracy covers one in between.
Yes, ma'am.
All right, I see it now.
Your Honor, and I would argue then we have a multiple conspiracy problem here. What are they actually charging us as the conspiracy? Because the conspiracy,
No.
I think that you have a multiple conspiracy problem.
Maybe for a jury, but why would that apply in a bond hearing?
Judge, the argument would be relevant as to purposes of this hearing, which would be, one, because there's only one capital offense on this indictment, the proof evident presumption grade, and the evidence that the state must carry with regard to that is only to the first degree murder charge. So evidence of the conspiracy, I would say, is not relevant. And then the second question would be the state's motion for pretrial detention, which is generally, is she a danger to the community or a flight risk? And I don't see how this evidence would be relevant to that either. And I don't believe there's any connection to this piece of evidence and the killing of Jared Bridegan in February of 2022.
What's the connection?
The connection goes to her intent, incitement, encouragement. Her intent that the crime be committed, which is the first element of the principal language. She's a principal of first degree murder. She wasn't the one who pulled the trigger. She's the one who set the events in motion. And the state has to prove that she had the intent, specifically that the murder of Jared Bridegan take place. So all of these statements and all of this interaction with her co-conspirators and her attempts to solicit and conspire with other individuals that failed up until the point she found the ability to complete the task with Mario Fernandez and Henry Tenen are relevant to her intent.
I guess my question would be, that's why this is admissible. Why would the conspiracy of KJ reaching out to whoever those text messages would be relevant and the connection to Ms. Gardner?
Because she attempted to bring in these individuals into her conspiracy that ultimately resulted in the death of Jared Bridegan and Mario Fernandez Aldana, as the court will hear from Detective John's testimony later in this hearing.
Judge, if the court reads these text messages that are on the screen, Ms. Gardner never asked Ms. Jensen to reach out to sue. This is Ms. Jensen on her own volition. I don't know how that intent can be imputed to Ms. Gardner.
Give me just a moment. These are hard to read. What are the timing of those other messages?
So when she and Ms. Gardner are suggesting is it too late to get a hitman, she says, Sue's husband knows people. She says, I'm not even joking, I want him gone. That's at 1:31 p.m., 7/17/2016. The following slide shows contact between Ms. Jensen and another party on that same date at 4:33 p.m. And then states exhibit composite 9 includes text messages on 7/19 and 7/21 in which said, do I ask so-and-so about people? Should I ask him today? Referencing the same person that Ms. Jensen and this other third party were discussing.
Tell me the date and time of that.
That one would be July 21st and July 22nd. She asks on July 21st, do I ask X about people? I wait. July 22nd, can I ask M today? Let's see what H says.
Okay, give me a second.
Yes, ma'am. They're also using language in this text that's at issue, code words that they use in other discussions, such as magic, making someone disappear, etc. This conversation clearly is in context of Ms. Gardner and Ms. Jensen discussing, asking these people. She just reached out. It doesn't, my contention is she did ask her to reach out. When she says, Sue's husband, I know people, she says, I'm not even joking. I want him gone. That seems like the go-ahead to reach out. I think it's relevant, and the follow-up conversation they have references the conversation Ms. Jensen had with this third party. In the context of following up, let's ask these people. Following up, let's ask these people. Using the code word that she uses with the third party. It gives context to what the defendant and Ms. Jensen are discussing.
And the messages you're saying are on the same date, just
Yes,
later in the
ma'am.
time?
And these messages between Ms. Gardner and Ms. Jensen, they're saying things.
No, I'm saying the messages that are in question are on the same date, just later in time? You
Yes,
said
ma'am.
4 o'clock?
They were at 4:30. This conversation continues from 1:27 p.m. through 4:49:56 p.m. in which they're discussing these code words, Chris Angel, magician, disappear. The texts of the third party are in the midst of these text messages also discussing magicians and making people disappear. And then Ms. Gardner and Ms. Jensen in the following days reference the individuals that are connected to this third person.
Is that the one at 17? I'm sorry, 7/17 at 4:45? Is that what you're referring to?
Yes, ma'am. On the third call, the first
The 4th?
four text messages. And then the first text message in the fourth column. And then the last text message in the second column and the entire first column.
Anything further?
No, Your Honor.
All right, I'll overrule the objection.
All right, Detective Johns, I sort of did it for you. I went through these text messages. In these messages, Ms. Gardner and Ms. Jensen are discussing getting a hitman, not even being joking, and asking if Sue's husband is.
Wait.
Oh. that would be J coming in as states 18.
All right, I'll overrule the defense objection. J will be marked as State's Exhibit 18. All right, I'm sorry. You may proceed.
And Detective Johns, we are speaking about older messages, but in your course of your investigation, did this type of discussion continue between Ms. Gardner and Ms. Jensen all the way up to Jared's death?
It does.
And in these messages, they used what you mentioned earlier to be another one of their favorite code words to describe Jared's killing, which would be magic, magician, disappearing act, Chris Angel.
Correct.
So here we are, it states Exhibit now 18. These are text messages between Ms. Jensen and SL. And in these messages, Ms. Jensen is asking her if she knows someone, and she says, Shanna needs a guy. And what direction does this conversation take?
Basically, Ms. Jensen's reaching out to Ms. Lee and stating, hey, Shanna needs a guy who does permanent disappearing acts. And she says that she needs a magician for stupid, referring to Mr. Brodigan, and ask if she knows anyone who can basically accomplish this.
And then the messages between Ms. Gardner and Ms. Jensen following that conversation, do they again reference this idea of magic or magician?
Yes, they're initially talking about ways to destroy Mr. Brodigan, in reference to feeding him things that might give him a heart attack. And then Shanna makes the comment that the best time for quote unquote magic is when they're amicable.
And then here, she and Ms. Jensen are discussing the potential individuals they could contact, including someone named Matt.
Yeah, she makes reference to Matt, who she talked to earlier, who was the trainer from the YMCA that she had the alleged affair with.
Okay. We don't need to get into that for purposes of this hearing. They're referring to someone named Nick, and she says between one of those four. So we have several people, Matt, Nick, the individual that she was speaking to Ms. Lee about, and they start referring to them by code names. So M, and then the next slide, which is their 2 days of follow-up, July 21st and July 22nd. This is Ms. Gardner in the dark gray, and she is asking Ms. Jensen, do I legit ask Matt about people? Ms. Jensen says to wait. She says nothing, and then the next day, they're again asked, can I ask M today? And to see what H says. Now these text messages, this is not the only contact that Ms. Gardner and Ms. Jensen are having. They're not just solely communicating by text, are they?
No, they're communicating via phone and other ways as well.
So in some of these text messages, are there points where the conversation ends and a phone call begins?
Correct.
And we're going to move on to some 2021 text messages in a moment, but I want to talk about how this kind of discussion continues with Ms. Gardner, not just with Ms. Jensen, but with other individuals. So these text messages go up through 2016. I want to discuss some of these individuals who came forward voluntarily to the Jacksonville Beach Police Department with evidence that Ms. Gardner had made similar comments to them. So let's begin. In 2017, did a relative of Jared Brodigan seek you out?
Yes, Justin Brodigan, who was Jared's brother, came to the police station. He had stated that he had also left the Church of Latter-day Saints, and when Ms. Gardner had found that out, she reached out to him and stated that she wanted to get the cousins together, and so they ended up going over to Mr. Brodigan's home, and where they're letting the kids play. During that time period, Ms. Gardner made the statement to Justin that she at times was so angry with Jared that she considered hiring a hitman to take him out.
Did he believe her to be joking? Did he say whether she said this in a joking manner?
He indicated that he thought that she was being very serious. However, due to the fact that they were divorced, and it was made in the past tense context, that wasn't something that he needed to alert the police, but he did believe her to be very serious about it.
And other than M and H and all these other individuals, did anybody come forward to you and say that Ms. Gardner attempted to solicit them to actually act as a hitman for Jared Brodigan?
Yes, during the time of their divorce, a tattoo shop owner had come forward by the name of Brad Bird. He stated that he had spent a lot of time with Miss Gardner when she was getting her tattoos and some other things. And one night they had decided to go out for drinks afterwards. And during that time period, she stated that she needed someone to shut Jared up and asked him if he knew people who shut people up. He indicated that the way that he took that conversation was that she was looking for someone to murder her then husband.
And I also want to talk about an individual who came forward and provided a sworn statement to investigators regarding conversations she had with Ms. Gardner, specifically involving her husband, Mario Fernandez Saldana.
I believe the conversation happened in 2017. A friend and coworker of Ms. Gardner's had come forward and stated that this was around the time that she was just meeting Mario and they had started dating. And she stated that Shanna told her that Mario had a military background and that he could take some guys, break into Jared's house, and take care of him, and no one will ever know what happened.
Moving on to, now it's going to be State's Exhibit 10. These are text messages between Ms. Gardner and Ms. Jensen in 2021. And this is a sample, but are there multiple text messages in which Ms. Gardner expresses her discouragement with the child custody battle she's having with Jared Bradigan?
Yes, there are lots of examples, both verbally and written, where she is very unhappy sharing the kids with Mr. Bradigan.
And she uses language, not just, I want to use the court system, but I'll never be happy so long as they're involved or alive.
Correct.
And then again, this is a pretty lengthy message to Ms. Jensen from Ms. Gardner. And in this, she expresses that she can't bear the thought of 9 more years of fighting for custody of her children. And this is again State's Exhibit 10. So once you got this phone download from Ms. Jensen, before receiving these messages, had you spoken with Ms. Jensen about her knowledge of Shanna Gardner's involvement in the death of Jared Bradigan?
Yes, she came to the police station and we did interview her.
Did she mention any of this information when she spoke to you at the police station?
Not at all.
Did you serve her or assist in serving her with a subpoena to testify in front of a grand jury in February of 2023?
We did.
And did she appear at the grand jury and give testimony?
She did.
When you gave her that subpoena, were you also monitoring Ms. Jensen's toll records and calls?
Yes, we were.
And when she got the subpoena for grand jury, did she contact Ms. Gardner?
She did.
And actually, when she was at the grand jury, was Ms. Gardner calling her?
Yes, she was.
And what has Ms. Jensen told you about her relationship with Ms. Gardner, up and through the murder?
She stated that they were very good friends, best friends, and that basically that Ms. Jensen is kind of Shanna's like confidant.
And what does she express about her view of the Jared Bradigan versus Shanna Gardner history?
She is Team Shanna, according to her wording. She was not a fan of Jared Bradigan, and she has a lot of admiration for Ms. Gardner.
Okay. And she described herself as Team Shanna even after Jared's homicide and even after she was brought in to give testimony in grand jury and on other occasions involving Ms. Gardner's potential involvement.
That's correct.
Eventually, were you present when Ms. Jensen was interviewed in July into August 2023?
I was.
And at that point, you had all these text messages that she had not disclosed to you.
That's correct.
And when you spoke to Ms. Jensen, with this evidence available, did Ms. Jensen give further testimony about Shanna Gardner's involvement in the planning and the homicide of Jared Bradigan?
She did.
I'm going to go through some of those statements. What did she tell you about her conversations specifically with Mario Fernandez Aldana about killing Jared Bardigan?
She relayed that there were instances where he was so close that he could touch him, and Jared didn't know it.
And just to be clear, Ms. Jensen said that Shanna disclosed to her things that Shanna Gardner and Mario Fernandez spoke about.
Correct.
Did she say that they had several conversations, one conversation?
There were multiple conversations over a multi-year period about Mario killing or finding people who could kill Jared.
Okay. And now we'll get into the specific statements. What did Ms. Jensen say Ms. Gardner disclosed to her about Mario and her plans to kill Jared Bardigan?
She made a statement about him, like I said, having people, there were a motorcycle gang that lived behind his house that he could get to kill Jared. That there were times where Mario was so close you could reach out and grab Jared and cause his death. And then just more ways that Mario was capable and the right person to get rid of Jared.
Did she say specifically if there was a certain time or context that Mr. Fernandez Aldana would offer to do this for Ms. Gardner?
It was typically when she would be either upset with him or when she was upset more so with something that had happened between her and Jared in regards to the children. When she would be upset about some type of custody issue or some kind of disagreement there being Mario's solution was always to offer to take care of Jared.
And did Kim Jensen tell you what Shanna took take care of, I'm using quotes, to mean?
That would be to kill Jared Bardigan.
And you mentioned that Ms. Jensen disclosed that Shanna Gardner told her Mario was so close to Jared he could touch him. Did she explain what that meant? Did he actually follow him and was so close he could touch him?
Yes, there were times where he would watch his movements or, like I said, follow him and try to, develop patterns of what he did and where he went and what would be the best way to carry out some type of plan.
Did he call these, did he use any phrasing to describe these moments where he could have done something to Jared Bardigan?
Missed opportunities.
Here's some of the statements we talked about. Did Mario also disclose, or did Ms. Gardner disclose to Ms. Jensen that Mario Fernandez Aldana had followed him in a vehicle on a prior occasion?
Yes, that he had followed him from the house back to St. John's County.
And what about to the hospital?
Don't recall that one.
Okay. Did Ms. Gardner disclose to Ms. Jensen why there was a delay or some kind of reason that
There was a delay in killing Jared, and that was Mario's excuse was, well, it's during COVID, no one leaves their house during COVID, so therefore I can't get a hold of him if he never leaves his house.
during this meeting with Ms. Jensen, did she advise you about Shanna Gardner's knowledge of Henry Tennant?
She did. She stated that she had met Mr. Tennant and that she knew that he owned the truck that we had released to the media that we were looking for.
And to be specific, Ms. Jensen told you that she had conversations with Shanna Gardner about Henry Tennant. Were those conversations before or after Henry Tennant was charged with the murder of Jared Bardigan?
Those were before.
So before Henry Tennant was publicly named as the individual involved in the murder of Jared Bardigan, Shanna Gardner and Kim Jensen had discussions about him.
That's correct.
And they had discussions about him owning a truck.
Owning the truck. On surveillance video that we found the night of the homicide, we had identified a vehicle of interest that we believe was involved in the homicide, and that was in fact later proved to be the truck that Mr. Tennant owned.
And Ms. Jensen disclosed to you that Shanna Gardner had discussed this vehicle with her prior to Henry Tennant being arrested for murder, or knowledge that that truck belonged to him being public.
Correct.
I want to talk lastly regarding Ms. Jensen's disclosures at this meeting about what she told you about a trip to Hawaii. The Gardner family, can you describe for the court this annual kind of vacation that they were doing to Hawaii?
They have an annual family trip where they all go to Hawaii, and would appear to include all of the parents, all the children, and then their spouses and grandchildren.
And was there a trip to Hawaii in 2022 prior to the murder of Jared Bradigan?
There was a trip to Hawaii approximately a week before the murder.
And did Shanna Gardner and Mario Fernandez Saldana go on that trip to Hawaii?
They did.
And did they return approximately,
About 4 days before the murder.
so around February 12th, 2022?
Correct.
And did Ms. Jensen describe for you a conversation that Shanna Gardner told her she had with Mario Fernandez Saldana in the week before Jared was killed?
The text messages between the two of them would indicate that their conversation had to do with the fact that Shanna was frustrated with the marriage and that she was going to call it off with him, and that they had discussed that and that they were starting plans to do that. However, later she indicated that during that time frame, Mario stated to Shanna that Mario was going to in fact kill Jared, and that if she didn't want it to happen, she needed to speak up and say it now.
Ms. Jensen told you this, and obviously you had the testimony from Henry Tennant, that Mario Fernandez came to him the day or day of the homicide on October 16th, saying he needed to do this now to save his marriage.
Correct.
Oh my God.
Ms. Gardner never mentioned any of this information to you when she sat down with you on April 15, 2022.
No.
Is this information that would have been of interest to you as the investigator into the murder of Jared Bradigan?
Absolutely.
And it said she actually gave you other theories that could send you down a wild goose chase. And I anticipate that when you're cross-examined, or when defense makes argument, that there will be some indication that Ms. Gardner said no or didn't really know Mario was serious about doing this. So I want to talk to you about her actions and some of your investigation into her actions following the death of Jared Bradigan. So start with the interviews you did with Mr. Fernandez Saldana and Ms. Gardner in March and April of 2022. Did you also do recorded interviews with Ms. Gardner's children, biological children with Jared Bradigan, whom I'm going to refer to as LB and AB?
We did not specifically do those interviews. However, the child protection team at the University of Florida did.
Okay. And I know the court's familiar, but can you explain why it is that you all send children to the child protection team instead of doing interviews yourself?
We generally do not interview anyone under the age of 13. We would send them to a team that includes child psychologists or other trained individuals in a non-threatening, non-traumatic environment to conduct these interviews.
And did AB and LB come to the child protection team and give a recorded forensic interview with the child experts?
Yes, they did.
Do you recall around the date of those interviews?
It would have been a day or two after my initial interview with Shanna.
So sometime in early March of 2022.
Correct.
During the interviews with LB and AB, you obviously got an accounting from them of where everyone was in the home that night. Did you note discrepancies between their interviews and what Ms. Gardner and Mr. Fernandez Saldana had told you?
They both, Ms. Gardner and Mr. Fernandez stated that he was sleeping due to having a bad headache and taking some medication. Both of the kids indicated that they thought that Mario was in his gaming room. But they later stated that they never actually saw him. It was just that his game console was actively playing, so they just assumed that that's where he was at.
And Henry Tennant advised you in his sworn statement that Mario Fernandez actually was not at home playing video games or lying on the couch. He was driving the vehicle to the homicide scene to commit this murder.
That's correct.
So these children are brought to CPT to give this interview. Did Ms. Gardner accompany them?
Yes, she did.
Did Mr. Fernandez Saldana accompany them?
No, in fact, during one of the interviews, one of the children made a utterance that Mario was on his way to Canada with some friends to go camping.
Okay. And did you later get records, financial, call detail records, cell site location data to figure out if that was true or not?
We did. We got his financial records and we got his cell site data that showed that he essentially was making his way from Jacksonville to Brunswick, North Carolina, and up to Pennsylvania.
Did he go camping?
He did not go camping.
Was, based on your investigation, can you describe for the court what the nature of this trip was? Was it pre-planned, vacation, business?
I couldn't tell you what the nature of this trip was, other than the fact that he made surprise visits to some people that he barely knew, and he purchased toiletries on the way. Once he got past North Carolina and up into Pennsylvania, he was making hotel reservations as he was driving. So I would say it was not a planned trip.
And while he's making this unplanned trip up to Canada, presumably, was he in contact with Ms. Gardner by phone?
Yes, he was.
And at some point, did he cease contact with Ms. Gardner?
He was in contact with her essentially until the CPT interviews were done, and then he essentially turned around and came back home.
Moving to August of 2022.
Well, that's not suspicious at all. Not a bit. What is going on with my... Why is my computer doing that? Why? How come? What's happening?
This was a key point in your investigation. Is that fair to say?
Yes.
What happened August 18, 2022?
Mr. Tennant was arrested.
And up until that point, Henry Tennant was not on anyone's radar, so to speak, until probably when?
I would say maybe a few months prior to him being arrested.
And in your investigation, what was the relationship you uncovered of Henry Tennant to Mario Fernandez Saldana and Shannon Gardner?
He lived in one of their rental properties.
And who was the owner or manager of those rental properties?
I'm not sure legally if it was Mario Fernandez or their LLC, but one of the two.
And were you able to identify Henry Tennant as a person of interest in the murder of Eric Cardigan?
Yes.
Once you did that, did you, in conjunction with the Jacksonville Sheriff's Office, arrest Henry Tennant on unrelated charges?
Yes. We essentially formed a plan where we would arrest him once he started driving. He's a habitual traffic offender, and that plan was executed. He was taken into custody.
I don't think people at large understand. Is this like a common technique that...
I need tech help. I need tech help. I don't know what I've done. Oh my God. When I scroll with my mouse, it's not scrolling. It's changing the size of everything. Now, the window where my face is huge, and my chat is itty bitty way over here, and I can't see it. Now, my chat is huge, and my face is itty bitty way over here. Help! I don't know how to fix it. Somebody please help me. I'm not a boomer. I swear I'm not. I'm a Gen X. I'm not a boomer. Please help.
law enforcement does when they're investigating a crime?
Yes, it is.
Does it provide the opportunity to interview somebody who's a potential subject or person of interest?
It does.
Does it present the opportunity to obtain leads and further evidence into that person?
Yes.
So when you arrested Henry Tennant on April 18, 2022, had his name been publicly released anywhere as a person of interest?
Not at all, no.
August 18, 2022. Had you spoken to Mario Fernandez Saldana or to Shanna Gardner about this person, or asked them any questions or interviewed them about Henry Tennant?
None.
When Henry Tennant was arrested, was he still living at that home that was run, so to speak, by the First Choice Home Rentals LLC?
Yes, he was.
When he was arrested, what did your investigation uncover about the activity between Mario Fernandez Saldana and Shanna Gardner when their tenant was arrested on a driving charge?
Right after he was arrested, the other gentleman that was living there used an associate's phone as to not be detected to call Mr. Fernandez.
And how do you know that?
He admitted to doing that.
He told you he used someone else's phone to contact Mario Fernandez Saldana to tell him Henry Tennant was arrested.
That's correct.
Okay. What did Mario Fernandez Saldana do?
This started a flurry of calls between Ms. Gardner and Mr. Fernandez. And then Ms. Gardner then reached out to her attorney as well as her PR firm.
Okay. And I have here, is this a timeline of relevant calls for purposes of this hearing for that date, August 18, 2022?
That's correct.
MF means Mario Fernandez. Okay. It says here that Ms. Gardner was speaking with someone named Christopher Thomas of the Intrepid Group and someone named Linda Lucetti. Do you know who these individuals are?
I do.
And who are they?
Christopher Thomas is the owner or president of the Intrepid Group, and Linda Lucetti is a media relations consultant that often works with Mr. Thomas.
In the course of your investigation, did you identify these individuals as having been retained by Ms. Gardner during the course of this investigation to sort of help her with her PR?
Yes, that's correct.
And Intrepid Group and Linda Lucetti, are they based out of Salt Lake City, Utah?
That's correct.
And do they have some affiliation with Ms. Gardner's mother's company?
I believe one or both of them had done some work for Stamp It Up, and they were offering their services pro bono to Ms. Gardner.
What was significant to you about this type of contact on this date?
I mean, the significance to me is your tenant, who you would likely say that you had no clue was involved in this, was arrested for, you didn't know what charges at the time, yet you felt the need to alert your attorney and media consultants that your tenant of your rental property was arrested.
For a driving unsuspended license charge?
Correct.
Did you make attempts to speak to Christopher Thomas and Linda Lucetti and other members of the Intrepid PR crisis management firm?
Myself and one of my colleagues flew to Utah in an attempt to speak with them, and they avoided us.
Can you be more specific about your attempts and their avoidance?
Well, Ms. Lucetti was running frantically around the front of her house as to hide from me so that I could see that she was in her house. Mr. Thomas was not at his office, went to his residence, and he had his wife answer the door a couple times to avoid speaking to me.
Were you eventually able to receive evidence and statements from Chris Thomas with Intrepid Group after he retained a criminal defense attorney?
Yes, as you said, you stated he hired an attorney and then contacted the state attorney's office directly.
Okay. And we'll get to the information they gave you in a moment. Moving on to states. What's been entered into evidence of States Exhibit 12. This is a text message between Ms. Jensen and Shanna Gardner on that date, August 18, 2022. Describe for the court the context of these text messages.
I believe this was like a lunch date that was coming up, and they did not want anyone to know that their tenant had been arrested at that time.
And this text is from the date that Henry Tennant was arrested.
That's correct.
State's exhibit, composite exhibit 11, are these the text messages that were turned over by Intrepid PR Group?
Yes.
Okay, and this highlighted number, does that phone number belong to the associate of the Intrepid PR Group?
Yes.
And these texts are dated August 18th and August 22nd, 2022. Was there one person who was willing to speak to you when you went to Utah?
There was.
And without using her name, can you describe who she is?
She was a junior level social media manager at the PR firm.
And she no longer worked for them when you made your trip to Utah?
That's correct.
What did she tell you about the contact between Intrepid Group and their other PR associates at the time and Ms. Gardner on this date?
As soon as Ms. Gardner found out that their tenant had been arrested, she, her words, frantically was trying to reach someone with Intrepid. She couldn't get a hold of anyone else just due to the time difference was very early in the morning. However, this social media person answered her phone and started taking down notes to give to Chris Thomas later on.
What did she say Ms. Gardner relayed to her?
That their tenant had been arrested and that tenant owned the truck that the police were looking for.
Moving further into State's composite exhibit 11, these are text messages with the Intrepid PR Group. These individuals are employees of that group, correct?
That's correct.
And this is dated August 18, 2022, the date of Henry Tennant's arrest on driving on a suspended license, habitual charges. We see here, is this green? That is Mr. Thomas, who is the lead on her case.
Correct.
Okay. And he said he spoke with Shanna. There were interesting developments in her case. And then moving on, ignore the language, but the last text message is August 24, 2022. Can you describe for the court what your investigation uncovered as to Mr. Thomas's knowledge regarding the charges?
Just that they weren't sure what the charges were, but it seemed to be unrelated to the truck or anything to do with Jared.
And again, at the time these messages are being sent, nobody other than the people who hired Henry Tennant would know of his existence as a link to the murder of Jared Brighton.
Correct.
Other than Jackson's police. In the court's binder of exhibits, State's Exhibit 13 is a business record showing the authenticity of Apple records received. Did you receive evidence related to an iCloud belonging to Shanna Gardner?
Yes.
And in particular, were you looking for evidence in that cloud relevant to a Ring camera that Ms. Gardner and Mr. Fernandez-Saldana had on the front of their house?
Yes, the Ring camera was located outside their front door. The day after detectives went and notified them of Mr. Brighton's death, they asked to see if their Ring camera had picked up anyone who might have passed by the residence. Ms. Gardner showed the ring to the detective, and there were no recordings past the 16th.
When you received the iCloud return, was or was not there?
On the iCloud were recordings from the Ring camera that we could also tell basically that the camera's settings were to constantly record. There were videos on the iCloud that showed both vehicles passing by their residence as well as customers coming to pick up orders or Mr. Fernandez putting an order outside their door. These were all things that would have been picked up by the Ring camera. However, on the night of the homicide, there was no activity on the Ring camera, at least in the app. indicating that it was likely that the information was either deleted or the camera was set to not record.
And you know that because what did AB and LB told you, or what did they tell you about how they entered the house that night, the night of the homicide?
They indicated that they would typically go through the garage. However, the garage door was closed, so they used the keypad on the front door, which would have been captured on the ring camera.
So based on what they told you, did you expect to see at least, at minimum, a ring footage video of AB and LB entering the home minutes before Jared Bardigan was killed on the night of the homicide?
Based upon the past history that was located on the iCloud, we expected to find them entering the residence as well as Jared's vehicle passing by the camera.
And there was no footage of those events?
That's correct.
And in fact, on this text message on August 22nd, 2022, which is around the same time period Ms. Gardner was speaking to her PR firm about potential charges against Henry Tennant, she and Kim Jensen have a discussion.
Sent a subpoena to Ring, which they were nice enough to forward to Mr. Fernandez and Ms. Gardner.
Okay, so Ring was not supposed to do that, I'm presuming?
No.
And so she is discussing, in this particular time in the investigation, which is significant to you, she and Ms. Jensen are discussing that Ring subpoena, and if they have it, if they've given the video.
Correct. In fact, it was actually a search warrant. It wasn't a subpoena. They referred to it as a subpoena.
And then State's Exhibit 14, this is a text with Ms. Jensen also regarding the cloud. And can you describe for the court what the significance of these texts are? This is September 2022.
This is Ms. Jensen basically asking Shanna, or talking to Shanna about whether or not she still has her old additional cell phone. And then they were basically stating that without her creating a new cloud ID, all of her data would just essentially be backed up to the secondary cell phone, which would defeat the purpose of having a second phone.
And Ms. Jensen makes a comment, I was thinking about that damn cloud.
Correct.
When you received, most of the evidence that we've discussed in this hearing came from the cell phone of Kim Jensen.
That's correct.
Did you do examinations of cell phones, devices, clouds, returns for Shanna Gardner?
Yes, we did. We did cell phone downloads as well as Google and iCloud search warrants.
In the returns of those items, devices, and returns, did you find the same conversations that you had found on Ms. Jensen's phone?
Some of the conversations were there, but a lot of the conversations were not.
So like the Ring cloud, or I'm sorry, the cloud of the Ring footage, you were expecting to see evidence that was not present on Ms. Gardner's devices?
That's correct.
Henry Tennant was eventually arrested and charged with the murder of Jared Bardigan.
That's correct.
And do you recall the date on which that occurred, or the time period on which that occurred?
Early January 2023.
Leading up to the arrest of Henry Tennant, were there investigative techniques being pursued by the Jacksonville Beach Police Department?
Yes. During the time that we knew we were going to announce the charges against Tennant, we had also received a court order for a wire intercept.
And a wire intercept to intercept phone, text, and audio communications between Ms. Gardner, Mr. Fernandez Saldana, and other individuals of interest.
That's correct.
And that court order was you did an application and a judge granted that.
That's correct.
In order to get chatter generated, what did you all decide to do to what the phrase being trigger communications?
We decided to go ahead and have the wire in place before the charges were announced against Mr. Tennant. We did that, and then we made the announcement about the arrest or the additional charges that have been added.
And before you made the announcement about Henry Tennant's arrest, did you purposely leak information to the media that a break or an arrest was imminent?
Yes.
And did the media run with that information?
Yes.
Okay. Did you say who was going to be arrested?
No.
So the information was just that an arrest or big break was coming.
That's correct.
And Your Honor, the state has moved into evidence 15, 16, and 17, which are wired recording calls of Ms. Gardner from the wiretap. For time's sake, I'm not going to play the entire calls. I'm just have the detective testify to the relevant portions. Beginning with call 170, which is State's Exhibit 15, what was one of the first calls that Shanna Gardner made after this leak was out and being publicized?
She was speaking with Ms. Jensen, wondering if she should give Mario a heads up about the information that she received.
And do you remember specifically in greater detail kind of how it was that she learned of the leak and what her reaction was?
I actually don't remember how she learned of the leak.
Did she describe to Ms. Jensen how she was going to give Mario a heads up or a warning that a big break was coming?
She talked about actually using her neighbor's phone in order to call Mario to give him information about it.
And that neighbor would be Marla Rogers?
That's correct.
During the entirety of the wiretap, was this a common theme that Ms. Gardner and Ms. Jensen discussed that their phones might be monitored?
Yes, that's correct. She made statements about the fact that she was warned that her phone was likely tapped.
And that was January 23rd. We're going to move on to a few days later when the arrest of Henry Tenen as the person responsible for the death of Jared Brightigan, at least responsible for the actual pulling of the trigger, is released. I want to discuss a phone call that Ms. Gardner made to her public relations firm on 1/25/2023. And I've included a portion of the transcript that the monitor used here. Can you describe for the court what was significant to you about this conversation?
She said that she admitted to knowing Henry, that she had met him approximately 5 years ago, but there should be no paperwork tying him to the rental property.
At the time that she made this call, the media, did a good job. They covered this fairly quickly, but at the time she made this call, had the media yet reported that Henry Tenen was linked to Mario Fernandez Saldana?
No.
At the time she made this call, had the media reported that Henry Tenen was a tenant to Mario Fernandez Saldana and Shanna Gardner's LLC?
No.
So in this call, she's telling them that Henry Tenen, the person under arrest, is in fact a tenant, but there's no paperwork or payments attaching him.
Correct.
What was the reaction of the individuals with Intrepid PR Group?
Their initial reaction was, well, that must have been a long time ago, right? Like you didn't, this was not a recent payment or anything like that. However, Ms. Gardner went on to tell them, in fact, that they had given him money earlier in the year. At that point, they basically told her that they should probably stop communicating about this.
So she advised the public relations firm that she and Mario Fernandez Saldana had paid Henry Tenen money for a pallet business within the past year.
Correct.
And discuss a call also made that day. I have the time notated wrong in here. It was at 17:27 on 1/25/23 between Ms. Gardner and Ms. Jensen. And was there another call in which she discussed Henry Tenen and monetary payment she made with Ms. Jensen?
Yeah, was essentially about whether they were was Tenen going to use the information against them to garner a better deal or throw them under the bus or twist them as being involved in this.
Throughout the course of the wiretap, Ms. Gardner, and here again they're referencing that she might reactivate her other one. Were there discussion amongst them about using other devices, platforms, phones, etc. to contact each other?
Ms. Gardner and Ms. Jensen would frequently talk about whether they could use FaceTime or other applications that were encrypted to communicate so that they could not be intercepted by law enforcement.
Not to give away state secrets, but can you evade law enforcement interception by using other platforms and devices?
Yes, you can.
The last thing I want to talk about is some of Ms. Gardner's activities following the arrest of Mario Fernandez Saldana, which came in March of 2023 after Henry Tenen gave testimony against him. Was Miss Gardner living in Florida during the wiretap?
Yes. Or no, excuse me, she was in Washington State.
And how did you find out that Miss Gardner had moved from Jacksonville, Florida to Washington State?
U.S. Postal Inspector.
After Mario Fernandez Saldana was arrested for the murder of Jared Brightigan, conspiracy and solicitation and child abuse, did Miss Gardner remain in Washington State?
No, there was a 5-month period where she was not with her children and she was moving around,
And how did you determine that?
mostly through cell site records.
Where did you determine that she was living?
Appears she had rented an Airbnb in Tallahassee for a while, and then at some point had moved on to Savannah.
And during this time, she was using a secondary phone or a different phone number than the one you had associated to her?
That's correct. She had activated, the day that she flew from Washington to Tallahassee, she had reactivated her quote-unquote burner phone.
And you say quote-unquote burner phone. Where did that quote come from?
When officers went to Washington to serve a search warrant, one of her children asked if we were looking for mommy's burner phone.
Detective Johns, obviously Ms. Gardner did have several phones and phone numbers during the time period of investigation prior to her arrest. And your team effectuated arrest on her in August of 2023 in West Richland, Washington.
That's correct.
Why did you all make the decision to effectuate an arrest on her rather than allowing her to turn herself in?
We wanted to make sure that she did not attempt to flee. Parents have considerable assets, and it would be very easy, given her geographic position, to get on a private jet and fly away.
When you did research into the financials of her home in West Richland, Washington, who bought that home and who paid for it?
It was purchased by an LLC that is owned by her parents.
Detective Johns, I have one more, Aaron.
Yes.
Detective Johns, I'm winding down. I just want to summarize the main points of your testimony that I think are important for the court to consider. One being, where did the money that was paid to Henry Tennant to kill Jared Brightigan come from?
The money came from the trust that was established by Mr. and Mrs. Gardner.
And was that trust held in the name of Shanna Gardner?
No. Well, it was, the trust itself was named the Shanna Gardner Irrevocable Trust, yes.
And the funds from the Shanna Gardner Revocable Trust that paid Henry Tennant were moved from the trust into First Choice Home Rentals LLC.
That's correct.
And the owners of the LLC are whom?
The owners of the LLC are Shanna Gardner and Mario Fernandez.
And Detective Johns, of your entire investigation, was there anybody else that you uncovered with a motive of such depth and breadth as that of Miss Gardner to have Jared Brightigan killed?
No.
And in your investigation, you obviously uncovered all these trail of individuals and text messages in which Miss Gardner incited, encouraged, solicited, and asked other individuals to help find someone, procure someone to do this task.
Yes.
And Ms. Gardner, again, never mentioned any of this information to you when you interviewed her as a witness looking for helpful information in this case.
That's correct. You never mentioned anything.
And she never came forward, even over time, as all of these other events unfolded, including Mario's Fernandez Saldana's unexplained trip up north, the arrest of Henry Tennant, her move to Washington, or her moves to Tallahassee and Savannah.
Correct.
Why did that pop up? Oh, what happened?
We had several people come forward who shared stories that they had heard over the years that you share custody with him.
I guess it's done. It didn't seem like it was done, did it? Well, that sucks. Okay, I guess that's over. Let's see, what else can we watch? Except StreamYard's all screwed up now. The screen where I watch what you guys see in the middle is huge. And the chat is in teeny, teeny, tiny font, and I can't see a darn thing. And then my controls at the bottom are itty bitty. And the only reason why I can use them is because I know where they are and what they mean. Because I have them memorized. But I can scroll again. Good gravy, Marie. But all of my font. But I noticed that before the scrolling got screwed up, that all my font is smaller. Like even my thumbnails on YouTube is smaller now. Oh, I see why you asked me if I was close to Boca Raton. Why don't I have sound? My sound is on. What is going on with my computer today? I got a new keyboard, y'all. I think, and I've got a bunch of stuff on my desk, and I'm trying to diamond paint instead of crochet today. I don't know what's happening. If I mute it on this stupid new keyboard, it's a light up keyboard. Because my other keyboard that I had was not backlit. But the problem is the font on the keys is white and you can't see it unless it's night and it's backlit. So I can't ever see anything during the day. Did I turn off the sound? Good God. Hang on, I'm going to reload StreamYard and see if that fixes anything. Y'all, I'm going to have a conniption in a minute. I can't even see how many people I still have. Oh my God, 4 people are still watching this train wreck? I have no sound. Is it a plane crash or a... Yep, a small plane crashes in Boca Raton. I have no sound. My StreamYard is so... My video whatever window is so large I can't read my chat. And no sound. I had sound a minute ago, but I don't have sound now. I hope my microphone works. Oh, I turned up the sound and I heard the little ding. So it's not the computer. Is it just YouTube that has sound? It had sound a minute ago. There's a Taylor Swift lawsuit? Good. Oh. It might not be anything. Some woman in Florida is suing her. Oh, it's the second time she sued her for copyright infringement. I feel like I'm deaf right now. How does RA find all the live feeds of the judges? Oh, I found it, but it says private. Oh, well, I see one person. And again, I have no sound. Where did my sound go? How did I flub up my computer so bad? What did I do? I don't know what I did. I sound there. If I can. We'll do more Tim Hawkins.
down. I'm going to do a new song. And if you get it, you just get it. Well, I don't know if we really landed people on the moon. I'm not sure if Lady Gaga uses auto-tune. And I'm uncertain there'll be peace over in the Middle East. But I just think it's true. And I do know we'll be stopping at Buckhands all at once. I've been driving these wide open spaces. Now I need a redneck oasis. Take my money, bucket, baby. It's my lucky day. I could try a little forks. There was a positive encouragement painted on a log. A large banana pudding, a Cali chicken wrap, a coffee for the journey, a Bucky Beaver cap. What's up, West Virginia? Stopping at Bucky's is my ritual. Stomach's growling, my gas tank's empty, and my bladder's full. I've been hanging with the unwashed masses, Bible verses on shot glasses. Take my money, bucket, baby, cinnamon roll. Homemade gravy, take my money, bucket, honey, it's my lucky day.
I've never been to Buc-ee's. There's a new one in South Florida somewhere. I forgot where. And they have a water park. Yeah, I doubt Taylor cares to. She's got enough money. She'll probably settle out of court. I don't know, though. I think celebrities don't want to encourage that. Because when they settle out of court, it encourages people to sue them. Because then they're like, oh, they'll settle out of court and I'll get some money. I've never been to Buc-ee's. I don't know what the big deal is. I guess if I go, I'll figure it out. There's one over in Daytona, I think. And I think there's a newer one. I don't know if it's new now, but a newer one. There's a guy on YouTube. His name is Tampa J. And he goes around to more unusual places, like not theme parks. He goes to abandoned places, older places, unusual places, things like that. It's pretty interesting. Some of his videos are really interesting. And so they went to the new Buc-ee's whenever it was brand new, like the grand opening or whatever, and went to the indoor water park that they have. And Travis loves water parks. So we want to go. But I've never been to Buc-ee's. My cousin lives in Vero Beach, and they drive all the way to Daytona just to go to Buc-ee's. I'm like, what is Buc-ee's? Like, oh, it's like a truck stop, gas station, convenience store thing. I'm like, why would you drive all the way from Vero Beach to Daytona to go to someplace like that? It's wonderful. I'm like, okay, whatever you say. They have the best pulled pork sandwiches I've ever had in my life. All right. You'll have to meet us over there one day when we go. I'm like, okay. Still nothing. They are fighting in the chat on Law and Crime. They are fighting. The chat is split. But when they did the poll is not up anymore. But the poll, it was only like 10% not guilty. It was 10% not guilty, 82%. And I'm bad at math. So I might not have remembered it right. I should have written it down. 82% guilty, 10% not. What does that leave for hung? I don't know. I'm going to quit doing math. There is one in South. I know you're not all the way south, but I don't think the Buc-ee's was all the way south. I don't remember where the new Buc-ee's is. There's another Shanna Garden. That hearing, didn't sound to me like it was over. And like I said, I've got the whole thing recorded, but the sound sucks. I don't know. Bill told me if I recorded it, then played it StreamYard would be better because it wouldn't be as taxing, because it wouldn't be trying to stream something and then uploading it again, which I understand that, but I don't know how to do the sound part, because what happens is, which I didn't realize until I went to pause it the other day, and it paused the sound. It's coming through my speakers and then through my mic to get back to you guys. So the sound sucks when I do that. So I don't know how to do the sound if I download it. So it's better if I play it through YouTube. I don't know what to. I'm new at this, y'all, so I don't know what to do. Let me see. What is First Coast News? What is? Wait, it's to. No, wait, it's to. Today's Friday. Is it this Friday? Oh, 1 week ago. Last Friday, they had a case management hearing. Court TV. Microsoft exact murder. Shanna Gardner extradition. Blah, blah, blah. I can't even talk today. Today's a bad day. Like I said, it feels like it's a Monday. It says that her trial is supposed to start October 20th. Okay, she was denied bond. What is First Court? Gosh, why can't I say that? First Coast News. Because they have a YouTube channel. I don't know if I can stream from there. Is that... Oh, good Lord. If it's close to Vero, my cousin's going to be there all the time. We got to find something to watch. Well, I guess I'll find out if I'm allowed to stream it. What's the worst they can do? I'm not monetized yet, so. Oh, there's her second husband. She went from that good-looking guy to that.
So we're here on several motions and also a case management hearing, and I'm interested in y'all's thoughts, but what I thought we could do is, I think it would help in some of the motions that the defense has filed, is to give me understanding of where we're at as far as the discovery, what you all have.
Judge,
Unless there's something that's come up since the time of the filings.
Judge, it's our position on behalf of Ms. Gardner, based on the letter sent by Mr. Khalil, that we are at an all-stop.
A letter.
Yes, it was enclosed to Ms. Day's motion that she filed.
The one about the reorganization?
Microphone.
That we are at an all-stop, Judge. We have made several requests for things that we believe are outstanding. We were supposed to have a deposition
Of
we thought,
the detective?
Johns, to sort of go over, like.
Why don't, hold on, okay. Let's, why don't y'all have a seat, okay? Mr. Khalil, you can be seated. We're gonna settle down. I need to use a microphone. What is the state's proposal?
Your Honor, after discussion.
You can use them, get him a desk microphone. Okay.
Please use the
Your
microphone.
Honor, after discussions with council and then the state's team, we decided that it would be best that we reorganize. There seemed to have been some confusion as to what exhibits have been tendered, what has been tendered in what format. And so the letter that we sent to council was notifying them of our intent to assist the best that we can. We are going to index the discovery that has been previously tendered in all of the prior discovery pleadings so that everybody would be working off the same sheet of music. That when we were referring to a particular exhibit and a file and the file size and everything, that everybody would have the same understanding. That we are in the process of going through and completing that indexing. My proposal, because I had done it in previous cases where we've had voluminous discovery, is to then provide hard drives with the index and all the materials in the format that are discussed in the index to both councils, and then also file an exhibit with the court. So even the court, when we're arguing motion hearings, would have the same index and have the same materials that would be available for discussions during the course of the motions. It was our understanding after offline and off-record communications with council that this would be of assistance to everybody. The other requests that we had made, because Ms. Stifler was getting requests from multiple parties from both defendants' teams, and then also even receiving communications from defense experts about formats that are being received and things of that nature, that we figured it would be better to create, one, an email box. There was an error in the creation of it, but we've now cured that error. An email box for communications, and then also points of contact, so that we were going through, we weren't responding to multiple people on multiple sides, so that we would bring some sense of order the best we could. Everybody understands that this is voluminous discovery. This was a suggestion and a proposal that we thought would be the best way to sort of try to bring some organization to it, and we're working towards that effort to do that. And we felt that after discussions with council, would be beneficial to both teams, to the state and to the court moving forward, so that everybody was a little bit more organized. This is obviously a very discovery intensive case.
Was that the defense proposal? You can be seated.
No, Your Honor.
Use the microphone.
No, Your Honor. Well, in fact, the first time I heard about it was when Mr. Khalil called me to told me that that's the way that they were moving forward. From Ms. Gardner's position, it was not. We have concerns. We have spent hundreds of hours going through what's been turned over, and we have complained about both the organization of the discovery, the file titling of the discovery, the duplicative disclosures, the vagueness in the discovery exhibits, and now seemingly we are going to have to go through every single thing again to make sure that what the state now proposes is the version we will use for trial is exactly what we've already reviewed. And there is no way for us to do that without opening up each file and confirming things like the page numbers match, that they are the same files. I mean, Judge, we don't know what we don't have, and we've voiced that several times. We've gotten different files that appear to be the same that are not. And under the law, we have a right to have the discovery, but the manner has been so disorganized with a lack of clarity, as was even pointed out at the last status conference, and what they are turning over, that we're frustrated, Judge. Frankly, we're frustrated. I mean, this is going to delay the trial. There's no other way about it.
That's October.
Increase the man hours that our defense teams, which are privately retained, have to expend just to make sure We know what we have. And it's, the word I would use is frustrating, Judge. It's simply frustrating.
You said
And I see
duplicative.
Ms. Day, you are the contact person for Fernandez, correct? And you're the one that's been going through the discovery, correct?
Yes, Your Honor, and I would echo everything Mr. Carodi just said.
Are you using the microphone?
I
For the benefit of Zoom, you have to use the microphone.
think so.
Okay.
Maybe. The only thing I would add is we've tried this before. Both our firm and Mr. Carodi's firm have previously been provided externals that we were told contained everything that the state had. We have meticulously reviewed the externals, provided list of things that were missing, and then we were told next point was coming, everything would be on next point, and all will be well and good. We got next point, within 2 weeks it was shut down. Then we went back to the externals. Once again, we're told everything will be on there, all will be well and good, just be patient. We get the externals, we do the exact same thing all over again. Then we're told evidence.com will fix everything, just be patient, we'll upload it. Once again, we review thousands of documents, and we're still requesting the same missing discovery that we've been missing since last May.
Mr. Khalil, I know that you are like maybe coming in and offering this as a solution. Sitting in the same position, I just don't think it is. I really just don't think it is. So I have printed off, and when I printed off all the state's disclosures, okay, I've printed off the specific demands. I have tried to so I could try to get some type of understanding, lining it up, and it just doesn't. And the same thing that the defense is saying has been the same thing that this has been communicated with the court. I believe the parties can correct me if I'm wrong. I tried to conduct a case management hearing, maybe, y'all correct me, like around December-ish, okay? Right before kind of holiday break. And I was told something similar, that hard drives would come in, and I don't necessarily think a hard drive will fix this problem, because I think we're on hard drive number 3, we're on cloud service number 2, and y'all can correct me. I think the defense is objecting to evidence.com because something was inadvertently uploaded yet again.
There's an evidence.com?
Ms. Gardner's devices were uploaded.
Ms. Day informed me that she obtained an unredacted copy of one of Ms. Gardner's cell phones that contains attorney-client communications.
It's not going to fix it. So, to facilitate what did y'all do with the hard drives that have previously been given to you? You're just keeping them, and you're comparing the two?
Judge, it is so voluminous that most of the stuff we have gotten onto our own cloud service, but that's no more than a file share service. And that is at least what Ms. Gardner has done, so that we can share it amongst our team, but we...
So you're taking the hard drive that the state has given you and you're uploading it to your own file share service, so you have now 2 separate kind of electronic...
We have hard drives, and then we have working copies, I would say, on the cloud that people can access and review.
Okay. And forgive me, y'all have to be patient with me, because I don't know / I'm trying to get some type of understanding, okay? So on the hard drive, and I'm gleaning this from a complete like overview of like what y'all are disclosure, all right? So on to what is in writing by the state.
So, and Ms. Day may be better situated to answer.
Well, I'll let her.
Yeah, but
I'll let her take the lead because she's, let Ms. Day.
yes.
Your Honor, the short answer is it doesn't.
At all?
No. And I have my external, and I'm happy to provide it for the court's review if the court would like.
Which one?
I have our firm's external, but I have a folder on the external in which I've saved everyevidence.com as it was received.
Okay, so let's start with the first one, okay?
And when you say first one, Judge?
The first disclosure, there's one that was filed on November 15th.
In Ms.
2023. It has both defendants. This is when the joint indictment at or around that time. So if y'all pull it up, November 15th. So on that particular exhibit, I counted 85 witnesses, category A. Then it is referenced like the different subparagraphs, right? And then there is a Brady disclosure on that particular document. And to my knowledge, while it was written by Mr. Tassoni that the sixth supplement had Brady information in it, but it was not disclosed Brady, right? The sixth supplement. It was just the notes. Are you with me? The notes from Mr. Chipperfield, but it was not disclosed under a Brady paragraph. But the defense.
That was just the transcript, Judge. The notes came. I may be confused fifth or sixth, but the first disclosure regarding 10 was just.
No. I'm on the sixth where they give over
Yes,
Chipperfield's.
I understand. Yes, Judge.
Okay, but it was not identified as Brady.
Yeah. Yes, Judge.
It was just notes.
Yes, Judge.
But what I'm referring to is the writing by Mr. Tassoni, who indicates the defense position is it should have been or is Brady.
Yes, Your Honor.
Right? But there's only, what I'm asking, okay, is there's only one Brady disclosure that I'm able to see from the state of Florida, and it is contained within November 15th. Right?
Yes, Judge.
How is there any Brady material in this trial? They would not let me on this jury. I have a definite opinion.
I'm still on November 15th, but I'm comparing back. There is a writing by Mr. Tassoni that there was a reference to Tenon's jail calls in this November 15th disclosure, but I could not find it. It is the subject of Mr. Fernandez's specific discovery request. Where is it in the state's disclosure that they had Tenon's jail calls?
If I remember the disclosures correctly, I don't believe the state's discovery exhibit specifically identified any defendant's jail calls individually. I think it was just listed as jail calls.
Where?
Her microphone works.
Pull it up, Ms. Day. Or the state can pull it up. Because that's one of the things that y'all wrote that you've been asking for essentially since the beginning.
And Your Honor, which pleading are you Referring to the last pleading of Mr. Tassoni that was filed 2
Yes.
days ago. Your Honor, the state would request, we just received the pleading, and we would request time to respond in writing. I think that would assist in clarifying this. We're not prepared to address all the issues in that motion today.
Okay, I will set aside a different time. Today, I don't necessarily have to hear the motions for sanctions. Today, I can set aside that time. Today, I want to get a full understanding of what just is before y'all start coming up with solutions. And Mr. Khalil, what I'm trying to explain is that this court feels as though if I don't, and then the state then proposes another solution, okay? This is how this case has been going, okay? Which there have been issues brought to this court's attention. I have a relatively short pretrial where everyone says, we have a solution. Then I pass this case off weeks and weeks and weeks, okay? For y'all to get together, for y'all to talk, for y'all to do this. And then what comes of that is more motions, more misunderstandings, more violations of the court's orders, okay? And so my thought is, it may be like, I don't mean to be as methodical, but I've never sat down with y'all. I've never really done this on the record. Every time I ask questions, and I'll give you an example, Ms. Day, if you recall, we were at sidebar, and I thought, I believe it was at the last court date, the state thought that the defense had a searchable a device from the Secret Service. Apparently the state has the ability, with whatever format they have, that they can search, the defense can't. And then you explained to me that what you all were given is if you click on a document, it's a zip file, it takes X amount of time to unzip it, you wait 3 minutes, you wait 20 minutes, you wait 2 hours for it to unzip, and then when you get it, it's some random search on the internet that has nothing to do with anything, and it's a waste of time.
It takes us days to download and unzip the files, and oftentimes we open them and it just appears to be computer coding.
That's what's going on. So the state thinks that you're giving something usable, and it's not usable. You take issue with that, Ms. Stifler?
I think some of the issues Ms. Day has brought to my attention at least have been somewhat user error. So some of her requests that I got.
Use the microphone.
Some of these requests I've gotten in her most recent, or the letter that I've responded to. They have sent me lists via email. I have responded via email, and in the state's first supplemental demand, in an italicized portion of that demand, I responded to their list. Some of the issues she's raised to me, we've discussed at a discovery conference at our office. Some of the platforms of the information for downloads through Axon or Axiom for the computers are HTML based. So if she opens it, the report goes through a web browser. That's just how it works. That's one clarification I wanted to make. As far as the extractions we've provided to Defense Counsel, our UFDR files, which they can open through Cellbrite, they also requested the raw data, which I made available to Ms. Day to go to Secret Service and get the raw data for her client. For Bias Firm, their expert has been contacting me directly, requesting
Service.
New copies, first original copies, various formats of different data, and I've complied as best I can to give him what he needs. We have our expert, who is referenced in the letter Mr. Khalil sent, who's going to coordinate with Bias Firm expert, and if Dreiser Hill has an expert as well, to get them the digital data in the formats that they're requesting. So part of it is they're asking me, they're using terms with me like raw data, and I'm giving them what I believe they're asking for. My expert is
gathering all these things in one place on all the devices to give it to them in whatever format that they're actually requiring. So they have both the readable version through Cellbrite and the raw data itself. I don't know which one she's looking at. It sounds like she's looking at the raw data if that's how it's opening. But we've provided multiple versions in different formats for these things several times.
When you say raw data, you mean like metadata behind whatever might be, not metadata?
Not metadata.
Okay.
So when you when you do a forensic extraction on a cellular device or computer, you're copying the information on the phone and decrypting it. You have to parse that data through a software program. For example, a phone, you would use Cellbrite. For a computer information system, in a car, you would use Ivy. You would use Axiom for a computer. So when we provide that to them, we give them the reader. We would give them Cellbrite on the phone extraction so that they can pull the parsed data through Cellbrite, open it, and read it the way you would a regular phone download. Their experts and their firms have also requested the raw data. I presume, and I don't know, that their expert perhaps has some sort of forensic equipment or a physical analyzer that they want to parse the data themselves and make sure it matches up to what we've parsed. So the example that we've been given from Cellbrite is you have flour, eggs, sugar, you have cake batter, and you have a cake. We've provided them the cake, which is the finalized PDF reports. We've provided them the cake batter, which is the UFDR file, so you can run through Cellbrite. And we've provided them the ingredients, which is the raw data.
All right. How are you?
I'm going to respectfully disagree with Ms. Stifler, and I also want to point out for the court that our digital forensics expert had a flight down here on February 25th. He had confirmed the date with Ms. Stifler by email on February 10th. I have the email if the court wants to see it. Ms. Stifler indicated that she would be in trial, but someone from the state can be present. I will have Detective Ostertag reach out to Mr. Green directly, our forensics expert. Detective Ostertag never reached out. Mr. Green was prepared, and it was canceled because the state was unprepared for the meeting on February 25th that they agreed to. So, I mean, this is, and our expert has looked at what Ms. Stifler has provided via evidence.com and said, that is not what we're asking for. And so the solution was that at our expense, right, we were going to fly our expert in to meet with the state to literally look at it in person, perform whatever methods he needed to perform, and the state canceled. So I think this idea that they're doing everything they can and making sure we get everything we've asked for is not true.
Okay.
The meeting did not happen. I did not cancel it. Mr. Green canceled it because he said he had not heard from Detective Ostertag. I reached out to Detective Ostertag and Detective Johns to reach out to Mr. Green, but Mr. Green said he was just going to go ahead and cancel.
That was the day before, Judge, because no one had reached out to him. He wasn't going to get on a plane without being confirmed that he was going to be.
Mr. Green? Is that the same one from the Karen Reed trial?
No one had reached out to Mr. Green after the meeting was confirmed on February 10th. And I've got an email from Mr. Green, bringing this to the state's attention on February 24th that no one has reached out.
So the defense is saying that whatever has been provided, you cannot use it for your defense preparation. I've not looked at it
Specifically, Judge, because that's why we have an expert, but our expert has told us that is not what we want.
Mr. Green's going to be a little busy for a while.
And Your Honor, I would just add, while we have received several copies of certain devices, oftentimes the file sizes are completely different. So we have no idea if there was a download error, if there are different versions of reports or downloads. We have no confidence that the versions we have are full and complete. We're just wasting our time reviewing incomplete documents that we're going to have to completely redo.
And you're talking about from the point in time that I'm at, which is November 15, 2023. You have no confidence that these things are complete.
For instance, Mr. Tennant has several cell phones. One of them I've gotten 4 or 5 copies of, and all the reports are different sizes. Miss Jensen's cell phone, I've also gotten 5 different versions of. All of those reports are different sizes. So, and these reports, they're 100 gigabyte reports, they're massive. So to spend time reviewing all of them separately.
What is the explanation of that?
Because we provided them via evidence.com, our next point. If they're down, again, it could be on the user end. If they're downloading it and their computer's running another task, there could be skipping in the data as they download it or an interruption in the download. So I have my forensic expert. He's going to go to the original extractions, rehash all the values, provide the hash values, which is the file size for each original download that's in the possession of the custodian, the original devices, and provide that to defense. We met with him yesterday to get that completed. And Your Honor, just for the court's information, the indexing that we're describing, I have listed these items and provided them. It is not intentional on the part of the state. It is, obviously there's voluminous discovery. I've been attempting to provide them what they're missing. There's difficulty with them receiving things through cloud-based downloads or for transferring. And Ms. Day, and I'm not faulting anybody, but we have sat together multiple times and transferred things from her laptop to my laptop. Neither one of us can control the computer processing and perfection of the download.
I understand. I'm not having any hearing on sanctions. What I'm trying to get to is, so the state is proposing something, right?
Yes,
that you
re-index. I'm going to clarify one thing that Mr. Khalil said. The thought process behind the index and for defense counsel's information as well. And I spoke with Ms. Day about this. I'm not intending to re-provide them all this discovery and say start from scratch. The idea behind the indexing would be that I provide them a number for each exhibit, which would be our working number for trial for our exhibit list, so that that number stays consistent throughout the entirety of litigation up and through trial. So we're all clear what we're talking about. That number corresponds to the name and a sufficient description of that piece of evidence, and that we tag it where it is on evidence.com, what file name it's under, where they can find it, and where it's been previously disclosed in the state's supplementals and original discovery exhibit. So I just want the court to kind of understand the thought process behind the state. It's not giving them a whole new hard drive and indexing it. It's an index of what we've already provided, hopefully to be a roadmap that they can look at. Exhibit 643 is Henry Tennant's phone. It was listed in State's Exhibit 1 on page 4. It has been provided on evidence.com under subfolder subpoena search warrant returns, titled as this, audit trail showing it was downloaded by defense on this date.
Can I stop you for just a moment?
Yes, ma'am.
So in listening to what they're saying, because the state has provided multiple copies of potentially the same thing, and they're, I guess, concerned that whatever they have is not what the state has / what the state would use, how would that then solve the problem? Additionally, how would that, because from what you all have been telling me, okay, what I'm understanding is that the state has not tagged every single file / thing that they have gotten, and you've been kind of doing it via email or whatever. And then how would you document a second, fast forward, 5th version of whatever they have?
So the evidence.com has an audit trail, which is, and obviously I've sent some things via the portal, which has an electronic trail of what they've received. The responses to their emails and letters have been by email, which I asked Ms. Day in the letter she attached to her filing, or Mr. Tassone's filing. There's a letter with outstanding discovery. I asked her to number it so that I could reply via letter in numerical sequence as well, saying, say number one was the HTML issue.
You know what? If you want this woman and this man to get convicted, I would go back and I would get hard copies of every single thing and send them hard copies and make sure it was plainly marked. I don't know, but I'm old. That's just me. I would make sure they had everything in hard copy, plainly marked, because right now I'm looking at this as an old person and it's going to be a crap show. That's just my opinion, but this is going to be a mess if they don't fix this now.
I can't get this computer to open it, tries to open a web browser every time I click on it. I would respond, one, Axiom is a web-based application. It will open a file through a web browser. Item two, we are missing X subpoena. The subpoena is in the Jack's Beach Police Department Supplemental Report 5 attached. So that's how I was planning on responding to her letter. The indexing, the way that we've organized the discovery on evidence.com is in subfolders. So it's organized under a tag of subpoena. It will have subpoena and the subpoena return.
Judge, we've never seen that. It comes in similar to the screenshot that Ms. Day attached, where it's just files with a series of numbers and.
Hold on, let me get there, okay?
Yes, Judge. Like page 16 of 109 in Ms. Day's motion.
And that's what Mr. Dreiser attached about that transcript.
Yes, Judge. They're unlabeled. They're just numbers.
Is that not how it looks for the state?
It's not how it looks for me, but I cannot change the file names of these documents. Some of
Right,
these
but-
electronic documents, because that would be changing
Hold
the
on,
original name
pause
of the
for
file.
just one moment. So this screenshot, and I'm looking at 16, Exhibit C, okay? Now I'm looking at 16 and 17. So let's start at 16. It has a series of file folders, right? And then it has a bunch of like various file types and MP4, which I'm assuming is some type of audio, and then a bunch of PDFs.
Yep, and if we want to know what that is, right, we have to open it, determine what it is.
And sometimes the opening, that's what you're saying, is it a zip or unzip? Like,
We download it as a zip. We have to extract it. When we extract it, this is what it looks like. And then, for example, if I want to know what 2024-1031-105-123-104-282-212-7, I have to open that. I determine what it is. I then have to do a save as, create, if I want to remember, like if I want to find this at a later date, right? I have to do a save as, save a duplicate copy in my own files that this is the transcript of the January 13th 10 in court hearing.
okay.
Because there's no way for me to correlate this to what the state is turning over unless I open it up, review it, and save it under a different name.
Okay, pause. Now, when, so let's say, Ms. Stifler, look at page 16. On page 16, how does that look to the state of Florida on your end of evidence.com?
The files are categorized in subfiles: subpoena, search warrant,
So
interviews.
they don't have these numbers.
I'm not sure. It's the same way on the CIP when we send discovery through.
I don't know what CIP means.
It's the portal that we use in most cases through the clerk's office. So
Okay.
they sign up for e-service, we go through it. I have no control over how the specific programming titles things when they're sending them.
Okay, go back.
Yes, ma'am.
Is that how it looks to you? Yes or no?
No, ma'am.
Okay. Is there a way for evidence.com for the state to give the defense what you are looking at? Because y'all solution is not a solution if then you create some index when you're viewing it from the way that you can see it, and then giving it to them, and then when they look at an index, then it's just a bunch of numbers, and then they're back in the same situation. Do you see what I'm saying? Like, if you're not, it's not comparing apples to apples.
And Your Honor, if I may add, I think that was the purpose of the hard drive and the cross-reference index, is understanding, and again, I'm probably not the best person to be talking about digital evidence. I'm a dinosaur, I'm a paper guy. But when we are talking about this digital evidence, it is being transferred not at the fault of the state, but as a fault of the delivery mechanism in a different view.
Understood.
And so that was our goal in having it in the hard drive, so that everybody, when they opened, hypothetically, index number 1, where it's all labeled index number 1 is what we're looking at, so there's not a difference based upon what my evidence.com screen shows and what their evidence.com screen shows. When we open up one, we're all looking at the same document, and we're going to say, when we're looking at that, this is where it was previously tendered under this supplemental discovery response, and this is the data size, how much data, what the size of the file was when it was tendered, and that's the size of the file that it is.
What I'm saying is, I don't think that you're hearing them. So y'all could do that on your end. It does not correspond to what they have been able to see. So you all could go down a line and say, this is on, and you all could say, this is subfolder this, it is referenced in state's exhibit, filed on such and such date / such and such date. What they are saying, and what y'all are failing to realize, is that they have multiple versions of these things. And so they have been saving them as file XYZ. And so if y'all do that with a new index, with a new hard drive, then that is what they are saying that they have to start all over with, because the mechanism that you all have been using has somehow undone, or whatever y'all are looking at just comes in a bunch of numbers / whatever. And so there's no way for y'all, this index, to truly cross-reference for them to make it easier for them.
I'm going to have to speak to Jack's speech about
Yeah.
that. Presumably I could get.
Tell me about it, Terry.
And with a next point, originally, the idea was it was labeled individually, and they couldn't bulk download. They had to download things through subfolders. This gave them the bulk download option, because I was told they need a bulk download option.
But then it comes in numbers.
I understand, Judge. My point being, I'm not being difficult. I'm trying to adjust to what they're asking for as best I can. I'm trying to provide it in multiple formats as best I can.
Y'all, look, we're gonna I want y'all to just strike all this, like, I'm not doing this intentionally, that is not the purpose of this hearing,
Yes, ma'am.
okay?
A solution that I might propose, but I have to put a pin in this, because this involves giving them access and accounts to evidence.com, which Jacksonville Beach Police uses as their case management system. It would be like us giving them a login to Stack. There's like security clearances, there's issues with that. But if there is a way for me to dupe my evidence.com folder into one and remove access to Jacksonville Beach Police case management system for their entire police department.
Who manages this system? Is Jack's Beach, or like whatever this web service is?
Evidence.com is how we receive evidence from some law enforcement agencies. They use it as their case management system. I have an account to access this particular case file in their case management system and to share files with defense counsel. I don't have authority to share access to evidence.com with them, because it's the Jacksonville Beach Police internal system.
I'm not suggesting that.
My suggestion is perhaps there's some way I can do this by creating
Not a good idea.
a mirror of their files on my account and sharing it with them with limited access, so they can't get into Jacksonville Beach Police case management system. Not that I think they would, but obviously they're.
And Judge, if I may just add this one point, and again, using the paper analogy, this is not foreign. If this was a paper case, hypothetically, and we tendered 1,000 documents, and in discovery, which has been done beforehand. How I label my trial file is not going to mirror how Mr. Carodi labels his trial file. I'm going to label my evidence folders or my witness folders or my evidence in the way I organize, because that's what I do. Even prosecutors across the board don't use the same organizational system. We are providing the discovery. What's difficult is I don't know how we get everybody to organize their trial files in the same way, and I think that's what everybody's trying to do here.
No, that's not it. So from one dinosaur to another, okay? When you have a paper discovery, if you gave it over, you would say property card, sequence number X with 5 pages. So then when you gave that exhibit over, there is no chance of change. So therefore, you, through the state, to me, this paper is the only thing that really matters. Y'all's emails back and forth, you're this and that, and you say, well, Miss Day, that doesn't mean anything. This is the only thing that means anything. And so then, like, for example, if I go, I'm still on this first one, right? Like if I go to the physical evidence, this should never change value. So paper is different. So if you documented, I gave over this document with this many pages and identify it, then it doesn't matter. I don't think that they're asking for a same trial file, what they are asking for, and that what this court should ensure, because these cases must stand the test of time. It has to be able to be, and I will tell you, like, it is a concern. Like, the different platforms have to be consistent for now and future review. Okay.
But sides shouldn't change,
So,
right?
This is kind of where I'm at. I don't necessarily think, from what I'm hearing from both sides, that you have to start totally from scratch from either side. What I think needs to happen, and where the state, because we're too far in, right? I think what needs to happen is the defense needs to identify the problematic electronic evidence, and that's where I see the majority of the problems coming. The electronic evidence of the multiple versions, okay? And I don't know, the hard drives that you all have gotten where you have the problematic electronic evidence, where it's the multiple downloads. What I would ask is that the defense identify those problem downloads, okay? The problem electronic evidence. That is where we're going to focus, okay, in indexing, okay? We're not starting from scratch because we're too far along. Then when you all see the problems, and maybe, does it have any potential of having like attorney-client privilege, or are you just giving back what they've given you? Or is there a way for you to duplicate how you were seeing it? Do you understand what I'm saying or asking? So let's say, I don't know what this is, because it's just a bunch of Defense Exhibit C, whatever this is, okay? Could the defense somehow duplicate that for the state, give it back? Does that make sense? Like, so y'all have identified, I don't know what this is, these files, okay? Duplicate it. Say, this is what we want indexed. Is this, what is that? Who is that? This is what we want indexed, okay? And then the state you go through and index that and give them back what you are going to use in an index form, what you all are proposing. Does that make sense?
It does, Your Honor.
So y'all are not just going through and saying, we're going to redo everything. It is what they are having problems with. So if they have basically, and if y'all have different values of electronic evidence that you all, maybe it's not on this evidence.com, but you all give them back a hard drive with whatever this is. If y'all have to buy 900 hard drives for each individual thing with an index on it that everyone is working off of, and this is what you're going to use, then minus whatever evidentiary redactions may be needed in the future, but you're giving them exactly what you're going to use, not a download, not a user error, but something that they can plug into a computer and say, this, we can count on that as being what the state is intending to use.
Yes, ma'am. That was the thought process behind this. I told them whatever we indexed or tagged, that would remain the identification number for our exhibit list. That would be what we're using at trial. We're not going to use a different version. That process has begun.
Do you know what their problems are?
Somewhat. I think I have Detective Padilla, who is cross-sworn with Jacksonville Sheriff's Office and the Secret Service. I've given him a chart where I have put in one chart all of the devices where the extractions are housed. He's going to the original data. He's going to pull an original copy of raw data and UFDR for all the devices minus their clients. He's going to make a chart with the hash value, file size, and confirm the data is complete and perfected, and provide that list to me and to defense. I will provide it to defense.
No. They need to identify, you can do that on your own, but like they need to identify where their problems are. And so instead of you doing all of that, you wait for them to say, these are what we have been working on / concerned about, and then you all give back exactly what you're going to use related to those particular devices.
Yes, ma'am. And Ms. Day's provided me a list. I'm working on that. But I only say that for the court to understand that Detective Padilla will be able to give us the confirmed hash value of all these devices. So they can let me know what hash values they have. They can tell me they're missing a download, but if I have to compare it to this list to see if there actually is a problem or if that's the actual file size. That's in process on the state side. Whatever they give me, I'm happy to cross-reference and re-provide. Ms. Day has already given me a list that we've been working on. I did a partial response on state's supplemental discovery 1 to one of her lists, and I told her to, if she numerically listed it, that I would respond numerically as well, and we can file those with the court as a request for discovery and discovery response.
Okay, so that I am, because I mean, I'm not privy, nor do I want to be privy to any of y'all's emails. If the defense would identify through either motion to compel or motion, some type of discovery motion, what you are duplicating / giving to the state as far as problematic. And when I say identify, I mean, let's say, I'm just going to hypothetically, it is, I don't know, Henry Tennant's cell phone, like you said earlier. Henry Tennant's cell phone, version 1, 2, 3, however many you've gotten, right? And then you say motion, and then date tendered, then motion to compel Henry Tennant's actual download for what you, that is state, what you intend to use. It sounds to me that this evidence.com is not a usable / workable format, so I'm not sure. I understand it might be their operating system for like a law enforcement aspect, but for court purposes, it is creating too many problems.
And the benefit to it, Your Honor, just so you understand why we did it, is for the very reason that rather than me plugging their hard drive or flash drive into my computer and transferring something and giving it to them, because I am operating off of, that's the evidence that Jacksonville Beach Police has in their possession, that I have in my possession, they have access to download it. We ensure that we all are looking at the same evidence.
But you're not. You're not. And that's what's creating the problem. And it might be usable for you and law enforcement. It is not usable for the defense. They have been saying now, I think for about 13 months, that they are getting this, and that is not usable. And also for court purposes, for record purposes, it is not corresponding to what I couldn't make heads or tails of this, to be honest with you. Like, this list is wonderful that is on the back of this exhibit, listing all the evidence, right? But it doesn't correspond to anything. So, and I understand that you all want to index, which I think is great, okay? If you all were working along the same lines and you could say on state's exhibit, whatever, this and this, but they are looking at numbers. And unless you know what numbers they have, there is no way for you to properly index it for review where everyone is working off of the same thing. That is what I'm trying to explain. So what I want, and by the next court date, I want the defense to identify the problematic, okay, electronic files. And how many versions you all have. To the extent, and you let me know if this is a problem, but, you know, because I'm working in an unfamiliar area, right? So if there is a problem with you all duplicating what they gave you, not anything that y'all, like your work product, right? But what they gave you, if you could duplicate it back to them. And then once the state has the problematic evidence, okay, then I'm going to meet with you all, and you can give it to, I'll give you some time. You give it to the expert, okay? And I need to know from whatever law enforcement or whoever, whatever, is able to review it. And I want to know how it is going to be communicated back to them. The way that it is communicated back to them, that is disclosed back to them with on black and white paper, okay, will be what it is going to be, okay? So that would ensure, hopefully, that what the state is saying is going to be what will be in this case, period, end of story. Not some cloud manipulated user error download. And I want to know, like, how big it is or whatever, and if you need to bring these people in, explain to me how it can be disclosed to them in a way that we can all be confident from this day to the last day that it will remain the same. That's what we're going to do, okay?
I understand, Your Honor. And looking at this is the first time Exhibit C, I'm seeing what they're seeing, so.
I know, but they have been saying the same thing.
Well, and Judge, I think one way we can do this, and we'll work towards this effort once we receive the problematic list, that's adding another column to our spreadsheet of our index. So we're going to have all that, and then we're going to have their identifying factor corresponding with what our corresponding factor is.
Okay.
That's
so,
really.
I mean, when y'all are looking at these numbers, do y'all have it cross-reference, or are you just doing what Mr. Carodi said and just changing it to whatever y'all remember it to be?
Change it, but also, as we said many times this morning, because
I can't hear you, Miss Day.
Because we have received so many duplicates, and not just true duplicates, but partial and reorganized and relabeled. It's not just necessarily, we download this from evidence.com, I identify this as report supplement 152 and label it as such. I then have to go back through what we have already saved, download, and reorganized to see if it's something that I already received.
Let me ask this, okay, for the defense. Let's say y'all identify the problematic electronic files, okay? And then I would, when I say duplicate, meaning that y'all duplicate it for the state, y'all have already gone through these things, correct? Okay.
Well, we've gone through in the sense that we have downloaded and logged that we received it and potentially whether or not there was an issue in opening it. By no means is the defense saying that we've fully reviewed every Google return or cell phone download. That is certainly not true.
Okay, I'm asking, okay, for record purposes. So if you all you all duplicate the problematic electronic evidence, right? Then you send it to the state. You file with the court under seal, okay, for later review if needed, okay? And that seal will mean that those versions, 1, 2, 3, 4, 5, however many they are, I would enter an order excluding them. Excluded. So then with the state, you all have the problematic files. You simplify it into the file that will be used, okay? So whatever gets communicated back, they can count on that is what you are gonna use, okay? Not version 1, 2, 3, 4, 5, but this version that you will amend your disclosure back to them, okay? That will be what it will be, okay? Forevermore. The ones that you all duplicate and file with the court under seal will be excluded from evidence, so that everyone will be working off just whatever you provide this final time. Does that make sense? So then it's not any cross-reference. What my thought process is, okay, is if they give you back what you gave them in these number forms, you can give it to whoever is reviewing this, and he can confirm, maybe it is user error, maybe it is some type of interruption, but he can say that, okay, I'm compared these, not them, not their time/expense. Your expert, he compares all this, and he says, this is the actual version, and give it back to them. Does that make sense?
It does, Your Honor. And
Okay, so
we are sort of undertaking that already.
You're not, I know, but like y'all have been telling me this month after month, day after day, and what is occurring is the state is doing this, but it's not being communicated in a way that anyone can be confident that it is the evidence that will be potentially presented. So their investigative purposes. So from that sense, the problematic electronic evidence will be excluded. Whatever y'all identify, it will be communicated back to the state of Florida, okay? And then what you amend/disclose to them at this point in time is it, okay? That's it. And then so like I said earlier with that next point, evidence.com is not workable, okay? So you all have to find some way. Evidence should not be able to be manipulated. It should not be able to be from all standpoints. And so you can say user error all you want, but we need to get a way that there is no user error, okay? So by the next court date, it's just going to be, as Mr. Khalil put it, dinosaur. It is what it is, okay? It's a bone buried in the desert, okay? It is what it is from this point to the last point. And so evidence.com is not workable, okay? Unless you can somehow bring someone in here that is going to tell me that they would be able to download whatever without any user error, okay? So otherwise, if someone is going to tell you that there could be user error, then you need to find another format, either 100 computers or whatever you got going on, okay? So, anything else about this electronic evidence? So you all are going to identify, that's y'all's to-do list.
Judge, I think that was the purpose of our expert coming down and looking, we think it's all problematic. And that's why we had wanted our expert to come down, look at the original raw data on the police officers' drives, look at the original devices, and say, this is a good copy. And so that was the impetus behind our expert coming down.
Mr. Crody, you're backpedaling. So let's just put all that in the rearview mirror, okay? Y'all are gonna say that this version, that version, this version, you're gonna say, we have looked at this, it's problematic, it's got, this megabyte, this terabyte, this, and just dump it, okay? Then you're gonna file it, okay? So that, if needed, y'all will have it. It will be a copy back to the state. It will be a copy to the court, kept under seal, okay? Your expert will have it, okay? That will be excluded. You understand? It will not be evidence, period. You're gonna communicate back. They are gonna then give you what their final version is, in something that, if it's 5 terabytes over here, it will be 5 terabytes over there. So you don't have to worry about it, but you'll have those other copies. So if it becomes necessary, y'all can compare it. You can raise issues. You see what I'm saying?
And their expert, yes, when we complete this, I've already reached out to council for future dates. We are happy to do an evidence view with their expert once we get this filed and tell them what size the files are. They can examine the original data.
Okay. Do you see what I'm saying?
Yes, sir.
So let's put that in the rearview mirror. And I'll address that if you want to bring it to my attention about this canceling or whatever. But let's just I'm not having any sanctions motion. I'm trying to get to a point where we can move forward. All right? Are you with me or no?
I'm with you, Judge. I don't think you understand the Herculean task that we have been faced with in this case.
I'm trying to.
Discovery.
I agree.
And now, as I think about this,
Oh, good Lord.
I understand what the court's trying to do, and I think that if we're just focusing on the devices, there aren't that many devices.
I'm not focusing on devices. I'm focusing on what you all consider problems. Y'all have been telling me that y'all been wasting time downloading this, downloading that, takes too long, whatever. Y'all tell me what your problems are. And that's why I cut Mr. Khalil off, because I don't want y'all starting from scratch. We're too far in. What I do want to do is address the problems. If you have multiple versions, they won't be allowed into evidence, but you'll have them. So if y'all want to investigate to see if this final version, that what they are going to be able to potentially use, you'll have it, but it will be for exclusion purposes, a part of the record, okay? There are 9 versions of Henry Tennant's phone will be filed with this court, will be communicated back to them and say, because they are not seeing what you're seeing, okay? And y'all are seeing 2 different things. They think they're solving a problem, but they're creating more problems for you. That is why we have gotten ourselves in this little pickle, okay? Because they keep saying, we're gonna do it. And y'all keep saying, when they do it, it's a problem. And it's a big problem because it's a lot of information, a lot of evidence. And so we're scratching all of that. Y'all will still have it. Your expert will still have it. Whatever they give back, that is what your expert needs to look at. Because all of that other stuff that y'all have been doing is excluded. The only purpose in it is that when they give you whatever this final version is, y'all have the time, if you want to compare it, but it won't be admitted into evidence the way that it was. So y'all will have some confidence, hopefully, in what this electronic evidence truly is. And
part of the problem is that some of it is web-based. And I don't know, but you can print something off of a website. I don't know why they can't just print the web-based stuff. Go to the web page and then just print it. And then they won't have to worry about that. Because if the internet's down, what if the internet goes down? What if the internet goes down that day in court when they need to pull up that piece of evidence? Because it happens all the time. How many times have we been watching court and they've been like, oh crap, the internet's down right now? I mean, then everybody's screwed.
I'm not gonna let these problems like sit around and fester, okay? If I need to talk to whoever, this evidence.com, this next point, whatever, is a problem. It has been a problem from the outset of this case. And so we need to get into a form where it is rock solid that y'all have confidence that whatever.
What have they done in the past? Well, they've always, like, it's not like there was ever a time where we didn't have digital. Like, what have they done in the past? You always see a bazillion banker boxes of stuff lined up, right? I don't understand. Maybe it's just because I'm old, but I don't get it. Why is this such a problem? They're wasting what? How many hours on? This is a total waste of time. A complete, total waste of time. It's such a ridiculous argument. Oh, I mean, oh my God. I can't even believe this is something to, I don't even have words.
Whatever is being communicated is what y'all need to investigate and spend your time on, is where I'm at. Mr. Crody.
Judge, I understand your effort, and we'll comply.
What is the problem with that? Well, you're saying it's a Herculean task, and that y'all have already downloaded whatever. I understand all of that. But, I mean, otherwise, just sitting around saying it's a problem, what would you suggest?
I have been concerned, and I remain concerned, and I do think that an index would be helpful, okay? I think but if they can compare it to what we've already have, that would be very helpful, because I think while there are problems with the devices, our solution that we had was to send our expert in to get the original data. Like, that was our solution, to make sure that we, on behalf of Ms. Gardner, were not missing anything. Okay, that was our solution. We have not been able to, we know we.
He thinks they're being shady because he said duplicitous. When he first stood up and started talking to the judge, he said they were being duplicitous. I don't think they're being deceptive. I just think they're being too reliant on technology.
Spoke to the court about that was our plan. We have not been able to accomplish that with regard to the devices.
Okay, well, let me ask you this, okay? If you don't want to do what I am suggesting, and you want the expert just to come in and look at what they have, and you, Ms. Gardner, leave it the way it is, what Ms. Gardner's issues, I thought y'all had common issues, that is, common multiple versions of everything. If you want your expert to go through all the versions that you have gotten and then go through potentially a final version, I'll leave that the way it is. What I'm seeing from Ms. Day is that you like the solution that I've given, which is I will suppress / exclude the multiple versions. You get one version back from the state, and that is what is going forward with Mr. Fernandez. Mr. Crody does not. Y'all don't have to be on the same page. It doesn't.
And I'm not prepared to tell the court right now which way we want to proceed. I don't have the knowledge of what exactly we're dealing with to tell the court which way I want to proceed.
Who's doing the discovery for Ms. Gardner?
There are several people doing the discovery because it's so voluminous, but I think we need to.
Who's the lead on it?
Probably
Ms. Medina.
And Ms.
He doesn't even know?
But we need to talk to our expert and ask him, I'm just not prepared to tell the court today that's an acceptable solution. I'm just not in a position.
How long is it going to take for you to talk to him?
Probably a few days.
My detective spoke with their expert he did reach out to him when we got his email before he canceled his trip and asked him what format he wanted everything to be sure. My detective has conveyed that information to me. I've conveyed it to our expert, and we are prepared to gather it in the format he wants and have an evidence view end of April, early May.
In what format?
He wants to look at the data on he wants to look at the original extractions on their computer, and he wants a first copy of the original extraction, which we're providing to him. Both the raw data and the parsed data.
Okay. When?
I sent an email to defense counsel. Their expert said he would send us a hard drive because he wanted to look at some things before he made the trip down. And I said I sent an email end of April, but I think probably, to be realistic, sometime in May would be best.
No.
Hi, Judge.
Hello.
This is Michelle Medina on behalf of Ms. Gardner, and I'm sorry for the noise on my way to court. But I've been listening. I've been dealing specifically with the digital evidence.
Great.
And the issues that we're having, Judge, we've provided the state with a list of all of the digital forensic evidence that they claim to have in their possession. And I've specified on that list what we just do not have. So it's not an issue of we received one version and we want another, is we do not have it, period. And so the goal was for our expert to just go and just retrieve everything they say they have and just get it directly, instead of having to wait to get a copy, see if it's a readable version, and then relay it back to them. So I think the best way, just for sake of time, is just to have our expert meet with their expert and retrieve the evidence directly.
Ms. Medina, you said that how did you give them that list?
In Word format. I actually have that list, and I can provide the court with
Why don't you do it in order to compel? So Ms. Gardner's issue is not multiple versions.
Well, we have multiple versions as well. This is just
they didn't.
It's a side issue of there's evidence that we just do not have that's digital. So it's two.
And it's also, is it the ones that you don't have, meaning that they need a taint review?
No, it's not taint related.
Okay. Well, all right.
That's why I think because we're lawyers and I agree with Ms. Stifler, sometimes it can get lost in translation with the technical terms. That's why even my expert had said, let me just deal directly with your expert because they understand each other, and just schedule a time and get it directly, you know?
Okay, I'm fine with that, okay?
Okay.
But I do want it documented some way.
100%, yes.
Like, I want it documented whatever you're missing, okay? So if you'll do that.
Yes, Your Honor.
Maybe as a motion to compel. All right. Mr. Carodi is the naysayer in the room about my solution. What do you think? About the multiple versions is what I'm working on.
Yeah, no, I think that's a good solution with the multiple versions. My concern was more of what we don't have and delaying that process.
No, I'm not. Okay, we're thinking about different problems. Okay, so I'm on multiple version solution, okay? Multiple version solution, which Ms. Day seems to be signing on to, and Ms. Medina, since you are in charge of it, okay, which is that whatever multiple versions you have of whatever evidence that you then, do you have an issue with the copy being filed with the court under seal? So, but y'all will still have all these versions, so whatever the final version is, you can compare if you want, but you know that those versions would not be admissible. Does that make sense?
Okay.
Are you with me or no?
So you're saying that you would receive a copy of our copy?
No. Y'all would make a copy of what you consider to be problematic. So have you seen the filing by Mr. Tassoni?
Yes, yes,
Okay.
I have.
So what I am gathering from my questioning is that, so State's exhibit, I'm sorry, Mr. Defense Exhibit C on Mr. Tassoni's filing, okay, has, I think, hopefully enlightened the state as to what you all are dealing with.
Yes.
Okay? Because whatever they are looking at is not what you are looking at, and then that is what part of the problem is. And they keep trying to solve issues based on what they are looking at, but you are looking at something different. So my thought was, you all make a copy of whatever you all believe to be problematic. And when I'm saying problematic, I'm not saying things that you have not gotten. I'm saying what you have already gotten. Let's say you've gotten multiple versions. Ms. Day has communicated what one of Mr. Fernandez's issues is that, let's say, and I've been using this as an example. I don't know if this to be the case, but Henry Tennant's phone is a 5 terabyte on one version. It's a 3 megabyte
Yes, that is
on.
correct.
I'm
Yes.
sorry?
Yeah, that is true.
Okay, so that's where I'm at. Okay, are you with me?
Yes.
So that is what you would make, whatever copies you all have received, okay, you would make the copy of what you all have seen, meaning the numbers / files that has been filed with this court now that make no sense, okay? That is not what the state sees when they are, I guess, providing it to you, is what I'm gathering. So you all give it back to them. You file it with the court, which you have given to the state saying these are problems. I would exclude it.
Okay.
Okay? So we know that, let's say version 1, 2, 3, 5 terabyte, 3 megabyte, 4 whatever byte, okay, is excluded. Y'all would still have it, but the state then amends and would be able to provide you with one version, okay, that would be indexed, whatever. That is what they're saying in a trial, that this is what it is the day that they provide it to you to the end of days, okay? That's what my proposal is.
No, I think, I guess my only concern is really the logistics of the copies because they're huge files.
I mean, why can't, instead of trying to, like what I'm saying, we break these things down into whatever they may be. For example, like, if it's one device, you get one hard drive, not some huge cloud, whatever.
Oh boy. Okay. That's just I would want to have that conversation with Shannon. Because I think in this format, it can be done with specificity.
Right.
And there's already documents of that specifying, we received this on this date. This was the file name. This is what it shows. I mean, we have that written out. My concern is just providing chunks of the electronic format, just because just downloading it takes hours, sometimes days. So my concern is just now copying it. Could it take just as long? I don't know, is my concern.
I don't understand.
Day and age.
It's like just the digital part, the digital copy.
The reason we did cloud-based nextpointevans.com is because it is a quicker, more likely to download properly and completely than hard drive to hard drive.
All right, this is a capital case, all right?
I understand, Judge.
This is a capital case. This cannot exist in some cloud somewhere. It has to exist of record. These clouds don't exist.
It's just a conduit to deliver the discovery to them. The same way the portal delivers discovery from our office to the
Understood.
office.
Understood. Okay, so let's say down the line, this is a capital case. It has to be filed in a capital way. And so if it's never anything and it's up in some cloud somewhere, that doesn't make any sense to me, okay?
Which is the reasoning behind the state putting all this on a hard drive index and filing it with the court and then providing copies of that court exhibit to both defense teams, so that at least it's of record.
Oh, please don't tell me she's like Kamala and she believes that the cloud is not a real place. Please don't tell me that.
The hard drive that we create and index will be filed as a court exhibit for appellate purposes.
Okay, so if there's ever a question about what they got as a defense team, how do we resolve that issue?
We can take, Your Honor, there's a way to take a screenshot of the, like when you open a hard drive, you'll see all the folders of how we received it from the state. And we could take a screenshot of that folder. It shows, you know, the size of the file. And then we can take a screenshot of that same, let's say, file showing a different size. And that way it's undocumented, it's visual, it could be in a list format.
Okay, that's fine, but Ms. Medina, that's not how it looks to them.
Right, but they can see how it looks to us.
Right, but they don't know what to replace it with.
I mean, I would assume that they have what they gave us.
They don't.
You know?
They don't. That is what the problem is. When they look at it, whatever, so we're still operating on these Exhibit C. 20, 24, all these numbers is in a file folder, okay? When they look at their file folder, it says subpoenas. For you, it says 2024, 1, 2, 3, 4, 5, 6, 7, 8.
Right, but they should know that they gave it to us on this date. Like they should have, I mean, I am assuming that the state would have documentation that on this day we gave the government and they see what they provided to us. And then we can show what we actually received through screenshots. I mean, that's just my initial thought process. But like I said, I really have to talk to Ms. Day to see
Have y'all sat down and said, I click on this?
Frankly, was our plan for the deposition with Mr. Johnson.
Yes, correct.
We had lots of questions on just how to open files, trying to figure out if they were complete or not. I'm totally understand some of this may be user error and not download error, but I have no way of knowing that without comparing it to a correct and accurate file.
Okay. But what I'm hearing from the defense is you don't want to start over. The state wants to start over.
Well, I mean,
I think what we're saying,
quite frankly, oh, sorry, Pat, go ahead.
I think what we're saying, Judge, is going back through the state's discovery exhibits, they have been woefully vague. And I think it would be helpful for everyone if we had a complete index of what the state believes that they have turned over to us. That, for example, going to the paper example, we have files that say Henry Tennant's jail calls. Okay, that's how they disclose them. We get them, and they look like a ton of numbers. Now, I know how many files are there, but if they're saying that they disclosed 27 of them, I would like an index that says they've disclosed 27 of them. And so I can go back through, or even more detail, if they're willing to give us more detail. So I can go back through the files that I've received and say, okay, I have 27 calls. What I don't want is for them to give me a new folder that says Henry Tennant's jail calls. I have to click on and say, okay, they're 27 there. And now I have to open my file and say, okay, there are 27 there. Are they the same? That would be, but I do think there is value in an index, and especially if they can relate it back to when they turned it over to us And then we have all the evidence.coms downloaded by date.
When you downloaded them?
We have them downloaded by date. So if they
And so if this trail that Ms. Stifler is talking about, if she can compare it to the trail that they have?
and provide us an index, and this is probably separate and distinct to the multiple version issue.
Well, we have not even finished that problem, Mr. Carodi.
I know. But I do think there is value in that. Our concern, and I think I speak for Ms. Day also, is you're going to give us a new hard drive, and then you're going to say, well, you guys are bound for that at trial. And if the state uses something on that hard drive at trial, and we're like, oh my God, we never saw that, they can say, oh, we gave it to you in the hard drive. It's on the hard drive. Well, that makes it that we have to start anew, and that's our objection. What we would prefer the state.
No, that is not what I'm saying.
No, I understand that, but what I think we prefer is that the state does give us a detailed index, and it includes when they turned it over, so that we know when we got it, and we can go back and cross-reference that, as opposed to doing a new hard drive. With regard to the digital part of it, I understand the court's concern. I do think there is value in what Ms. Medina was saying, in that if we can determine how large the files are and what we believe they reference, I think that would be, that would, and then I think what happens is the state turns over a new copy of it, for example, Ms. Jensen's cell phone, and gives a copy to the court, and that becomes the copy that they will work off of trial.
This court does not need copies of the discovery. What I was proposing is that I keep copies of things that are excluded, so that y'all would get it back, and you would know that these multiple versions, I don't care if it's a copy, I don't care if it's a screenshot, that there is some reference in this court of what is excluded and what will be worked on. That is my thought.
Judge, I think the inverse is true, because if there was a disputed trial versus what was excluded and what was not, you would be able to figure it out you would inevitably have to go to the copy that they turned over. You wouldn't go to the copy that was excluded, you would go to the copy that was turned over to determine if the information was in fact turned over. And that's why I'm proposing that essentially there be a copy deposited with the court as to what they are going to, with regard to the devices in dispute, as to what that they would use. I don't know that providing the court copies of what the court is excluding.
Well, it has to be of record what you are turning over to the state, and then and I would say that is not admissible, then they turn back over what is admissible. So we are not working off of multiple versions, that y'all would not be referencing some old, I don't care if it's an actual copy or whatever, y'all make a copy or reference somehow, like if it's too arduous to duplicate it electronically for the state. My thought was that if you did at least identify in some way that their expert could verify, and then we say that is not going to be the evidence in the case. Instead, the amended whatever index that y'all come up with will be the evidence. So we can just kind of cut all this off. That I'm trying to get to one version of whatever y'all are concerned about. That's what I'm trying to get to. Whatever I am operating, a little bit in the dark, that I don't know what these things are or how it's best accomplished. But what the problem is that what I'm seeing on the filings is that what y'all are seeing and what they are seeing are two different things. And so if I don't speak, French, you saying something to me means nothing, okay? And that is what has been going on. And so I'm fine. I'm not gonna, I'll wait, okay? I'll let y'all have the conversation. I'm not gonna wait y'all are not gonna get all these long past dates anymore, okay? Because it's too problematic. If I want answers, it's gonna happen quickly, because, we are too far in. So that is what I'm thinking. So on y'all's notes, let's start from the top, okay? Problematic, multiple versions of electronic evidence. All right? From what I have heard during the course of this case management hearing is that we need to get to one version. I will let y'all talk offline about it. I'm giving you my potential solution or thoughts about it. You all have the majority of the working knowledge, okay, to get us, which is any goal in any criminal case, to one thing, whatever that thing may be, one. And so I want you all to share however you believe to be appropriate and accurate so that you all can get on the same page of what is the problem and then a potential solution. My solution is that we scratch just the problems and I don't want to work. What has happened in this case is there's so much and then y'all are dealing with so many problems. To me, it's step by step, one by one. So we are gonna first deal with the multiple version electronic evidence problem. I think it is a great idea for the state to index everything, wonderful. But what I'm only suggesting a solution to at this point in time, whatever y'all wanna communicate as far as like trial exhibits or indexing, do it, okay, do it. However, what I'm going to manage at this point in time are problems. Are we with each other? So you talking about indexing, great. You talking about organization, great. I'm not worried about that. Y'all are professionals, you can handle that. I'm gonna deal with evidence problems, okay? So number one, we'll all write the same list. Evidence, electronic evidence, multiple versions. However y'all see it to be appropriate, the defense needs to communicate the problem electronic evidence to the state of Florida in the form that the defense has, okay? Whatever that may be, like how they gave it to you and how it is problematic. You understand? Like, I'm looking at C. We'll use Exhibit C as an example. If the state looked at Exhibit C, okay, are you able to tell what is in your file? So I'm just using Exhibit C. So if you are able to cross-reference Exhibit C with whatever is in your file and you are able to index it some way, make it make sense along the disclosures that have already taken place, great, that will be the solution. If it is not, then we need to scratch the way it has been provided and then provide the final copy. And then it is what it is. And so I will let y'all offline talk about that, okay? So that is gonna be to do number one, okay? Then number two will be you all, Ms. Medina, on the missing electronic evidence. Is that the same for Mr. Fernandez or no?
It's been a while since me and Michelle have compared notes on what.
Okay, well, y'all can let me know. So let's, number two on the to-do. Missing electronic evidence. You all identify it, and it needs to be of record. So y'all's emails back and forth mean nothing to me, okay? Motion to compel, that will put the state on notice that you all are missing these things to the extent that it has been referenced in some former state disclosure and y'all have looked at it and you cannot find it. Show them where they have disclosed it, and then I will handle that at the next court date. So file that, okay?
Will do, Your Honor. Thank you.
All right. Now, to me, problem number three, I think, I can't remember the date. I believe it was back in 2024 where I want to know, so this electronic evidence has to me, almost like overtaken everything else that y'all have been doing. Y'all have been working, right? And you've been deposing witnesses and all of those things. So at the next case management hearing, okay, what I did my best to count, cross-reference witnesses and physical evidence and things of that nature that have been done and need to be accomplished. Okay, so I want just a nuts and bolts analysis from both the state and the defense. What is left to be done as far as like physical evidence? And when I'm saying physical evidence, I'm saying, like, is there any, I think I've asked this question before, there's nothing forensically that's outstanding in this case, correct?
There were some forensic testing requested by Dreiser Hill firm. I spoke with the ATF agent yesterday. They had anticipated completing that I gave them a deadline of March. So they know it should be completed shortly. So that's it, though.
How was that requested?
I requested they complete the forensic testing by March because
No. So the defense asked that.
There was a particular swab that they wanted DNA testing completed on.
But you didn't file a motion?
I just agreed to it.
Okay.
They can file a motion and you can, for record purposes.
No, I mean, okay.
I'm happy to file, but the state did agree, so.
And we had some other swabs
Try
submitted.
to save you one.
They had asked for all forensic testing when we had the October trial date be completed
Okay.
6 months ahead. So
No motion needed. Okay. However, what I would like is some documentation, because this is the first I'm hearing of any of that, okay? There needs to be some type of documentation, either a consent order of what you all, what was requested and what was, or some type of, there needs to be some type of documentation of the request and then the agreement of the evidence that was tested.
I did list the swabs on a supplemental. I can't remember if I parenthesized it requested by defense or not, but I can file something reflecting that. When I receive the testing and disclose it, I can put that in the supplemental.
Okay, that's fine. So whatever evidence was requested by the defense that was tested by agreement by the state, when you get whatever results, that needs to be documented some way.
Yes, Your Honor. That should be shortly forthcoming. ATF, I requested it be completed by March, and I followed up yesterday.
Okay. Now,
And
the witnesses.
Yes, for your Honor's information, I'm looking at Ms. Gardner's case, docket line 318. In December, I had filed a state's exhibit regarding depositions. And
Right, I tried to go through that.
I listed all the depositions we completed in 2024.
Right, and then I did look at that, and then also with some of them were completed later, and then there have been depositions since that time
Yes, Your Honor.
that have not been documented about who was completed. What I'm really asking is what work is left to be done witness-wise, okay? Next court date.
Yes, Your Honor.
I need an outlook for that. But it looks like, I mean, y'all have been working diligently through the witnesses. And the other problem that I wanted to, I'm going to put it out there, I want an answer. The defense has filed requests for specific discovery that is longstanding in this case, and the state needs to respond by the next court date. Do you know what I'm talking about?
I think there was a request for, we had done one filing. I will go back and make sure to respond to all outstanding requests for specific discovery. I think there was a request for some body camera footage in regards to Henry Tennant's arrest on unrelated charges, which I'm happy to provide, and we'll file a response.
How is that admissible?
I think it's in Mr. Fernandez's case.
The one, all right, then the one I'm referencing is one in Ms. Gardner's case. I'll respond to whatever's outstanding.
It was what I brought up earlier about jail calls that exist. And they also wrote in Mr. Chisoni's filing that they have done a public records request, but to the extent that the state has memorialized those.
Yes, ma'am, and we just have not had an opportunity to respond to Mr. Tassoni's latest filing, and we plan to do so in writing.
But it was referencing what was filed
Yes, ma'am.
way back. So once you all get together, you meet about whatever the multiple evidence, the missing evidence, the consent apparently is not an issue. If the physical evidence has essentially been examined or whatever, I did see that, I guess, some of these experts and things like that have not been scheduled for any deposition yet.
We have not scheduled what I would say would be, you know, the law enforcement that played an integral role in investigating the case.
All right.
That's really who's outstanding.
Okay. And then, but also these forensic experts, both computer.
Correct, because we haven't,
Right. Well, I mean, that makes sense.
Yeah, we've been, and the DNA testing's still ongoing.
There's some.
Is there?
Yes, I'm still.
Oh, the ones that were requested?
Yes.
Okay.
It's the same analyst, and there are some experts in regards to cellular site data and location data, FBI and ATF.
Is there any issue with wires?
As far as?
Like wiretapping wires?
We've been spending, like, with the devices.
We're gonna file a motion to suppress the wires because we think it was a bad wire, if that's what the court means.
Okay. Let me I'm not asking, that should have been a better question. What I'm asking is there any issue with disclosure of wires that you all are able to, I'm on discovery, not motion, so is there?
To our knowledge, what I can tell the court is we have received many recorded wire intercepts that.
I saw on one, it's 230.
Yes, Your Honor, and I also provided, they're transcribed. I provided transcripts to defense counsel as well.
Is that disclosed?
No, I didn't specifically list transcripts.
All right.
I can do that.
Look, whatever you are giving over needs to be of record. And so if this is in this master index, that would be great.
That's
Okay?
fine. I'll let the court and defense counsel know. I am organizing and planning to file a chart with specific statements of both defendants I plan to introduce at trial. I've been trying to be specific in their statements and my disclosures, but there will be a master list with a motion for pretrial ruling on admissibility for some of the statements in regards to their cases. So they'll have, prior to trial, an outline, all the statements of co-conspirators, all the statements of co-defendants, all the statements of specific statements of defendants I intend to try to introduce at trial.
All right.
And that would include the wires, any digital evidence, reports, interviews, that sort of thing.
So this, I do think the index would be very helpful for everyone. But what I'm trying to do is, like, on the back end of whatever index that you all, before you start creating something new, that you know where the problems lie, so that the index that you all create for whatever reason is addressing their problems. And I know that you all have been trying to address problems, but the problem is that y'all are not on the same page as about what is going on. And so when you get the list of problems that the index, it'll be great. You can say that is addressed on index line 1012. Okay, but if y'all want to have some master index, great. Okay, but what is at the forefront are these problems, these problematic things. The majority of it is in electronic information.
I understand, Your Honor. I agree. I think it's prudent that we put it in writing in the record instead of just doing emails. And I will say, I want the court to understand, Ms. Day and Ms. Medina have been working very hard and collaboratively with the state. It may not seem that way from this hearing, but I do think that all three of us have been really trying to solve these problems.
I don't take that at all. I think what I do believe is that y'all are somewhat on the same page, but not totally on the same page. And that is, in this court's perspective, very bad, okay? Very bad, because evidence has to be what it is. And so, like, if people have multiple versions of something, there is no reliability in what is being put forward. There is no reliability in what they were spending their time on. And so what my thought is, and what is so important, especially in a capital case, that it is what it is. And so, like, that's where we've got to get. We are not there yet. I don't think we're necessarily far off. And that's why I want the defense to put not in, but like orders to compel, like, so that it is specifically identified what these problems are. And then I'll get to whatever else y'all want to litigate, but like, so that I have like kind of a clear understanding, honed down into what actual electronic files / electronic evidence is, where are the multiple versions, what, that listing, so that I can order responses to it in a timely fashion that does not frustrate the path of this case. So that's why, like, starting all over, I don't necessarily, some of this you are going to have to, but hopefully it will be just on a few things, maybe, not totally. Okay? All right. So how long is it going to take for y'all to do that? And then I want whatever, so that I want the state to confirm that it is 230. That's what I saw in the disclosure, is what it is, okay, with your index. If y'all don't believe that to be an issue, fine. So disclosure-wise. Then the state has disclosed certain subpoenas. I'm assuming that this index would say, like, I know that you have written a supplement disclosure about subpoenas and response / evidence to it. This index will address those issues in a more succinct way.
Yes, Your Honor. And also, Ms. Day's numbered list, I can either incorporate that into an index, or if she's going to file that as a motion to compel, I'll respond specifically. There are times where we sent subpoenas and got no returns, and I tried to file it to reflect that. I know it's hard to disclose that.
Right.
In a way that makes sense.
Right. So I don't necessarily, if you have tried to do it, if it is in the index, that it needs to read almost like a sentence. For example, like I'm looking at, let's say, community first subpoena, date subpoena, whatever it is, no response. And then that should hopefully,
Yes, ma'am.
in a line of things, say that this was the date of issue, this is the return date, result on the subpoenas, because there's so many subpoenas. I counted, just on this first disclosure, I think I counted like 40,
Yes, ma'am.
44 subpoenas, okay? And so if the state could line those up in whatever index y'all create for this master, that would be, in my mind, helpful. So we'll just stop it there. So to me, I have two top priorities, which is what will be the focus of the next, which are these multiple versions, so that if you need court intervention about how we would deal with it, if you all show them how it is, like if it's screenshot, great. If it's, you have to actually give it to them, fine. But I'll look to you all to see how you all are able to potentially resolve this. If y'all are able to resolve it on your own, okay. If you need me to exclude/suppress the one and then y'all just start all over, that's what I need to know at the next court date, okay?
Your Honor, I do have one question. I understand the court's priority is the devices. That is a huge, substantial amount of the evidence. My notes do reflect there are about 198 subpoenas, and I do believe...
Well, I was only looking at that one exhibit. So.
I have them all listed. I do believe we are missing about half. So...
Okay.
We see it as like an equal concern to the devices.
Subpoenas?
Yes.
Okay, got it.
So I didn't know...
All right, so do that in a motion to compel. You list what... have you all referenced, like, let's say subpoena A has a result and you have that? So the devices or the subpoenas where you don't have corresponding response, list that in a motion to compel and put the state on notice.
Okay.
Okay?
Yes, Your
Not
Honor.
an email.
Yes, Your Honor.
Okay. So then everyone is operating on the same page and the state can go through whatever, and then we'll deal with how they have responded or how they intend to respond. If they have no response or what. How long do y'all need to do that? And don't say 30 days.
I know, I'm in a all-week trial next week.
Can someone else help?
Yes, we have a paralegal.
Get the list of, Your Honor,
Right.
of what they believe.
Microphone. Microphone.
Oh, I apologize. As soon as we get the list of what they believe they need in the motion to compel, we will.
How long do you think? From the defense, how long will it take for you to compile it?
I guess...
And do it do one, okay? So from this hearing, this is what is missing, right? And do it just in sections, so then it can be communicated in the state and we can then deal with those.
Your Honor, my hope is that we have scheduled a discovery conference on April 17th amongst the parties. We hopefully will be able to have the answers by that time, if not sooner.
I don't think we're gonna have sound issues or judge issues in this one, though. It might take us a while to get there, but I think once we get there, we're not gonna have any problems. She knows how to control her courtroom, that's for sure.
All right, you're just shy of 30 days then when I could probably do this again. All right, the other thing, so if you all are gonna have those conversations, okay? If it becomes necessary from y'all's perspective to just have the experts talk to one another, or schedule on-site collection or what, I don't know what y'all want to call that. I don't know. If you all will select a date and time, I'll put it in order. So then there's some teeth behind it, okay?
Yes, sir.
Perfect, thank you, Your Honor.
I mean, I'm operating a little bit in the dark because I don't know what these things are. I don't know kind of what it takes, but if you all give, I appreciate y'all's patience with me because I'm trying to understand it, but as to the extent that this court can help kind of unravel some of these issues, I'm happy to do that. And y'all, what I do intend to do from this hearing is designate this as a priority case. And as a priority case, it would take precedent over anything I have on my calendar. So if you all need me, I will make myself available at a drop of a dime, okay? So there it is, courts, actually the chief judge has made this a priority case. I will incorporate that / memorialize it in order so that you all know that if you need me, I will be here. You will have the court time. I don't want these problems or miscommunication or whatever might be occurring to fester for days and days and days. If y'all get to a meeting and you can't get it resolved, you can have time with me the next day, okay? I do not want these things to kind of go like this. We need to, and to me, it takes maybe sitting down, hashing it out, and then I will intervene if I need to. I'm not going to intervene if I don't need to. So I will do that so that you all know whenever you need this court, I will be here. Okay? All right. Thank you all for your time. Do you all have time? I have something, but I will reschedule it as I've indicated, maybe April 25th after y'all's meeting.
I'm out of the country that week, Your Honor.
Okay. The date and time, how written in stone is that April 17th date of a discovery meeting? I say I come before that. I can come in before that
Yes, ma'am.
to get answers. So I'm available next week. I'm available the week of April 7th, and y'all tell me a time. Isn't the bias firm unavailable?
Through April,
I believe it was April 1st, Judge. I know I'm unavailable the 9th, 10th, and 11th doing the death penalty CLE, so I need to get those hours for my certification.
All right.
Your Honor, I'm in an all-week trial next week, but maybe April 8th, that Tuesday.
Okay.
Sorry, the dates again were April 8th, 9th, and 11th?
Mr. Corradi said he's unavailable the 9th, 10th, and 11th. He's in a death penalty CLE. So right now, y'all can have plenty of time with me next week.
I think Ms. Stifler said she was
Oh, she's in a trial.
I'm in a trial in front of Judge.
There's nobody else that could just get answers?
I can get answers and relay them to co-counsel. If that's when Your Honor wants to set it, somebody can be available.
The 8th is, I think the 8th would work.
If we do the 8th, I'd have to do early morning because I have 4 trials set. One is a speedy issue. So I could do special set at 8 a.m.
I can do that.
State's available.
Yes?
Yes, Your Honor.
All right, y'all got it. April 8th, 8 a.m. special set. Case management hearing.
That's to see where we are in the devices.
Yes, and then from that point, once y'all hopefully have figured that out, if y'all want to proceed with the sanctions and things of that nature, I would schedule at that point. That will give the state time to review Mr. Tissoni's latest filing And y'all can tell me, and like, if you want partial review, or you let me know at that point in time, and I'll schedule the hearing. Okay?
Yes, Your Honor.
And one last update, we did receive an email late yesterday from Mr. Gano. He iCloud, and he is prepared to send that to defense counsel for review.
I thought it was the phone.
When he says Apple phone, he means Apple iCloud, I believe.
Okay. I guess we'll see when we see it.
See, y'all are talking two different languages. All right. See you. All right. We'll see y'all next time. April 8th, 8 a.m.
My things are so teeny tiny. Oh, there we go. I don't know how to fix it. I got them memorized, but they're still teeny tiny, so it's hard to see. I don't know why everything got kerflumped on my computer. It's so weird. I'm surprised you guys are still hanging out with me. Worst stream ever! And we still don't have a verdict. I don't think we're going to get a verdict today. I really don't. I keep trying to read Law and Crime Chat, but it's going so fast. And my font is so teeny tiny, I can barely read it anyways. If it was bigger, I could probably catch part of it as it flies by. There is supposed to be another. I don't know why it says 3 o'clock, unless they changed it or they're just broadcasting it at 3. Who is Leslie Singleton? There's a motion for a new trial in Judge McBurney's court. I do not know who Leslie Singleton is. Oh, where is it? I saw it earlier that there's supposed to be something on Shanna Gardner at 3 today. Well, they found Monica guilty. I don't even know what she did. Well, why don't I see it? How come I see stuff and then when I go to look for it, I can't ever find it? That irritates me. I'm afraid to touch anything now. Since I don't want to screw up my computer any more than it already is. I could have sworn there was one today. Okay, well, no, it was 3 days ago. I'm seeing things apparently. Okay, well, here, I found it. We can see if they figured out what they're going to do about the digital evidence. That was interesting. I've never seen one of those before. What are they calling it? Case management or whatever? I mean, it's kind of idiotic because all they need to do is do everything hard copy.
Nobody's told me anything yet. They're still hoping.
Process of, other than the defendant.
The defense has filed several motions. I have an order designating these cases. I have copies for the attorneys. Can you staple these? I understand that it was going to start index.
Yes, Your Honor.
All right. Do you want to tell me what the status of that is?
Your Honor, I was in a week-long trial last week. I did meet with my paralegal yesterday. Our paralegal has been designated to work solely not exclusively, mainly on this case. He's begun indexing
Oh, you
discovery.
guys.
He's indexed about 4,500 pages of discovery thus far. He also
Hang on. Hang on. I can't see my little thing that's going to drive me batty. Brandy Churchwell. She tweeted, Aiden Kearney's motion to be exempted from sequestration order. Brandy said, I remember as soon as Turtle Boy was named as a witness, I said, I guarantee it's because Hank wants to keep him from being in the courtroom. What I didn't know is that he has done that before. When he was a defense attorney for gangster and murderer Whitey Bulger, he tried to exclude 3 journalists by naming them as witnesses. Oh, why can't I see the whole thing? I was going to read the motion, but part of it's cut off. Dang it. Oh, she highlighted part of it, though. In considering the Commonwealth's motive for placing Mr. Kearney on their witness list, thereby subjecting him to the sequestration order, the court should take note that this is not the first time Commonwealth lead counsel Brennan appears to have exploited a witness list by including journalists critical to his position on it for the purpose of suppressing their ability to report on the case, rather than for a good faith reason to examine the journalist's purported witness. In U.S. v. James Bulger, the defense team, which included Mr. Brennan, sought to exclude 3 journalists whose reporting was understandably critical of Whitey Bulger, a notorious and treacherous gangster and murderer, by naming them as potential witnesses against Bulger. I do not like that man at all. I should do a video on Whitey Bulger and dig deeper about Brennan. I should do that. I should do that. I should. Okay. Dang, I need to fix this. My stupid little box is down here.
has been working on the joint motion to compel discovery, which was filed by Defendant Fernandez and adopted by Defendant Gardner, and we are beginning a written response and provision of some of these things that are missing. Some of the items on.
Microphone.
Not items that are missing, but questions the state.
Why isn't she yelling microphone like she did last time?
Detective Padilla with the Secret Service and Jacksonville Sheriff's Office Computer Forensic Investigations Unit has begun the process of, other than the defendant's devices, all other devices in the case, reviewing the original data to ensure the data is complete and hash valuing all of the devices so that we can provide a file size and hash value for each device to defense counsel to ensure that everybody has the same data that they're working from. So I believe Gardner's team filed a motion to compel electronic discovery. So that's underway with Detective Padilla.
Is there any objection to that?
Only to the time frame. They requested that we provide that within 30 days. I've spoken with Detective Padilla just because it takes time to rerun the data. I don't know if that's realistic for us to complete it. So I would be requesting, I have no objection to it, but I'd be requesting a window of 60 days. And if we run into any issues, that we'd be allowed to come back before the court and request an extension on some of the devices.
All right. So how is this index going to work with the
Wait a minute.
request for the specific discovery? It's over 100.
So I've looked through this and my paralegals looked through it and I have
so
notes on
confused.
every
Hang on a
single
minute,
item
guys.
here. Some things I need to follow up and request from Jacksonville Beach Police. There's some.
Oh. Okay. Never mind. TV Trial Live is streaming the same thing. That's where I saw 3 p.m.
Surveillance videos in the property room that were negative evidence that I don't have. I would just, probably what's most prudent is I just file a written response to this in addition to the.
That's why I was confused.
What about the items where it says that it doesn't work? Like whatever you all have provided doesn't open for them, it's in the wrong format.
So there were a couple that I had my paralegal check himself. We were able to open them. I think it's best if I file a written response specifically citing to that number, just outlining for defense counsel how to open the items.
I'll give you an example. Like I believe it's ATF PowerPoint, where it says that you all provided it in a PDF and there is no ability for the defense to open that. I'll give you that as an example. Like, how is a written response going to solve that?
All right, specifically item number 5, ATF cell data location. That's actually FBI cell data location. There's a PDF of the PowerPoint. I will provide them a color copy of the PowerPoint. My response would be, there's no animation. I don't know what they're speaking about. So my written response would be, I will re-provide the PowerPoint in a color copy. I can do it instead of scanning a PDF to them, actually provide it to them. But when I email them the slides, I email them the slides as I receive them. The animation doesn't animate. There's color coding on the map that a color copy might assist them better.
All right, what's the defense position? Have you all met since this time?
As far
You can remain seated.
As far as myself and Ms. Day and Mr. Dreiser? Or you?
Right. I thought also, Mr. Cleel, you might have said that you all were going to talk to the defense about the index. Am I not remembering that correctly?
Your Honor, where we were left was we're waiting for the defense to file a motion to compel. We have a discovery conference scheduled next Thursday, where hopefully a lot of this will be outlined as to what they're going through. I think the intent was to do what was requested of the defense, which is to indicate in this index where the files or the information was previously tendered and in what format, so that they can easily cross-reference from the original responses.
All right, you all said that your discovery meeting is next Thursday?
Yeah, yes, Your Honor, we have a conference scheduled at 4 p.m. on Thursday the 17th.
And some of
Judge, and I think from my perspective at least, having spent about a day and a half since our last court date going back through everything, from Ms. Gardner's standpoint, I need the index. I think a big problem here, going back through it cradle to grave, is that the state initially started listing every subpoena by date, and then they moved to generalities like toll records. Well, it's hard for me to know when I've got 6 different types of toll records for a certain individual, and I'm missing subpoenas for some of them, how that all matches up. And so I really, from Ms. Gardner's perspective, I'm really looking forward to the index so that I can cross-reference it with what I have, as I told the court last time, that I have and Ms. Gardner's team have sort of indexed and created our own sorting system to match it up and see what the state has on its end. And I have reviewed Ms. Day's detailed motion that she filed, and I agree with everything she said in there. That cross-references with our own list of concerns.
And from Mr. Fernandez's perspective, Your Honor, we echo those thoughts, as well as would like to just address, and at the discovery conference, we can kind of get into the nitty-gritty. Today's probably not an effective use of time, but from the one specific example that the court asked this morning, the state responded that they would give us a printout and that would resolve it, but we just pulled it up again, and when you pull up the PowerPoint, there's a play button. We can't play it. So I don't know how giving us a colored copy change. I don't know what would play if it could play, and maybe their response is it doesn't play anything, and then we can look at theirs. But that, just to give you an example, that is what we're seeing, is that there's a play button. It looks like there's an animation of cell data, and we can't see that.
Okay. All right, so based on the motion to compel the responses, I think that, and like I've outlined in this order, which is pursuant to the rules, It's just a part of how this court normally presides over cases. However, I've given kind of like a more leeway, and I have not been as involved in the progress of these discovery issues. And it is what I have detailed, which is none of these issues are new. They have been there since the beginning. I know that the parties, which I've also detailed, that y'all have been working diligently, doing depositions of witnesses and things of that nature. However, there are a couple of things that I can see, at least from what the defense has filed and what the state's position is. The issues are lost in translation somehow. And I don't know, like if they say they can't open it and then the state's response is we'll just reprint it, that has been the issue. And it's also the subject of another defense motion, which is the duplicative nature of such a large amount of evidence.
He did a motion about duplicitous? Oh my
I
God.
want to avoid, okay? So I will, this is what I'm going to do. You all have a meeting already scheduled on April 17th. You all should conduct that meeting, okay? And to the extent that you all can go through essentially each line item, that is the defense saying whether it's Ms. Day indicating that you don't have it, and then the state with your paralegal or whatever you're doing, that then you either have it or you don't have it. You all come back to the court, and I want basically a hold down list of things that you all are not able to resolve from this discovery meeting. Does that make sense? So you all are meeting. You can say, we were able to resolve, and y'all keep working essentially from this document that has been prepared, that's been adopted. Are y'all with me? So if you all are able to resolve and the state has provided, then you all, in a discovery response, outline that. You all let me know what is still outstanding and what is not. That you all, that is a state disclosing, referencing the motion to compel by line item 27, whatever, you all have now resolved those issues, okay? So from the 17th, I'm gonna give you all a week. That is all of the week of April 21st, okay? And then if you all have the time, we are gonna sit down and have a hearing. I would propose May 2nd. And is the defense okay with the state's timeline on providing the electronic evidence? Y'all want it in 30 days, correct?
Judge, we want it as fast as possible. So
Right.
whatever the court, as much time as the court wants to give the state. We'll defer to the court.
Defense doesn't like any of the suggestions
Before
the judge's
I
making.
hear that
He's maybe
motion,
trying to
if the state wants to
fix
be
things
heard
though.
on a different timeline than is requested, then I'll set that issue for a hearing. You can call whoever that can explain what's going on to me, and then I'll make the decision, okay? But that will be before the 17th, so that that person can be working or, so when are y'all available? I would propose on this motion to compel, we would handle on May 2nd. The issue related to the disclosure of the electronic evidence, I could do it this week. whenever, if you want a moment to
Judge,
try to contact your.
I'm unavailable the remainder of the week.
Okay, no one from your firm is?
He keeps saying the state is being duplicitous. And he just doesn't want to be okay with any solution the judge has to fix this. I have a feeling we're going to have an issue with that defense attorney when the trial rolls around. Because he's just not happy with any solution the judge gives. Because he said that when he first stood up in the last hearing to complain, he said state was being duplicitous, and then he put it into motion. The judge is trying to help. And they need to talk into their microphones. I can't hear anything right now.
Would the state like an opportunity to contact the witness, see when he's available? He can, as far as I'm concerned, and what I try to communicate in this order is that I'm going to make this case a priority to resolve these issues as quickly as possible. I don't want weeks to go by because if I let that time frame go by, that could be time that people could be working and they know what deadlines are. Per the discovery rules, I'm going to set deadlines. I'm going to issue orders, and those will be complied with, or you all can ask for extensions. And the attorneys will also make this case a priority. There is a rule that allows and mandates what calendar conflicts look like for the lawyers. The factors listed, which I've put it, all these are just rules. I know y'all have filed all these motions, but these are rules that we should all just observe, right? If there are calendar conflicts, if there are schedule conflicts, they should be resolved in favor of this case being moved forward because there are too many witnesses, there's too much evidence, there's too many issues overall. So if it's a smaller issue, I'd ask for some member of y'all's firm to be available, some member from the state to resolve these issues and so we can move forward. I don't need everybody. Y'all can designate one to handle this court's ruling on how long it's going to take for this person to hash value, whatever you called it, like say how big certain files are. I'm going to listen, I'll make a ruling, okay? So somebody, small issues, I don't need everybody. I would like for the attorneys, especially on the defense side, like Ms. Day, for you to be available. Ms. Medina, if she's, I think she's on, to help Ms. Peoples, if y'all are like dividing work that way, so that we can move these issues forward. The other thing I wanted to ask the lawyers about is that I think probably the like November timeframe, I brought up to the lawyers that I'm assuming, and I know that the defense has started filing some of the capital motions, but I did not see really any indication or designation by the state of witnesses that would be related to the penalty phase.
Your Honor, I'll just speak to the state in regards to the capital. I believe with the aggravators that have been enumerated, it's all contained within the facts of the underlying work.
Understood. But I also, like, if there are any disclosures related to, like, for example, this is all hypothetical. So let's say the state maybe anticipates adding further information, such as like a medical examiner that would testify even, so let's say it was HAC. That is not the case here, right? I would ask that the state be very specific, okay, about witnesses that may carry over, that may offer additional evidence that would be admissible kind of only in the penalty phase. Like, so you can put your straight evidence on in the guilt phase, but let's say, like, if it was HAC, maybe the medical examiner for prejudice reasons would not testify about the pain, the suffering, all of those things in the guilt, but they then are elaborated on in the penalty phase. So if there is a witness that would expand on information related to the penalty phase, then I think you should put the defense on notice. Additionally, if the state has done any mitigating investigation, the rules call for disclosure of that information to the defense. And I don't want it, I want it made big and bold, capital discovery, penalty phase discovery, so that we don't have any issues related to what has been brought up in the past. Like, I think Mr. Dreiser is the one that brought it up. He objected to how, like, a transcript was disclosed by the state. It needs to be, I would like for the state, as best you can, because the discovery rules not only say trial, but this trial has two parts, that you also disclose what you would potentially
So this is definitely
in a penalty phase. Maybe it's nothing, but I asked for that a long time ago. They have started filing their motions for them to then file additional motions that if they want to object, I'd like to handle those early on. Does that make sense?
Yes, sure.
Okay. So, let's talk about the trial date.
How do they decide
Does anybody think it's realistic?
Your Honor, I think we've had discussions off the record about moving the trial date, and I think we at least had preliminary discussions about the selection of a new trial date. I've spoken with the next of kin in this case, and they are understanding and in agreement with the new trial date that we had previously proposed.
What about the defense?
I would, on behalf of Ms. Gardner, concur with the state's assessment.
On behalf of Mr. Fernandez, I concur with most of what the state's assessment is, but would take the position, however unfavorable with your newest order, that until we see this newly organized discovery, it's premature to set the trial date.
All right.
Judge, if I could just go back for a second on the discovery, the joint motion to compel discovery. And I think the state, what I'm trying to understand, is the state to file a written response before the court expects us to meet and confer, or after? I would prefer they file something before, so I know going into the meeting what their position is on each line item, as opposed to going in there and not having an idea of what their position is, or to the extent not having confidence that they have looked at all 207 items. Because otherwise it's going to be a waste of time and take us a long time if we're saying, hey, okay, let's talk about item number 203, and they haven't even considered item 203. So I just want some assurance before, and I think a written response is appropriate, before we dedicate the time and resources to go have this meeting, that the state has looked at each of these, formed a position on each of them, and then we can go in and we can talk about the position and maybe transfer items or have them show us how we can open things or whatever it may be. But my concern is that 1 week from now is a short time, for in my opinion, unless they're going to dedicate the resources to it, to get through 207 items and get a response to us or have an idea of what their position is on all 207 items.
The paralegal that y'all have working on it, how far along?
looked at each item on this list and at least have started, I have notations. I'm not ready to provide my notes to defense counsel today, but some things I'm ready to provide, some things I'm looking to find, and some things are, many of these are questions that don't involve provision of a missing item, but something I need to answer for them. Like how to open a Google, you have to use Notepad, that sort of thing. My concern is I don't want to file a written response until I'm certain the response to each item is what it is, if that makes sense. Because I don't want defense counsel taking what I provide to them, which they tend to do, in an email or a phone conversation and putting it in a motion later. Because I'm trying to provide it, information changes, it's fluid. I don't want to make a written formal response, sign it by the state saying this item doesn't exist because I'm looking at it now and I can't find it, but later I find it and then it shows up in some motion. I'm doing my best to assist them, and when I send emails and provide these items, it's in an effort to assist as quickly as possible. And in terms of filing a formal written response, I prefer it to be more accurate than expedient. But I'm happy to provide them information in an email, understanding that it's not the state's final written response before the discovery conference, and then supplement it with our actual formalized, corrected to the best of my knowledge response after our meeting.
And that's the problem, Judge, is that we never get finality with them. It's a moving target the whole time with this discovery. And so what we're trying to do, and what I thought the court's intent was, is that everyone is going to get locked in. Here are the issues. They're going to provide us a final response, and then we proceed forward. We cannot proceed forward if this is a continuous moving target. And that's what Ms. Stifler just told the court.
That's not what I
It's a
said.
moving target.
I'm happy to respond in writing. I just am not prepared to do it until we discuss some of these things at the discovery meeting.
What was, I understand. So let's say we never had this court date, right? Y'all had already scheduled this discovery meeting. What was the understanding? Because at the last court date, y'all said that you had the discovery meeting, I guess scheduled, and I was coming in before it, and I asked because that the defense formalize not in an email, which y'all did, and you did it within the time frame that this court asked. But this discovery meeting was always going to take place.
So, Judge, the discovery meeting was something that Mr. Khalil proposed in his letter that was going to essentially hit reset on the discovery process.
And I did ask Ms. Day to, and I'm sorry to interrupt, also, I asked Ms. Day these items that we've been going back and forth by email to number them, so that the discovery meeting, we could discuss them in reference to a specific number, and I could provide that information and then give them a written response to some of these items. So I'm not saying I'm not willing to do it. I'm prepared to do it. I just can't do it before this meeting because some things maybe we can work out that would clarify the response that I would put into writing. In terms of, I can't open this item, I don't have the correct application, that might be something, or they're asking for things and they're citing at A3, I need clarification on where they're citing to before I can respond properly. So I'm happy to respond formally in writing, and I'm happy to give them an idea, or speak with them, or give them notes, or an email of my initial review of this, but I'm not prepared to file a formal response prior to following up with them about some clarification issues I have in order to respond.
And Judge, we'll speak to the state. We have no problem meeting with the state. My concern is if the court's expectation is that we're going to sit down with them in a week and go through all 207 items one by one, that without us having a preview of what their position is, that's not, in our opinion, not workable.
How long was this meeting initially set for?
I think it's at 4 o'clock at the end of the day, so I would anticipate, 30 minutes, an hour, is what we envisioned on our end. It was never meant to be a sit down and go through 207 line items. items.
What was it meant to be?
I think just an update as to where we are on Mr. Khalil's endeavor to reset discovery.
Why do y'all need to do that?
Judge, the idea behind it was to have regular discovery meetings monthly so that we could address not necessarily all 200 items at one meeting, but at least make attempts to go through and resolve every issue defense has. And knowing that we all have a specifically allocated time period every month to do so in order to keep track of all the requests in one place at one time with all parties present. This was just the inaugural meeting.
That seems like a waste of time. What is the most important thing that's going to move this forward on this list that y'all want an answer to?
I mean, all of it, Judge? I mean, I don't know, I don't know what the court means by move forward.
Meaning, so I'm assuming, maybe wrongly, that y'all still have depositions moving forward.
We don't have anything scheduled because.
Why not?
Because we have taken, I believe, most, if not all, of the civilian witnesses and several or many law enforcement witnesses, but we are now to the detectives and the agents that really participated in this, and I don't have confidence that I know every subpoena that was sent out in the return, that we have all the reports and their attachments. I just don't have confidence, and what I don't want to do is start a deposition, and that's sort of why we wanted the deposition of Detective Johns, is to go through many of the items that were on the list, and we did set aside a full day for that, to go through the items on the list and ask, for example, we have a return from AT&T for this number, but we have no associated subpoena. Where's the subpoena? We have a subpoena, but we have no associated return. What happened? We're missing the attachment to this police report. We have sub-reports through 164. Are there any more? Things of that nature. And most of that, if not all of it, has been through great effort of Ms. Day memorialized in this document.
All right, so at least at looking at this list, generally speaking, it looks like from the reports, I'm assuming, because looking at this list, there appears to be maybe one Jack's Beach report that appears to have some issue with it, that there's maybe part of it. There are computer forensic reports that I guess aren't working, and some forensic reports from Jack's Beach that are related to the electronic evidence, and the other part are ATF reports. I think just a glance at this, that a lot of maybe some of the issue would be that because the defense is missing, for example, an ATF report, the ATF report would let them know that whatever subpoena went out, did not come back in any type of return. It would be contained potentially in the narrative of those reports. And so the fact that the state has listed it because it somehow appears somewhere, but then the report would then answer the question. I think that you all start with the reports, that they cannot compel, only the state can get unredacted copies of some of this information so that they can read it and maybe cross-reference that this isn't some mystery. I think a lot of it is because they don't have full access to some of these reports. And what is this online thing that they're referencing?
I'm sorry.
So are you talking about number 3?
Right. What is that?
So we found that on a public available website that was released by the state in a public records request. Much of the content we have, it's a different format than it was provided to us by the state. And there's a cover letter from the ATF that neatly organizes these reports. It was released by the state at some point via public records to the media, and now it is posted online. And it's this nice 250-page binder of collated ATF reports that was never provided in that format to the defense.
Oh my God.
I don't know how the formatting issue, but I've looked into it and I can provide, that's ready to go. Provide to that in that format now.
See, it's easy to make hard copies.
Yes.
Okay.
You're right, Terry. Somebody leaked it.
Total supplement report from.
One moment, Your Honor. I'd have to look that up.
And has the state compelled all federal agents that worked on this case to get their work product? And are they willing to release it kind of unredacted for the defense disclosure?
Yes, they have not given me any issues releasing information to me. I do have a Zoom meeting with our analyst with ATF Friday to collect the entirety.
How did an ATF report get on the internet?
Secret Service was only involved in the extraction of the devices. Those reports are in the files provided with the devices themselves. The same way that JSO puts their mobile device extraction reports and receipts in their cellmate folder, so does U.S. Secret Service.
What is a receipt?
That's their version of the chain of custody property card showing they received an item. So, for example, that would be something I would respond in writing, that receipt is referring to this document. They call it a receipt. We colloquially would call it a property card or a chain of custody card or receipt of.
Oh, I thought she was older than that.
Are you all still using?
I thought she was closer to 5. Dang.
Jack's Beach.
I was hoping she was asleep in her car seat. I didn't even know she was awake and saw the whole thing. Until I heard the bond hearing.
I'm going to file a written response and attach
No,
it.
I mean,
Her poor mom. I mean,
how
poor her, but
how are they getting? How are you? Like, example, like
Imagine
so
the
you are
nightmares and
trying
stuff
to
that
give
Fortune is
them
gonna
these
have.
federal reports. How is that being delivered to the defense?
That's something I want to discuss with them at our discovery meeting because I have them prepared. They can advise me how best to receive them. If they want me to open new files on evidence.com with an audit trail, if they want it on a hard drive, a disk, the physical document portion of the response, I'm just going to attach and scan in with the discovery response so that it's attached to the discovery response and clear.
What's the state position on I guess the appointment or deposition of Detective Johns? Are y'all still objecting to that?
To him being under oath and subject to questioning. I had told Mr. Cody and Mr. Hill in a phone conference that I had no problem having them come to Jacksonville Beach, sitting down with a property clerk or myself, my paralegal, and having Detective Johns available to answer questions or provide items as necessary. But again, my concern becomes when we're trying to answer discovery responses, that they're taking sworn testimony from him on, as we're trying to resolve issues that they're going to put later in a motion or a filing.
And Judge, again, that's the finality problem, is we're trying to move forward, lock the state in on what their discovery is for a case that they've been working now for more than 3 years, and they're still not willing to let their lead detective sit down with us, and if we ask them if something exists, let them be bound by that statement. And that's you know, that goes to the discovery here, where you're never going to move forward until we're able to lock the state in. And we have, Your Honor, just to let you know, we have, at least from our position, we know that we have up to SUP 167 of the Jacksonville Beach Police Department reports. That report is dated September 11th of 2024. That is the last Jacks Beach Police report we have.
Hold on, give me the date again.
9/11/2024, SUP 167.
Well, it's looking like she might have to do sanctions if the state isn't going to turn over stuff.
Let me ask the defense, Ms. Day, Ms. Medina, or Mr. Crody, the subpoenas that are referenced in that list, none of those answers are resolved in the reports that have been generated by Jacks Beach? Correct. So Jacks Beach is indicating that they sent a subpoena and there is no resolution by narrative that there were result or no result?
Yes, but I would also say oftentimes the Jacks Beach reports themselves don't even indicate that a subpoena was sent. We're just finding subpoenas.
How?
Many were sent, they were all issued by the state, right? The state issued them. Some were sent by ATF, some were sent by Jacks Beach PD, some were documented in reports, some weren't, some we have returns, we have no subpoenas, some we have subpoenas, we have no returns, and I think that's a fair assessment of what we're looking at. I've been through this in detail recently, trying to figure out again where we are, and the state's first discovery exhibit, if you pull it up, Judge, they did a beautiful job of saying, here's the date that it was, there are some errors in that, but they did a beautiful job, listing the date the subpoena went out and who it went to. The problem is that was really the first year of subpoenas, and they have sent dozens and dozens out that are not listed in any discovery exhibit with that type of detail. And that's why we're looking forward to the index, to try and cross-reference to what we have identified.
What is the state's position on a deadline of this Friday to give the federal reports and determine from Jacks Beach if there are any reports past 167?
Are you referring to specific numbers or just in general any ATF and or Jacks Beach police?
So you said that is ready to go, so I don't necessarily think Friday is unreasonable deadline to basically produce this unredacted report that has been prepared through public records.
I can specifically tell defense in the court, I am fine by Friday to provide items 3, 4. Item 5, I just confirmed with Agent Bobby Blythe with FBI, there are no animations on these slides.
Why does it have a play button then?
I don't see, I'd have to speak with Ms. David. I'm looking
Show
at
it
the
to her.
slides and I don't see a play
Stop.
button anyway.
Just show her
Can you
what
put it
you're
on the
seeing.
screen, Judge, so we can all see it? Okay.
I don't know. Whatever she wants.
Well,
I don't know. Yes, put it on the screen. I'd like to see it. Hook the computer to that thing. Go to the cart.
The record I'm being told, that's the ATF work analyst work product slide. I don't know what that means. I think we should get it if it exists. Because if it's work product that they intend to use, which I would imagine that's a real possibility. And even if they're not, we need
That's
a
fine.
response to that.
Mr.
So
Kaiser, I'll provide it. I just didn't realize that's what they were referring to. That's where, see, this is where some of the confusion is coming in. That was a slide provided to Mr. Dreiser and Mr. Hill at a meeting many months ago.
Has it ever made it to a disclosure?
No, because it was being prepared for trial purposes as a demonstrative exhibit, but I will provide it. That is the analyst that I said I have a Zoom meeting Friday with to get all her work product. I will provide that after I meet with her Friday.
But that's a PowerPoint. What number is that, Ms. Day?
What number in the motion?
Right.
Number 5.
Yes, number 5.
I can't have that by Friday because I have a Zoom meeting with her Friday afternoon, but I can provide that after.
All right.
I can provide item 6. I can answer question 7. I can provide item 8. Items 9 through 14 are going to be on hold because I think they correspond to the electronic evidence. And as I told the court, I'll have the detective come lay a foundation for the state's request for an extension on the provision of those items. Item 15, 16, 17, and 18, I can answer those questions by Friday. Item 19, I can answer that question by Friday. Item 20, I can provide by Friday.
Hold on. 15 through 17.
I'm sorry, 15, 16, 17. Yes, ma'am, I can answer those questions by Friday.
All right.
18, 19, and 20 are questions I can answer by Friday. 15 through 20 is just a clarification as to how things are categorized and labeled.
I can barely hear you, Ms. Stifler. You said what number?
Items 15 through 19. They're just confirmation and or clarification by the state. For example, number 18, photos of clothing refers to the 10 photos. Item 17 had been labeled JO DNA consent form.
Hold on. So does 18, these photographs, how does Jack's Beach categorize those? Do they put it in like a property card or like is there an evidence technician report that would document how many photos were taken?
Jack's Beach Police, unlike JSO, doesn't do separate property cards. The property section in their supplemental reports details what property is attached to that report. So for this example, in Supplement 123, they referenced photos of clothes taken from a garage at Potomac. There are only, defense says we only have 10 photos, none of clothing. There were states or photos. There are additional photos of clothing, although they're not, this is getting into the weeds, but there are additional photos of clothing in a folder that the evidence technician had previously provided under evidence technician photos. They're just labeled photos of clothes in the supplement, but really by clothes, they're referring to the boots, the bags, the swabs in the door. For that specific supplement. Those are the photos attached to that supplement.
Can you pause? Have these witnesses been deposed already? Like the evidence technicians and?
Some of them.
So none of these questions were answered through the deposition?
Your Honor, if I'm not mistaken, there were 3 evidence technicians that we set. I believe 1 was taken, and if I'm not mistaken, the other 2 were having medical issues or were out of country, so needed to be rescheduled.
have not been.
They have not.
Your Honor, with regards to those outstanding evidence technicians, unfortunately, both of the remaining Jack speech evidence technicians were going through some serious health issues, and we just asked them to contact us when they reached a point that they were comfortable giving them the necessary space that they need.
Okay.
And I think it's late in the game, Judge, but with everyone speaking, and maybe I'm just not remembering correctly, but I think when you came in, you just started the hearing. I don't think we did a Jesse Dreiser on behalf of Mr. Hill speaking.
Hey guys, I'm still here. In case you were wondering. That wasn't what I wanted to do. I can't see. Okay. Wait. That didn't. Okay. This is what I'm seeing right now. You see that on this through the right side? That is my chat. This is why I'm not putting any comments on the screen. This is a close-up. I cannot read that. I can't click on it. I mean, I could click on it, but oh, it does show up on the screen, but I can't read it. I can't. Can I scroll it? Oh, I can scroll it. But I can't see what I'm clicking on. Oh, good gravy Maria. I can't get that off there because I can't see. Now how do I get it off? Because I can't because I can't see it. Usually it turns blue when I click on it, but now I can't see where it is that I clicked. Uh-oh. Oh, okay. Okay. I'm not clicking on anything else. So when I had that scrolling problem earlier, I can scroll again. I can scroll again. I look like a little hobbit. Why do you guys can only see my head? There. I can scroll again, but my chat is an itty bitty teeny tiny. I can't see anything, and all of my controls at the bottom of StreamYard are so itty bitty teeny tiny. I have flubbed everything up today. This is like the stream from hell. And I love you all for still being here through this train wreck. You guys are still here.
And for the times in which behalf of Mr. Fernandez's team, we remained silent.
Okay, come on, StreamYard.
If we had any
Well, I'm not sharing it. Oh, now StreamYard says to wait.
The evidence
How come you're
technicians
doing
that
it on this?
I guess y'all are holding on to.
That makes no sense. Okay. I know one. I don't have none. They're too short. My feet barely touch the ground. They weren't ever married? I didn't know that. Oh, okay. 7. Okay, I knew there was a baby. I don't know why I thought she was pregnant. Well, still. Shouldn't you already have that stuff? Why is there still stuff you haven't provided? I still don't get why the ATF is involved. And the Secret Service. They were talking about the Secret Service earlier in the last hearing. Guys, I don't think we're getting a verdict today. I'm waiting for the jury to come in and say, we're going to go home. Oh, that's cool. Is that their daughter's name, Bexley? A weird name. You can't hear it all? It's because my error box that pops up that says, when StreamYard shuts off my audio, my little warning box is like this tiny up in the corner and I didn't see it. Because I can still hear it when I get the warning. Hang on, let me try this again. I'm sorry, y'all.
I don't know. It needs to conform with the rule.
Can you
The
hear
rule,
now?
what the defense is
Error box is
objected
still there.
to, which is
StreamYard, what are you doing?
kind of,
StreamYard, you're killing me today.
call it like disorganized.
Okay, I'm
I
gonna
can't
turn my
remember
camera off
So
again. And if I
the
can
rule
find the
organizes
button.
it. Any response, the defense from the state should not leave them with the responsibility of what category to put it in. So the state, and whatever your response is to their order to compel, which I'm going to grant in part, and I'm going to leave part in abeyance, and I will set the other parts for a hearing to determine a time frame that is reasonable. Also, keeping in mind that this is a priority case. So it is the state's obligation, it's the state's responsibility to categorize it for the defense so that they know what their ability is per the rules, or whether they need to seek court intervention or not. I would ask that the state, whatever you decide to do, that you comply with 3.220. That, I think, will help organize everything. And to the extent that we can, I guess, get a response prior to the meeting by Friday, that would give, I guess, about 3 to 4 working days for the defense to review it. Then hopefully that looks like about a quarter of what has been requested by the defense. I can wait, or I can intervene now, put deadlines on the response on the subpoenas.
Judge, I think you need to do deadlines with this group because
so that you all can,
they're a problem.
I guess the state can respond whether they have it or not. And then we all come back together on May 2nd.
It sounds like the state's afraid of the defense asking for sanctions. Just do your job and don't worry about getting in trouble. Do what you're supposed to do and you don't have to worry about that.
But just looking at this list, it doesn't make a whole lot of sense that, you know, some of these things are more than 2 years old, whether the state has it or not.
In terms of the subpoenas, it's not that we don't have it, it's that what we receive from the institution we subpoena is not always.
Yes,
For example,
Carla.
if I send a subpoena that asks for a specific time, date range, they've received.
Well, earlier I was like, "Oh, we're not going to have a problem with sound in this court," because every time she couldn't hear somebody, she was going microphone, 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 and I was like, "Oh, good, we won't have any sound problems in this court." And she's not doing it for this hearing.
Toll records, as have I, from that institution that aren't necessarily responsive to that range. So they could send records from a different date range or a wider date range or a shorter date range.
Well,
it's just a matter of correlating it for them.
I will, let's put the subpoenas to the side for a moment. Let's talk about the receipt from Ruby Tuesday that was disclosed on November 15th, 2023. Like, whether y'all had that or not, to me, you should be able to respond to that, right? That doesn't take anything other than the state determining with the law enforcement or a copy of it, right?
Yes, ma'am. I said
Okay.
items 34 through 42 I should be able to provide. It's just a matter of.
So let's put the subpoenas to the side for a moment. There are a lot of them. What about the photos, videos, media? Those were disclosed in 2022.
I kind of feel like this isn't the judge's job. Aren't attorneys supposed to know how to turn discovery over to the defense? This seems like a total waste of time. Especially as long. What date did you say?
Yes, ma'am. I'll work on providing. I know certainly.
2022. So 3 years ago. Over
some of these
3 years
items
now.
Are contained within the ET, at least in terms of 157, 158, are contained within the ET photo disc that was previously provided.
The DVD of the flyover, does that exist in their property room? 163.
Yes,
Are these like DVDs that just need to be copied?
most likely. I
Right,
can
Friday.
get that done.
Friday. These USB things, you're saying it's, was it somehow uploaded?
Can you give us, are you talking about?
Like 175?
Yeah, so.
Was that uploaded to something and came down? And
So that's how it's listed by the state, and our question is, we don't have a folder that's titled that, so what is it?
All right. Okay.
I mean, the old days, you'd get a disc, right, that said USB drive containing video, and you'd be like, okay, that matches with the discovery exhibit, but we don't have a folder or a file name with that.
All right. The defense y'all go get a hard drive or whatever y'all have or whatever. I don't know what, maybe y'all can talk offline about an ability to transfer these things, provide it to the state.
Well,
by tomorrow.
apparently,
Let them
Jacksonville
go out
Beach
there,
Police
have somebody in the property room copying some of these things.
Yes, Judge.
have an online system called evidence.com that she can just go to and find all of the evidence, but she can't give the defense access to that. And that's what the problem is. So she's giving
I'm
them
obviously not familiar with the evidence.com. I'm not sure why y'all can't, I guess, get the disc and pay whatever fee they require, or give them hard drives or whatever y'all need to get it duplicated. I don't know what the easiest way to be. I'll let y'all talk offline about that. Like if it's they tell you disc, but these things should just be in the property room, and someone just needs to go over there and copy it. They're like, don't have, and I don't know if it's a function of it went up into that cloud and it came down and a bunch of numbers that they can't verify, but let's just copy what is in their property room by Friday.
That's fine, Your Honor. That's exactly what it is. The way I labeled it in the discovery was how it's labeled in the Jacksonville Beach Police reports. So at the supplement, it would say USB drive containing video. It's attached to a specific supplement report. I can give them that supplement report number. It's been provided through NextPoint and now evidence.com. And presumably it's just, as Mr. Carodi said, a naming function. So I'm happy to
Let's just
go to the property room and copy it.
Just copy it
And then
from whatever they have. If it's a USB, give them a USB and transfer it onto whatever mechanism. I'm not gonna dictate that, but things that have been in the Jacksonville Beach Police Department's property room, give them whatever mechanism, whatever y'all come up with, just copy it and not upload it. So to me, that is a simple solution, and then y'all can detail it the way that you want. These interviews, I will hold that to get some type of bearing on if it does exist in recording fashion. How do they keep those?
the interviews are on discs, but the interviews have been provided. Most of what they're citing here, some of these do not have, they're just asking if there are recorded audio or visual or recorded statements of these people, and some of them there are not. The state did not record anything.
The information from the news, the state is cataloging that?
Yes, ma'am, that came out during deposition of those witnesses, and I did send all of those items via email to defense counsel previously. I will put it on a disc and attach it and reference it to this response. And I'll reference my prior email that sent those items.
And the jail calls.
The defense
The jail
is like,
calls, I'm working in conjunction with Gardner's other motion filed for specific discovery.
Okay, I'll hold on that.
Yes, Your Honor. But the
like,
jail mail.
you get a zip
items
file, it
2,
takes
3,
us 2 hours to
4,
open it, and there's nothing there.
205, I'm sorry, 204, 205, and 206, I can provide. I have those.
203 through 205.
And then prosecution says, oh, that's just user error.
I'm sorry, 204, 205, and 206.
All right.
So they just
They
need to put
received a
everything
certain
on hard
number of jail
copies.
mail, and I will
They wouldn't
respond
have
if
this
we have
problem.
additional jail mail I will provide. confirm the number of letters.
Okay. Can y'all get the disk or hard drives by tomorrow?
And then
provide it
if
to the state?
computers crash, like Terry
I heard
said,
y'all-
Yeah, I mean, it depends what size, but generally, yes.
and then the
Okay.
first
Well,
you said
y'all talk
some
about
things
those
are
numbers.
web-based.
That means
So if
nothing to me.
Yeah, I think we're talking
the
about.
web goes down, if the internet goes down, they're screwed.
You know, the terabytes that exist in this case, so. Yeah, I
Right.
think the answer is yes.
Okay.
You get them a device.
They're making this way harder than it needs to be.
Are y'all available the week of, I said May 2nd, what about April, are y'all available the week of April 21st?
Your Honor, I'm out that week.
Oh, you're out.
Yes, ma'am.
Man, I am so glad I didn't go into law. I know y'all hear me say that all the time, but the more I watch these, the more I am convinced that God put me where He needed me, because I would have made a mess of this.
When are y'all available April 28th?
I am not organized enough. My calendar would have been cray. I would have been in the wrong courtroom doing the wrong trial on the wrong client.
What about
A
the defense?
disaster.
The 30th, the 1st, and the afternoon of the 2nd.
I am unavailable the afternoon of the 30th. However, if that's the only day that works, I'm sure Mr. Hill may attend. I'm available
All right.
all day on the 1st.
What about April 30th?
In the morning or midday or
Morning. Morning?
Available that morning.
Yes, Judge.
Yes, Judge.
All right.
Judy, they didn't have court
know if your
today,
witness
right?
is
So no
available?
jury selection.
I
They're
just
gonna
texted him.
go back to that
Not heard back yet.
on Monday.
That, so it's the 8th now. If I go to the 30th, that's essentially 30 days,
No, it's not.
almost.
And just so
Almost.
we have no intent to cross-examine the Secret Service guy on this issue. If the state wants to provide a declaration to the court, I'm just throwing options out there with regard to the witness as far as how much time he would need.
Well, the defense has asked for 30 days. If you don't object to longer,
No, we do object, but if
Okay.
the court is going to find good cause,
well, I need to talk to him. I don't know. I'd rather do that shorter rather than later, because if I pass it all the way till then, I mean, it's an ATF agent? I thought it was somebody from JSO.
He is cross-sworn with the Secret Service and JSO CFIU.
Okay,
He works for the Jacksonville Sheriff's Office and is cross-sworn with the Secret Service.
okay. Well,
He's generally very responsive. I just need today to get in touch with him, get an idea. He might tell me otherwise. He's begun the project. He might be able to give a shorter deadline. I just haven't had the chance to speak to him since originally 2 weeks ago giving him the device requests.
all right, well, I'm going to set it April 14th for hearing a motion to be set, and then you can get with your witness, and then y'all can let me know that you got the devices, okay? And then I'll set it from there.
So no, we're not setting the 30th.
No,
Judge, did you say so we can tell you whether we got the devices?
no.
Okay.
Well, yes, like, you're going to give it to them, and they're going to give it back to you,
Oh,
copied.
Yes, okay.
Whatever, I don't know what method, I don't know.
No, I was confused because the detective is talking about devices as in.
No.
Yes,
I'm not talking
okay.
about that. I'm talking about in my mind, when you've got a lot of information you just break it down into small, usable pieces. So what we can do, we're gonna do. And then I'm gonna check and make sure it's done. And then we're gonna go on to the next issue. And then I do want an answer. The case is currently set, and I know, Mr. Dreiser, you think that it is premature. But when we all know what dates we're working towards, to me, we can spend, the remainder of this year working through these issues. We have not even gotten to the substance of this case. Y'all have not gotten to, a lot of the substance of the case. Maybe y'all have been working around, and I understand why, as complete as we can get this discovery. And I also I think it's about the time that Mr. Gano needs to file some type of report too.
So I do have an update on the court on that. We did receive a copy of a UFED report for Miss Gardner's iPhone. We have reviewed that. We found it in our review to be appropriately redacted, and we have given Mr. Gano essentially our findings, and he has indicated that he's going to move forward and provide.
I need you to document that. So,
right, Judge.
like without objection.
Right. Okay.
You see what I mean? To comply with the order.
Yes, Judge.
Y'all have the time. Y'all have the time to review it.
Yep.
And then you need to say, whatever report he's provided has been reviewed. No
I
objection
understand,
to disclosure.
and I accept responsibility for that shortcoming on this occasion.
No problem. I just, we've actually made some headway,
Yes, Judge.
which is good. Okay. So,
And Mr. Gano's advised the state he's begun working on Mr. Fernandez's Google returns, so he'll.
great.
contact
We're
Supervisor.
making some headway.
Yes, Your Honor.
That's wonderful. But in order for it to move forward, Gardner has to indicate to the court that it's okay for disclosure. Then I will okay the disclosure because you're the only one that has it. So then it goes back to the state to Fernandez. So we're moving, which is incredible news in light of where we've been in the past. So that's wonderful that at least that is moving. So as soon as you let the disclosure.
I'll file that today.
Okay. Then I will issue an order allowing disclosure per the, I think it's the second amended order that I did, okay? All right, so my thought is that you all start looking at those dates, okay? That I previously communicated, because it takes, it will take a lot of planning and coordination consistent with the order that I put into place and the factors, and that we start working toward a new date, because October is not realistic in this court's view. All right, so I'm going to give you all until we meet again to finalize what y'all think about it, okay? Do you want me to repeat the dates back? That would be proposing. Do y'all have it or no?
I'm just going through my notes.
The trial date, Your Honor, January 20th,
Through?
March 13th.
Correct.
And what are you asking us to confer on as to whether that's realistic or that we're still available?
Look, with you all, I have to book early and often, so I want an idea of what y'all have going on in that time frame. At this point in time, I would think that because there's a trial date,
they're
that
being
y'all
tied
have
together.
blocked off that time. Instead of taking time that I know that we are not going to make, I would unblock that time and move this case to a different date, is my thought. So there was in setting that, I was
He
not
did it
anticipating
for her to save their
that
marriage.
the Gardner team would be unavailable during that time frame. So what I'd like to do is reset and everybody start working towards that date, blocking those dates, giving this case the priority status that this court has now ordered on the new date. Because right now, it's April. The case is set, 6 months from now. What is it, Mr. Dreiser?
I thought I understood the new date, meaning the January to March dates. You're not suggesting that we come up with a new date.
No, that we work towards that date.
As I sit here, having listened to this entire hearing, that seems, even though it's, the next winter, spring, it seems unrealistic to me. So I was wondering if you were asking us to confer on blocking new dates. That does not seem to be at all what you're asking, so I understand what you're saying.
Well, right now, because I have not moved, October is what I was asking y'all to block off, all the way almost to the end of the year. And so which I believe the last estimate by the state, I extended that period of time that I asked y'all to block off by, I believe, 4 weeks, to give the parties plenty of time. I don't know what any of this would look like in a trial sense. I do know just procedurally what, depending on the jury's verdicts, what the defense would be entitled to, the court's position would be as much, and when I tell you as much as I possibly can, I will have both juries working. And I'm putting it out there now that we're talking about discovery, right?
Oh, wait, are they going to have 2 juries? Oh my God. Shave the Menendez.
Both juries working, that would mean that you would have to duplicate some of this evidence in both cases. So if both juries can be working / deliberating, that they are both able to work / deliberate. So as much as I can overlap them with as little downtime as I possibly can for one jury or the other, that's what needs to be done. While one case has been closed down, that jury is working, the other case will be closing down. And as much as they could share physical evidence, but photographs and electronic evidence and all of those things should be duplicated so those juries don't have to be down, that they could all be working kind of simultaneously at the same time. And that's what the parties need to think about for scheduling. And I'm just putting it out that y'all can give me, y'all know what it is, I don't, right? That how you all, if it becomes necessary, how you all would choose to operate, right? Meaning that if there are, defendants are entitled to 2 separate penalty phases, how y'all would work with that, whether you want that or not. So those are questions when I'm scheduling that I need answers to so I can give y'all realistic time frames, and I'm not just blocking off time that may or may not be needed, but I also need the parties to be realistic about the rights, that the presentation of some of this evidence. So those are the things that I want y'all to kind of discuss amongst yourselves about how much time you would be asking to reserve so that I can give y'all the time that you need. And I would always have a buffer period. I'd rather reserve it and not need it than try to have people scrambling around, when you have other things planned. So that's what I want y'all to discuss between now and the next time I see y'all, okay? Okay?
Yes, ma'am.
All right. April 14th, 9 a.m. Hearing a motion to be set.
They haven't asked a question or anything. They're still going at it. Well, I guess they're done. Well. I'm tired. I don't know why I'm so tired. Hi, baby. She comes over here and looks at me and I say hi and she just walks off. I guess she just wanted to say hi. What you doing? What? Now she's like, why are you talking to me? They have all left me alone today, all three of them. I can't believe that they're still deliberating. They haven't come out to ask a question or anything. Nothing. Haven't heard a peep out of them today. That's unusual. Usually we get questions. They don't usually get the answer to the questions they ask, but they usually ask questions. Well, it's almost 5, guys. I don't think we're going to get a verdict today. So I guess I'll go ahead and let you guys go. Spike's dreaming. Spike, it's okay. Mommy's right here. So I guess I will let you guys go. And I think I'm going to take the whole weekend off because Karen Reed's trial might start Tuesday, and that is going to wear me out because I'm going to be hooting and hollering even more than I did in this trial. This trial, I just kept yelling, dude! But I know I'm going to, there are going to be moments in this trial I am going to get mad. I know it. I know it. I can tell it's coming. I can tell. Man, I might. No, I'm not. I was gonna say I might do some research on the Whitey Bulger trial, but nah. I'm tired. I'm old and tired. I don't wanna. I'll probably go take a nap. Especially after the day I've had. After I tried to figure out what's going on with my computer. Let me check one more time. And I wish. Oh, chat is slowing down. Oh, they're talking about Monica too. Somebody says they think they might be close to a verdict because it's almost 5 o'clock on a Friday. That doesn't mean anything. Somebody said, but if gas was pumped into the back of the truck, they would have smelled gas. Someone says it's enough reasonable doubt. We are at a little over 7 hours of deliberations. The jury has not asked any questions. We believe they worked through lunch, and the judge has not said when they will end for the night. Watch. I'll quit streaming, and they'll come back with a verdict. Watch. I've been holding them up all day. That's what it is. Oh, Debbie. I just got diamond dots all over the place. Now, see, I told you, y'all, it's like a Monday in my house today. This is why I don't like to do this at my desk, because there's not enough room, and this is why everything's screwed up today, because there's not enough room to do diamond painting on this desk, and I try to do it anyway, and I always screw stuff up. I should have crocheted today. Okay, y'all, I will see you Monday. I'm going to take the weekend off. I need to rest. I need to reset, because today has been a disaster. And I love you guys for sticking it out with me, because this has been a terrible day. I don't even know why you guys are still here. Bye. Have a good weekend, you guys. Oh, I can't even see the button in the stream.